Please be seated, everybody. That wasn't good. This is case number 2018 CA 5321, Jack Kowalski, etc. et al. Versus Johns Hopkins All Children's Hospital. Starting with the plaintiffs, let's take appearances, please.
Samantha Lawrence, Greg Anderson on behalf of the plaintiffs.
Ethan Shapiro, Pack Proles, Howard Hunter, David Hughes, and Dr. Amin on behalf of the defense. Good morning.
Good morning. Are we ready to talk about exhibits?
Yes, Judge. So I just wanted to clarify. So we filed a rather extensive list. That wasn't intended to, like, we have to deal with all these today. It was rather an attempt to say, instead of doing these daily sheets, why don't we just say everything that we're trying to get in? And so this is not everything, but it's a large part. So does that make sense?
And can I, for the couple of them that have a Y, can I go ahead and admit those?
Yes, Your Honor.
Yes, Your Honor. And just for a couple, just for the record, 3031 and 3035, we stipulated them over our previous objection and the court's previous indication there.
Okay. So the court will receive, Madam Clerk, ready? Okay, the court will receive over the plaintiff's objection 3031, which looks like it's pages 1 to 39, and that's the complete, is that correct?
That's my understanding, Judge.
As well as 3035, pages 1 to 26, which is, my understanding is the complete, is that correct? 3035, it's 26 pages.
Yeah, 1 to 26.
Yes.
Now, also by agreement, by stipulation, the court's going to receive 3029, 3050, pages 1 to 16, 3055, pages 1 to 15, 3124, looks like, is that all of the agreements? So is that all the agreements?
That appears so.
Yeah, Your Honor, I never even saw this last night. I went to bed before 11:15, and obviously we could have not gotten through 8 pages in any event. So,
Okay.
Well, Ms. Crowe, what's next?
Judge, I'm going to address one that needs to be in before we play the video deposition. That would be 31352. They say it's already in evidence, but we checked, and these are photos that were taken by Dr. Major, and they did put in some, but we didn't think this particular photo was in.
Madam
And it's the
Clerk,
one that's used on the video with the doctor.
Madam Clerk, is 3135-0002 in? So it is not in? Any objection to 3135-0002?
no, Your Honor.
Court receives into evidence 3135-0002.
Thank you. And then the next one that we would want in. Oh, I thought I marked it. Give me 1 second, please. Thank you. 3233.
3233.
Mr. Shapiro is going to address this one, Judge, if you're not familiar with the exhibit.
Your Honor, these are the WordPress blogs authored by Beata Kowalski.
We only put certain numbers.
Yeah, we're not admitting all 257 pages. We've selected just the pages of the blogs. Not some of them follow what people can comment online. We're not seeking to admit the comments, just the words of the Mrs. Kowalski.
Was this the exhibit that there was a disagreement on authenticity?
Yes.
Well, I did ask Mr. Kowalski during his direct examination whether his wife authored the WordPress blogs, and he said yes.
Thank you.
No.
Doesn't have to be specific. There's a deposition of Georgia Kimball, who set up this WordPress blog, and her testimony is all over the place. That she authored some of it, she doesn't know which part she authored, she doesn't know parts Beata authored. Jack was never involved. I think his testimony was he knows nothing about the blog, he'd never seen the blog.
The answer is you're going to have to, with evidence, demonstrate the authenticity of whatever you're trying to get in.
Through, can I say the deposition testimony to the court?
Well, it's got to be sworn evidence in
Yeah.
that position.
Yeah, we'll, I guess, we'll have to make the call for when we send it. Yeah, we do have the sworn deposition testimony of Ms. Kimball, and respectfully, it says something different than what the plaintiff says, but we'll have to make the proffer on Monday then. I understand.
It's just, I mean, I remember this one being, I recall Plum saying that they were objecting to the authenticity, so that's been a well-known issue.
All right, we will put together a legal memorandum and give you page line citation. Your Honor.
Right, and you're going to have to, since it looks like you're going for selected pages, I'm going to need to see that those pages were, that you're going to have to prove the authenticity of those. Because if it's somebody other than Maya Kowalski or Beata Kowalski or Jack Kowalski, or conceivably possibly Kyle Kowalski, then you've got a hearsay problem with probably no exception.
I understand, and the inverse, I assume would be true, that if we could show that it was one of the four, it would be received as a statement. I understand, but we'll put together the testimony.
If it's authentic and you can show that it's, you know, a statement against interest by, you know, party, then certainly
Okay.
that might be a different story. What's next?
Okay, moving on, Judge. We'll go to page 1, the 3019-114. J. Hatch, Interdisciplinary Clinic Practice Manual, Medical Legal Policy, Images and Recordings. Their objective is unfair surprise. This was listed on our exhibit list of 9-1. It was also produced to them on 9-3. They never filed
Which year?
objection. And it was
Of what year?
of 2023.
Okay, so after the discovery cutoff date.
It was also produced, they sent us a notice to produce at trial. And that's DIN number, I wrote it down, I lost the DIN number. DIN number 3311. They asked us to produce at trial policies and procedures regarding the preservation and retention of videos, photographs, and electronic communications. So I don't know how they're going to say surprise, Judge. It was produced pursuant to their request. It was also listed on our exhibit list. And when they filed all their objections to our exhibit list, they did not object to that one. They filed their objections on September 8th, after we filed our list on September 1st. So I don't understand how they're surprised.
It was never produced to us. This is the first time that we've seen it. It may have been mentioned on an exhibit list. At DIN 485, going way back to September 30th, 2019, we sent a request specifically for any policies, procedures, etc., concerning the video surveillance of patients. And in their response, again at DIN 485, we were told none. So we've operated for 4 years on the premise that this does not exist. And to say that they produced it at trial when the first time they raise it or even show us a copy is last night, it's not bait stamped. It's an unfair surprise, and we don't even use it in our case.
Judge, this is factually incorrect. It was produced on September 3rd when we produced all of
September
our exhibits.
3rd, 2023.
That's correct, sir.
And the
But it's
document request for this issue, specifically number for,
The response is at 485.
okay, DIN 485, which is November 30th, 2019, so some, what, four years before?
Judge, it wasn't located until they did their notice to produce a trial in August, and
No, too late. I mean,
They
look, if
had
you
it.
had a 2019 request with a response of none, and then on the eve of trial saying, oh, here it is, that's too late. What's next?
Um, 3023, I'm confused by their comment. I don't recall withdrawing the Arnold Palmer admission at 4916. I don't believe that's,
I think what you said was that we discuss it later.
oh, that's right. Thank you. That's right. Because we're going to have the testimony of Dr. Alexander about the issue I think they're raising a problem about. Okay. 3030.
Well, are we dealing with 3023 at this point?
No, sir. I think you said you needed predicate laid for the history, and that would be through the testimony of Dr. Alexander.
Thank you. What's next?
3030.
What is this?
This is Dr. Hannah's ketamine standing orders.
For Maya Kowalski, or just like a form that he uses in his office?
This is the form that he uses in his office regarding ketamine.
It's an undated form. It's not signed by the Kowalskis. No evidence is ever presented to the Kowalskis. There's no evidence if it was created 2016 or 2015 when he was treating this patient or afterwards. So we object to relevance, authenticity, hearsay.
Was this
Wow.
form used with Maya Kowalski?
Not that we're aware.
Yeah, I mean, these are the standing orders that were in effect at the time.
We had one person argue.
These are the standing orders that were, in fact, this was produced to us through Dr. Hannah's office, Judge, when we subpoenaed the records.
Well, I understand it certainly is a hearsay document, but let's talk about if it was used with Maya Kowalski, I can see the relevance, but if it's just here's a form in his office without any connection with the Kowalski family, then why is this coming in?
Well, it's a standing order, and it was used with the Kowalski.
Well, wait, it's a standing order. It's not a standing order in the Kowalski case. It's a form that he uses in his office.
For ketamine patients.
But, and again, I go back to, did he use it in the Kowalski file?
Yes, that's my understanding.
So you will have this form annotated with Dr. Is it Hannah's handwritten notes with respect to Maya Kowalski, right?
Let's revisit it, Judge.
Are we all here?
No, sir. Through this accident on the interstate.
I know
Employee
that.
walked up.
Okay, but is there somebody out there waiting for him?
You're one.
Great, thank you.
Judge, we'll revisit this with Dr. Hannah.
Okay, but well, look, if Dr. Hannah's record has that form filled out in the Maya Kowalski, that's one thing. But if it is just a piece of paper in his office, then no.
I understand, Judge, but if it's a form that was in the file when we said, give us your records regarding Maya Kowalski, even if it's not filled out, if it was part of the record, he produced a response to a subpoena for your records regarding Maya Kowalski.
If it's filled out with Maya Kowalski's information, then I think it's materially different than a blank form that's used in his office.
All right, Judge.
What's next?
3044.
3044.
And 3045 are going to be similar conversations.
3044, pages 1 to 3.
So this is Dr. Sally Smith's preliminary medical evaluation report of 10/13/16.
And where does this reside?
Attached to the shelter petition, Your Honor.
Is this in the Johns Hopkins All Children's Hospital medical records?
No, Your Honor.
No.
Then no, it's not coming in.
Judge, to be clear, we listed it because we wanted to make sure our understanding was that Chapter 39 immunity also applied to this report by Dr. Sally Smith.
If this report went to the dependency court and was not part of the medical records, then, you know, unless there's some explanation, it's Chapter 39
Okay.
immunity.
All right, so then the next one.
Well, if I may, to be clear, I think that's kind of shot across the bow and a suggestion that we're not going to be able to cross-examine her on her report. We understand it's not evidence, but we'll still be able to explore this with her if they call her in their case.
Well, I understood exactly that was the reason, but and yeah, the reality is right now we're talking about whether that document is admissible.
Understood. Yes.
Whether you can use it to refresh a recollection or some other purpose, that's a different conversation.
Yes.
Thank you.
3045.
Yes, go ahead.
I'm sorry, I'm waiting for the objection. 3045.
3045.
Also, here, just rank hearsay, I think it's 45 or 53 pages.
This is her report that was used in the dependency
Yes.
action?
This is the report that is not part of the electronic medical records, but was put in the hospital paper chart, if you will, but not in electronic medical records, so that everybody could access it. This is the one that I believe Dr. Criticized heavily the hospital for having this in the hospital chart.
Yeah, I'm a little, well,
In fact,
does she make diagnoses in this report?
Yes.
Can you pull that area up?
There.
You go to the last couple, well, maybe 45.
Before that, go back up before.
Yeah.
There's, yeah.
Here it is, yeah. Starts here, diagnosis continued. 22, 23.
All right, can Mr. Hunter address this? He's more familiar with the document.
What's on the next page?
Or diagnosis.
No. I'm still back. Mr. Whitney.
Your Honor, first, what they pointed to there is no diagnosis. It's speculation with no foundation, no predicate, based on rank hearsay. If you look at the previous page, she never reached a diagnosis. She made an assertion that there's extensive evidence to support, but she never actually reaches a diagnosis. Then she goes on to complex regional pain syndrome, which she has no expertise in, admittedly. The hospital's noted that. DCF's noted that. And she attempts to refute the diagnosis of CRPS. This was not in the hospital medical record, not produced to us. And although there's this assertion that it was part of the paper chart, there were other paper reports, such as that of Dr. Lewis, that were scanned into the hospital medical record. This was never done. This was never produced to us in that fashion. It was specifically used in the Chapter 39 proceeding, and there is no diagnosis.
We've got chapter, the DCF statement that she does not have background training experience somewhere.
I'm a little confused. Help me out, defense. For years, you've been wanting me to not talk about the dependency action, and now you're asking for the chief prosecutor's report to be put into evidence in the dependency action. So I'm unclear as to whether you're now asking this court to open up the dependency action.
No, sir, we're not. If I may be heard.
I will allow it.
This goes to a fundamental problem of contradiction in this case. We are being sued for vicarious liability for the conduct of Sally Smith on a parent agency basis. We are defending that allegation on two grounds. One is that she's not our parent agent and never has been, and that we have no vicarious liability for her. But in the alternative, that what she did was appropriate and within the standards of care.
But you would agree with me that this report has nothing to do with her treatment or lack of treatment of Maya Kowalski.
I would agree with you, Your Honor, that it doesn't have to do with the treatment of Maya Kowalski. However, that's our position. That's not the position of the plaintiffs. What we have heard from the plaintiff's expert, Dr. Neuberger, as well as others, is a criticism of this report, of Dr. Smith's conduct, of her investigation, and of her alleged involvement as a result of what she found in this in Maya Kowalski's treatment. It's all wrapped up together. Now, this report was prepared, make no mistake about it, I want to be very clear about this. As far as we are concerned, this report was prepared in the course and scope of Dr. Sally Smith's role as the medical director of the child protection team for Pinellas County. We believe that this report was prepared as a result and part and parcel of the child abuse investigation, and that she, as well as we, are entitled to Chapter 39 immunity with respect to it. But if the plaintiffs are going to criticize her care, or her consultation, or her involvement, and attempt to hold us vicariously liable, therefore, based in part on this, we are entitled to introduce it. It was in the custody of all children's, in the scanned paper documents portion of our records, not the legal medical record, just like Dr. Lewis's report.
Can I ask a dumb question? What's the hearsay exception that would allow this in?
This is a business record that was created by Sally Smith in the course and scope of her ordinary business practice.
For
The Chapter 39 investigation.
this document is hearsay. This document was prepared for the dependency action which the defense has been seeking to continue to have excluded. This document, in addition to being hearsay with no hearsay exception to which it would apply, also, even if it did, has a substantial 403 problem. This is not diagnosis or treatment of Maya Kowalski. So there is nothing that this report can do to salvage itself from a hearsay problem. Not alone the Chapter 39 immunity, which also exists, and I've been hopefully very consistent on. At the end of the day, what the jury is going to be instructed has to do with medical malpractice. And there is evidence that Sally Smith went well beyond her role, taking off the hat of child abuse investigator and went into the role of treating physician. And that is the conduct to which All Children's Hospital, or Johns Hopkins All Children's Hospital, depending on the apparent agency issue, may or may not be responsible for, not the role of her as the child abuse investigator. So this document is not coming in. 3045 is not coming in.
Judge, let me just note two things, if I could, for the record. One is that we take issue with the court's comments regarding her participation in care and treatment. The other is that we may be placed, as a result of your ruling, in a position of both defending conduct and having this document, as well as other activities on her part, used as both a shield and sword by the plaintiff. And we will have to revisit this when Dr. Smith appears to testify. And the foundation we may again attempt to lay the foundation. I'm just telling you, Your Honor, this contradiction goes to the heart of the problem we've had with the entire case as far as Chapter 39 is concerned. Thank you.
Next.
3046. It's court removal in 2018 of Maya Kowalski.
Our objection here is that this insinuates to the jury that this was a medical decision made by the Kowalski family in the absence of the material context, which is that the hospital argued strongly in the defense proceeding that she should not be allowed to receive ketamine anymore. And so to put this document in and suggest that the Kowalskis realized that ketamine was no longer helpful when they were under, in their minds, a court order prohibiting them from using ketamine would be prejudicial. So we object on 403, we object on Chapter 39 involvement, we object on relevance to this document.
Judge, this is 2018. This is long after the defense court has been dismissed. They went in and removed the report, the medical record.
I'm going to allow it, and there was also testimony and questions as to whether the port was removed at Johns Hopkins All Children's Hospital in 2016. So this would perhaps answer that issue. So 2046 pages, is it 1 through 6?
It is.
Will be received.
And we would like some instruction on whether we need to approach before we cross-examine. If when they bring this up, whoever they bring this up through, when we cross-examine on the reasons underlying this port removal, we need to approach, or can we explore those issues?
Well, I don't know what you mean by explore those issues. Haven't we previously talked about that the Kowalski family's understanding was allowed to come in as to whether ketamine treatment was allowed to come in the future or allowed to occur in the future?
I'm sorry, I didn't recall that. Thank you.
I mean, am I misremembering that? Because I thought we had a discussion before the trial started as to the meaning of the legal effect of the continued vitality of the dependencies court order after the shelter proceeding had been dismissed. And I think I wasn't going to go there, but I think we did have a discussion that the Kowalski family's understanding was, that goes to their state of mind.
Yes, I think we tried to tread a very thin line with Mr. Kowalski on the stand, and we didn't specifically mention the position taken by Johns Hopkins to prohibit ketamine. The testimony was rather that they had this general fear and concern that if they went back to ketamine, the process might repeat. That was kind of the nature of the testimony. We didn't go perhaps as far as we were allowed to go, which is the reason that this was done, the reason that they weren't doing this, because there's this court order entered based on Johns Hopkins' argument, and we would like to be able to go there.
But am I misremembering that conversation?
No, Judge, you're not, but here's the essential thing that the plaintiffs keep trying to do. They just said twice that the ketamine infusion wasn't allowed because of Johns Hopkins, when we all know it was because of a court order. And they just again said the ketamine wasn't allowed because Johns Hopkins' recommendation to the court. They keep trying to deviate from this court's rulings with respect to that.
Well, obviously there's no jury in front of us right this second. The issue that Mr. Whitney wanted to do is, does he need to come forward? I don't know what issues you're going to attempt to address with respect to this document.
Judge, it's a medical procedure she underwent in 2018. It's relevant. She didn't have a relapse afterwards. It's relevant it's being a medical record for Maya Kowalski.
I think I've already said that I'm letting it in.
Okay, sorry.
But I was going to Mr. Whitney's, he wants to approach, and I don't understand what we would be approaching on.
Understood. We'll wait till the time.
But in this case, better safe than sorry.
Sure.
So
Yeah,
if you think it's going to be close, please come forward.
I'll push.
never approached so much in my life, Judge. But we're trying to abide by that.
Like a jack in the box here.
Yes. All right, moving on, Judge. 3051. This is the report by Jack Kowalski regarding the fact that his wife is missing. The gun is missing. This is the report by Jack Kowalski. I believe it's the day before the suicide or the day of the suicide. I believe this is relevant to their irresistible impulse argument, Judge.
Didn't Mr. Kowalski already testify to this? What we normally don't put in police reports. So, I think there's already testimony on this issue, and it's a hearsay document, so let's not put it in.
All right, Judge, the next one, I'm not understanding their objection. It's 3054. They say objection page 609. Maybe that's a typo?
What are we on again?
Can you put up 3054, please?
I don't think there's a page 609.
That's a mistake, obviously.
Yeah, so they could identify the page.
Well, there's a base number down at the bottom.
Oh, maybe that's it. Thank you, Judge.
All right. Paralegal's way ahead of all of us.
Yeah, just too clever for us. So 609, can you go to base 609?
Page 10, I think.
On this document, on the right, you see base number. Page 10. Can you go to 609, please? Probably. Is it the toll page that you're objecting to?
Well,
Is this the page you're
it looks to be, and I'm just reviewing it now for the first time, but there's a whole lot of hearsay within that first entry. No.
Well, what date are we talking about first?
This is September 25th, 2020.
She's having trouble climbing the stairs.
But it goes to her condition as of September 2020. She's climbing the stairs, for one.
I mean, fair, that could be a medical condition, perhaps. It's not for medical diagnosis or treatment. The problem is, I mean, sentences like, RN stated student had told counselor it was her asthma. RN also discussed it could be related to her not weighing enough and could make stairs very taxing. And so it appears to me that it's not clear whether Counselor Wolf or the RN completed this form at first glance. Either way, it'd be one or the other reporting hearsay of the other in this document.
Triple.
To the extent there are comments by the dad, they would be admissions. And RN was clearly a medical personnel.
It begins when Counselor Wolf called and reported. So things related to Counselor Wolf, who I don't believe has in medical training. I don't know that. I don't know who she is. He is, but foundation predicate, and then there can't be statements to the counselor cannot be for a purpose of medical diagnosis or treatment. So it's not subject to an exception. And I'll point out that they had leave of court to take depositions of counselors, teachers, and I don't believe they took the deposition of this individual or asked about this document.
How are we going to use this document?
What I don't know, sorry, Judge, I don't know that we're using it with a particular witness, but there are statements in here by the dad which would be admissions.
That she doesn't weigh a lot? She's able to take the stairs? I mean, I'm trying to understand how this is going to be.
It puts in context where how she's doing as of October of 2020.
Here's, let me just tell you my view. I don't really see how this document helps or hurts anybody, but I do have concerns about statements from where it says RN, and I'm not sure that means registered nurse in this context. I really don't. And because we all understand, or I don't think we can say that, but I would suppose that a lot of the school nurses are not RNs. And I think RN could be the identity of a person.
I understand the court's concern. I would say I think they are generally aren't trained to give meds, but
it's implying like she has some sort of medical training and is giving advice and talking about conditions which I suspect she has no understanding of.
I understand.
So I just think it could be misleading. That's my concern. But that being said, it's consistent with everything that the plaintiffs have been saying. So
Okay.
I until I know more.
All right. Well, can we put a pin in it, so to speak, Judge? There's apparently an issue with something that counsel wants to use with witness today. Can we switch to that issue?
On this document?
No, sir. It's separate and apart. If we could switch gears so that we could address the witness issue.
If you can, I just have a diagram of who's who in this trial that I wanted to show to Detective Graham. I showed it to plaintiff's counsel. I don't know if there's an objection. It's just a trial illustration. I don't know what the objection would be. Obviously, I'm not putting this into evidence. I don't know. Maybe there's not an objection.
Wait, was it to Detective Graham? How are you going to?
Because
Detective Graham talk to each and every one of these people?
no, I'm just going to. I want to make sure the jury understands. Detective Graham does not work for All Children. She's not one of the employees.
No.
I can't.
I mean,
I think it's important. Well, I plan on bringing an illustration like this to be able to show as witnesses come in front of the jury who works for who, because there's mass confusion.
you're asking me to use this with Detective Graham to show to the jury.
Well, the same way as
And
if I
that
had.
answer is no. Detective Graham, you just said, didn't talk to all these people, so why are we showing pictures of all these people to Detective Graham?
Well, I was going to show it to the jury just as if I had a board, but I'll just print one out, and I guess I can bring it that way.
I guess I'm fundamentally misunderstanding. You want to show all of these pictures to the jury during your conversation with Detective Graham when Detective Graham didn't talk to these people.
Right, just so I
So
know. Okay.
why?
Because I wanted to make sure the jury understood that Detective Graham is not one of the people on the All Children's team.
So you're going to ask if she was a member of the Sarasota County Sheriff's Office, and you think you need a picture to say that she's not part of Johns Hopkins All Children's Hospital?
I'll put this into a bigger trial illustration, and we'll use it at a different time.
I mean,
There's rampant confusion with this jury about who works for who and at what time people work for people. And what I was trying to build as people come to testify to make sure the jury understands these are the All Children's people, these are the Safe Children's Coalition people, these are the DCF people, so we have a running tally.
perhaps that's part of your closing argument, perhaps, but I don't see why you start putting up pictures of other people that Detective Graham didn't talk to.
Okay, I understand, Joe.
Sure. You're here, Joe.
Okay, let's give them a couple minutes. Did they just get here?
Yes, Judge.
I'm going to briefly excuse myself because I think Detective Graham is here for Mr. Anderson's request that we try to get her on earlier. I think the plan, just so you know, is to play a video while I can talk to her about what's permissible and not permissible to talk about.
Okay, but apparently a couple of the jurors just got here because of the crash that was on the interstate. So I want to give them a few minutes. So see if they'll be ready to go in about 5 to 10 minutes, or do they need more time?
He's driving the last over.
Okay, so they're not physically in the building yet. So it's still going to be another 10 minutes or so.
And Your Honor, before Mr. Shapiro excuses himself, I think we need to address the motion that we filed yesterday, and I think Mr. Anderson's going to take it.
Okay, but understand, if you don't file something after like 5 o'clock, the clerk won't docket it until probably lunchtime today. So
I have a copy for Your Honor.
thank you.
That privilege.
Didn't we already address this?
Twice, Your Honor.
My recollection was there was a criminal investigation proceeding.
Yes, Your Honor.
There was one filed on October 8th. However, the recordings and the actual clips that they seek to introduce have nothing to do with a criminal investigation. They have to do with pursuing on behalf of Sally Smith and the CPT team some information that they will need. So the clips that they want to show are, did you consider leaving your wife? Things like that. They're not going to anything that 934.04 to .09 requires, and the purpose of such interception is to obtain evidence of a criminal act.
Well, let me stop you.
Yes, sir.
My recollection was we were going to deal with each specific want each specific statement differently, but generally speaking, there was a criminal investigation into Beata Kowalski and potentially Jack Kowalski at that particular time, and therefore and I've already ruled on it and I'm not changing my mind on it, is Florida law would allow the detective to record unilaterally that investigation.
And if it was indeed a criminal investigation and that is the basis, then there was a requirement that the witness state that she had a reasonable suspicion, which I asked in deposition, and she said she had not formed any, or that she had probable cause, which I asked in the deposition, and she said she did not have any. And so if it was a criminal investigation, she had an obligation under these circumstances to Mirandize or otherwise allow representation of counsel, which she also admitted in her deposition that she knew the Kowalskis had. So in terms of the violation of fundamental rights here, we've got the 4th, 5th, and 6th that, by her own admission, have been violated. And you've got the problem here of her recording this and taking, quote, evidence, testimony, without even complying with 934.03. Our point is, it's either one thing or another. If it's a criminal investigation, she should have been looking for probable cause, reasonable suspicion, and she should have been Mirandizing and respecting right to counsel. If it wasn't an investigation, then 934.04 through .09 would not allow her to take such information without addressing that fact with the Kowalskis. It's got to be one or the other, and I've got her deposition testimony to this effect.
I maintain my prior ruling on the issue. So are there what specific clips are you seeking to use, Mr.
I can, if you want to hear them all, yeah.
Well,
Whatever's easier for Your Honor, there's about probably 12 total that each runs somewhere between 15 seconds. So whatever you prefer, Your Honor. They're all relating to statements about staying in the
while
hospital.
we're waiting for the jury, let's...
Okay, so I guess in order, if you want to play number 1.
I mean, when we were in a meeting with the doctors one day, the other one think Maya, I'll sign her out, and I said, hold on, time out. And this wasn't wasn't written down, which I was kind of mad about, but I asked the doctors, I said, what's the time frame you talking about? And they explained. I said, that's doable. And was my wife happy with me, what I said? No, absolutely not. But, so you have to, there's times I'm going to go the other way.
Okay. And thank you for sharing that.
I don't know why they didn't write that down.
So that one we would seek to admit as obviously goes to the false imprisonment.
Does not go to criminal intent and also hearsay. It's fundamentally based on hearsay. And simply because it's a criminal investigation, hearsay rules still apply. And there's no exception that I've seen. Not to what he said, what Jack said, but what he was told.
That will be allowed. Are we identifying this as a specific A, B, C, D, E?
I just have it as clip 1. That's the way I've identified it, however you prefer.
Well, is this coming into
Yes, we would seek to admit it into evidence, yes. We'll have that as clip A.
Of what number are we talking about?
The recordings are 3120.
No,
21.
3120.
The recordings are 3121.
3121, clip A is okay. Let's see.
I'll do clip, if you'll play clip number 4, that'll be B.
And we have to be absolutely clear since we're now specifying which one they are, that we're not changing them.
Yeah, can you give me 1 second?
Judge earlier here.
Tell them about 10 minutes.
All right, yes, 3121A. That was.
Yeah, so we'll do 3121B, which is clip 4.
My bigger question is, why would a parent go to these extremes?
'Cause I'm told this is the last resort.
But you're saying it's not. And this is not, I mean, also what it taken was a question from you somewhere along the line that are we doing the right thing? Maybe we should go back and talk to another doctor, do something more conventional, not something that's likely to kill her.
I'm effective of keeping her here. That's what I told you. And if they think something else, I'm supportive of keeping her here in Lucknow.
Again, we would seek to admit it regarding his consent to treatment on the issues of false imprisonment, even as of November 17th, admission by a party opponent.
Again, Your Honor, relevancy, materiality, and again, it does not show any criminal intent. It does not show a crime was committed, and hearsay, of course, although there may be an exception to it. This one would require foundation and predicate from Jack Kowalski.
Overruled. What is C of the chart?
C would be clip 7, please.
But it's just your wife's behavior is very concerning to me.
Sure. And it's getting worse right now. Just, she don't want to cooperate.
Yeah, 934, and again, this requires some type of qualification that it was for a criminal act as opposed to just some sort of, I don't even know if we call it a bad act, what it is. But then it's relevance.
Well, again, the 934 objection, chapter 934 is overruled because there is an exception in the statute that would allow for this. Now, if this were a criminal prosecution against Jack Kowalski, maybe it's a different story, but that's not what this civil trial is. So the court will overrule those objections and allow C to come in as well. So A, B, and C are in so far.
The next one, Clay, would be clip 12.
And I'm not.
Because I know Mom talked to her once, and that was supervised. And I guess she got shut down many times because she was falling off the crack.
She could.
And then she told me what she said. I said, you can't do that. Don't talk about medical stuff. Why are you talking about the lawyer? Why are you doing?
Why can't she control? If her daughter is her main priority and why can't she follow the rules and do what she's being told?
Exactly.
Anything else, Mr. Anderson?
Again, as of this particular one, 403, in addition to the others, 403 and relevance.
Overruled. What's the next one?
The next one would be clip 11, please.
Was that last one D?
That last one was D, yes. This one will mark as Exhibit D, clip 11, please.
But, like you're saying with all this recently of calling and demanding, I'm appalled over it. I'll be the first one to admit it. It's the last thing you want to do during this. Number one thing is to focus on her getting better. Don't cause waves. Is she causing waves with me too with it? Yes.
Tell me about that.
I don't agree with she's doing, calling and questioning.
And how does that go at home when you tell her, knock it off? This is not what's best for Maya.
That's right.
Do you tell your wife when you go home that Maya is progressing and doing well? What's her response? Or aren't you telling her?
I tell her, but I don't talk to her about, I'm not trying to talk medical to her. I don't want her because then she might get on the phone and say, why aren't they doing this? You know how many times she asked me, why don't you ask them about this? Ask the doctor this, ask the doctor that. It's like, no. She's your daughter, but she's under state custody right now. So whatever happens, happens. I says, don't tell them what to do. Does that go over well? No.
Chapter 39, the argument between Beata and Jack was excluded on that basis. This goes to that at the same time, and as well as 403 and relevance to what crime is being attempted to be proven through this. But again, Judge, the problem we're going to have is when you get into what's they're being talked about here, I have to cross-examine on this.
I'm somewhat in agreement, but let me hear from Mr. Shapiro.
Sure.
Because I think this one really is a little bit different than those other clips.
Okay, the reason why I was offering it was because there's a lot of information that the jury's received about why calls had to be redirected, what was the discussion of the calls on supervised visitation. This is an admission by a party opponent that he's acknowledging that the subject matter that Mrs. Kowalski was bringing up on the supervised calls was in a matter that was adverse to the child.
Okay, but we also have a discussion about what a husband and wife were talking about, and there's other issues that are included in that clip. So I'm going to keep E out. What's the next one?
Okay. Let me just make a note so I don't play that one wrong. I would go to clip 8, please, that I'll mark as F.
Let me ask you, if Maya was released tomorrow and you guys got that child back, would your wife want to make an appointment with Dr. Hannah or doctor to take him? Would she?
It's a possibility.
And would that surprise you? If she thought, oh, we need, she's been without pain meds, we need to get her down to Dr. Hannah for a booster.
Possibility. Probably do something like that.
Well, as to that one, and I do want to assert the husband-wife privilege to the extent that any of this goes to communications. I'm not sure if that one does. But again, we're talking about in Chapter 39, what is the relevance here of whether or not she's going to take the child back to Dr. Hannah? Yeah, it is speculative by Jack Kowalski. And we, again, do not see how it is relevant to any of the issues that they're, I guess, using this for. And so under Chapter 39, plaintiffs move for the court to keep this very narrow.
And Mr. Shapiro, I mean, it is asking for a forecast of future conduct.
Yes, it goes to the direct allegation of the concerns of the hospital that Mrs. Kowalski, the Kowalskis were planning on, if they were going to go to pursue what the hospital's defense is, which is unnecessary and very dangerous treatment, it goes to the allegations of Munchausen by proxy. And so this is highly relevant as a statement from a party opponent telling, admitting that one of the things that the Kowalskis were going to do, which validates the concerns at All Children's, that they were going to take Maya from the hospital to Dr. Hannah, and it shows their intent in that regard.
But fundamentally, the discussion about the future conduct really is a Chapter 39 issue. It's not a criminal investigation issue at that point, because crime, we're talking about conduct that's already occurred, not, you don't arrest people about what's going to happen in the future. We tend to not do that. So, one, I think it's speculation.
Just one last basis would be the state of mind. I apologize.
The conduct of, or what Beata Kowalski believed, and I think it's very clear I don't think I'm going on a limb on this, is she felt that the Johns Hopkins treatment course was wrong and that the best care for her child would be to have these ketamine treatments. That is, parents are allowed to disagree with the course of treatment, and that's why the hospital has to honor the against medical advice. If the concern is the hospital is saying, well, what the mom might be doing, that goes straight into Chapter 39. And since it's a future event, it's really not part of a crime investigation. So F as in Foxtrot is out as well. What's next?
Clip 9, which would be G, please.
Now, I thought you were going to ask me the question if Maya was released from here and she was going to be brought back home, and I would have had my wife move out.
That's my next question.
That would be absolutely. in a heartbeat.
Okay,
Objection, this is speculative. Future events go straight to chapter 39, and the questionable relevancy given this, but this is again towards the future events that may or may not happen if your wife, etc. And so then there's also, I guess, a communication problem with husband and wife privilege.
there has been testimony about whether there was a plan to have her move out for a legal reason. So that has already been in there, so I don't think we can say it's not relevant.
But still speculative as to a future event. What would happen if? And remember, Judge, that throughout all this, even by the DCF.
Well, but it's him as opposed to Beata.
Say again?
It's what Jack Kowalski's going to do and not what Beata Kowalski's going to do.
Based on what the if of what Beata Kowalski would do, then it would be on what Jack would do if Beata Kowalski would do. And the Kowalski, by the way, retain their medical, well, it's not appropriate to this, but.
On this one, I am going to admit it is relevant and it's distinguishable from F and Foxtrot on what I just indicated. So the court will receive G as in golf.
Three more, Your Honor. The next one would be clip 3, which will mark for identification as H.
I don't see a child in pain. I don't see it.
Yeah. Well,
I see a child who's probably trying to appease her parents or parents.
do you honestly think she can't walk because
I think there's a psychological component,
I wouldn't?
and I think
It goes to the state of mind of Mr. Kowalski and his observation that there's a psychological component to 9's point.
Directly chapter 39, and this is also the police officer offering her medical acumen or lack thereof.
I agree with that one. So H as in hotel will not come in. What's next?
What we'll mark as I would be clip 6.
I was told here at the hospital upon her admission, and maybe some of this will shine a light on at home too. When nobody else was in the room but Maya and the staff, she didn't have to go home. When Mom would walk in the room, she was instantly in
I've
pain.
heard that many times.
There's no other explanation
I-
for that.
Yeah, I noticed it too with myself being home, and then Mom comes home from work,
And all of a sudden she's bad.
there will be changes. Yeah.
So you're at home, your guys are doing well, and playing.
No complaints about.
No complaints
but
about
then
that.
when Mom gets home,
She's
maybe-
okay.
This is all fundamentally based on hearsay. This is a predicate laid for Jack Kowalski based on pure hearsay. And again, we're leading into chapter 39, and we are, again, speculating on what would happen. There is the part about what Jack saw when Beata came home. But again, we're trying to, I don't understand what that's relevant to in light of what the predicate of the question was.
Okay, the court will admit I as in India. Obviously, there's Jack Kowalski's direct observations are highly relevant.
Can we edit out the predicate, the hearsay predicate?
Well, let me hear it again.
I was told here at the hospital upon her admission, and maybe some of this will shine a light on at home too. When nobody else was in the room but Maya and the staff, she didn't have to go home. When Mom would walk in the room, she was instantly in pain.
I've heard that many times.
There's no other explanation
I-
for that.
Yeah, I noticed it too with myself being home and then mom comes home from work.
And all of a sudden she's bad.
There'll be changes.
So you're at home, your guys are doing well, they're playing.
No complaints about me.
No complaints
But
about
then when mom gets home,
She's in pain.
So the part where I heard from the hospital and then.
Well, one thing. Okay, I agree. So we'll start it with the word "when." So it's that first few words.
Okay, Clay will need a couple minutes to that, but I'll.
But the word "when" is where we're going to start it.
Is that when the detective is talking?
Yes.
Yes.
Last one, Your Honor.
Hang on, Judge. Maybe we need to listen to it one more time because the substance of the hearsay, I thought, came after the when. Simply by taking out the source of it does not relieve it of being hearsay.
Play it one more time, but I'm pretty sure I'm going to allow it starting with "when."
I was told here at the hospital upon her admission, and maybe some of this will shine a light on at home too. When nobody else was in the room but Maya and the staff, she acted completely normal. When mom would walk in the room, she was instantly in
I
pain.
heard that many times.
There's no other explanation for that.
Yeah, I noticed it too with myself being home and then mom comes home from work.
And all of a sudden she's bad.
There'll be changes. Yeah.
So you're at home, your guys are doing well, they're playing.
No complaints about me.
No complaints
But
about
then when mom gets home,
She's in pain.
It needs to go from the end of that description, because what that description is about is repeated back by Jack. And so that's, I understand the court's ruling on that. But that predicate leading up to it, to the very, very end there, when Jack starts in saying, yeah, and to put it in, it's put into context by the latter part of it.
We're going to start playing it with the word "when." And you said the last one coming?
Last one is clip 15, which will mark for identification as J.
So when you heard this term, you saw it. Did anybody explain to you what it was?
I looked it up
Where did you look it up at?
on my phone.
WebMD? Or some
I just
other?
typed in,
And what do you recall it saying about Munchausen by proxy?
for what it said, it was almost textbook of what we went through. Mom's
Mom's in the medical field.
the
Mom's
man.
overwhelmed. Mom's demanding.
And it's like, one of these, yeah, it was concerning.
This is based completely on what he read at the time, which was hearsay. So he's repeating back something he said at the time. And so first thing we have is hearsay within hearsay. Yes, and additionally, now we're getting into chapter 39, diagnoses.
Oh, Mr. Anderson, let me hear from Mr. Shapiro, because I think I'm in your camp on this one.
Yeah, so on the first issue, it goes to Mr. Flosky's state of mind on this, if you want me to address the second issue on chapter 39.
I think you need to address the 39 issues.
Okay, because again, the issue of Munchausen by proxy, the plaintiffs have put directly into evidence that that was a misdiagnosis. They've called Dr. Newberger on this topic. They're complaining that the diagnosis codes were wrong, and that's why we refused to transfer. And here we have the state of mind of Mr. Kowalski acknowledging that based on his understanding of it, there is a prima facie case that it's a concern that he had as well. Goes to his state of mind at that time, during the hospitalization, at the exact time they were trying to transfer Maya.
J as Juliet is out. So in 3121, I have let in A as in Alpha, B as in Bravo, C as in Charlie, D as in Delta, G as in Golf, I as in India. And I've excluded E as in Echo, F as in Foxtrot, H as in Hotel, J as in Juliet. With respect to I, obviously it's going to be reduced from the totality of the clips. So defendants, let's make sure when you are providing these clips that
you provide those that are excluded on a different media so that when these clips go back to the jury, or so that they can go back to the jury. I say you have that question in your mind, Mr. Hunter, but I think your paralegals understand exactly what I'm saying.
I got it.
Okay.
Judge, I have one more. I'd like the court to reconsider just for a moment B, which is where he says we'll keep her here. At that point, at the time of this recording, there was a shelter order in place, so there was no real relevance to whether he wanted to keep her there or not. This was not during the period of when, the 7th through the 13th.
My bigger question is, why would a parent go to these extremes?
Because I'm told this is the last resort.
But you're saying it's not. And this is not, also what had taken was a question from you somewhere along the line that are we doing the right thing? Maybe we should go back and talk to another doctor, do something more conventional, not something that's likely to kill her.
I'm effective of keeping her here. That's what I told you. And if they think something else, I'm supportive of keeping her here in Lubbock.
Reconsideration denied. Obviously, that goes. There's a criminal investigation into some sort of child neglect, child abuse. That type of question is directly relevant there to that criminal investigation. So it survives a 934 analysis. And once I get past the 934 analysis, it's a statement against interest. So, and I don't see how that's a Chapter 39 issue because we have a false imprisonment claim. So,
Judge, but this statement was made on November 17th. For it to be relevant in any way, it would have to be in the period from the 7th to the 13th, 14th, when the order was issued. After the 13th or 14th, when this was done on the 17th, he had no choice whether to keep her there or not.
I am.
So it doesn't go, it's not relevant to what the point they want to put in, which is that during this period of time, from the 7th to the 13th, he said it would be fine to keep her there. If it was during that period of time, yeah, sure, it's relevant. But now we're after that. He's already in the shelter order time period. So what is it probative of? That after that, he still...
I've denied the motion for reconsideration. Let's move on. So B as in Bravo is in. Okay. What are we doing? Are we doing the detective first?
No, Judge, we're going to play a 55-minute video. And then, or a 45-minute one. We can do a 45-minute one if you prefer, given the time.
Yeah, maybe we'll do that, Your Honor. We'll play.
Well, what's coming after that depot?
Detective Graham, who I'm going to meet with and make sure she knows what statements.
So I'm bringing in the jury for 45 minutes and then sending them back out?
Or, no, we'll be ready to call Detective Graham at that point.
Which deposition are we trying to play?
Well, whatever the court pleases. We have one that's 45 minutes. We have one that's 55 minutes.
I need to walk off the bench just before noon, and we're going to take.
Okay.
I'm going to take. When we bring the jury in, we're going to do a deposition. Then we'll take a break after that. Are you okay? Are you okay, Madam Court Reporter, if we go for up to 55 minutes, or do you need a break now?
No, I should be okay.
Well, that means she wants a break now. So.
The issue is I don't know which deposition they're going to play, and I understand we've only been provided Dr. Malik. We haven't been provided these depositions.
Who's the 55-minute one?
We have provided you
Just Ms. Krause.
the videos.
This morning.
Ms. Krause. Folks, to me. Who's the 55-minute one?
Dr. Revivo.
There you go.
We were never provided that clip, that video to review until I guess this morning. We just got it.
No, we don't have the video still.
We don't have the video. We've never had a chance to review it.
Okay.
But they provided their.
One person.
Yeah, they provided their cross designations.
No.
Have they had a chance to verify the clip?
Okay. Judge, I'm
The
not aware.
answer seems to be no.
I was unaware that was the case. Which ones have you viewed?
Dr. Malik is the only one we've received a complete video of. with enough time, not this morning, enough time to see it.
Well, if you prefer we do Malik, we can do that, but then Mr. Anderson's gonna be here through lunch while we do that one, and we'll put on Detective Graham after lunch, so it's whatever you prefer.
The goal was to try to get.
I don't care what the goal is. I've got a jury waiting. You know my time constraint. Make a decision. Do you want Dr. Malik, or do you want to go with a deposition that you haven't had a chance to review? Or force him to call Graham now?
I might be able to meet her in 15 minutes, be able to put her on by 9:45.
Judge, if counsel's telling us that all of the objections and the court's rulings have been honored and all of the my cross is in there, then I will trust counsel that that's the case. And it's for the purpose of getting Detective Graham on this morning.
I designated everything and highlighted.
There we go. So we want the 55 or the 45 minute?
We'll do the shorter ones, so that way you can get out here.
Thank you, Ethan.
Okay.
So we'll do the 45 minute. What we're going to do is we're going to take a 5-minute break. We're going to tell the jury we're taking a 5-minute break, and then as soon as we come back, they're coming in. So if they need to use the restroom or anything, have them do it now. 5 minutes. Please be seated. Is Mr. Shapiro going to be outside during this?
Yes.
So we don't need to wait for him?
We do not, Your Honor. I do want to mention that the video does show records, but they're in evidence.
Are we confident that all of the...
It's the Lurie Hospital records that are in evidence.
Okay.
Also, if we could give a brief just introduction from your own to the phone witness about the time frame in which the doctor was involved. That would be acceptable.
Yeah, I'm assuming someone's going to say it's on this date. The deposition's on this date.
Well, I had the deposition date, but I was talking about the treatment dates more.
It's in here.
It was Lurie Children's Hospital and 3 days at the hospital.
It's in there.
You feel comfortable saying?
Well, let's see what actually is said. I mean, if it's clear in the deposition, then I try not to insert myself at all if I can help from it. Anything else, or can I bring in this jury? Let's bring in the jury.
Is there a place I can see the screen without having to move the world?
We're going to try. Okay, welcome. Please be seated. So, members of the jury, everyone made it through the interstate okay today? I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that correct? Correct. And that no one approached you about this case. Is that correct? And have you seen any media coverage about this case? Is that? I heard a correct and a no. So did anyone see any media coverage? No. Let's try that one more time. It's Friday. Has anyone seen any media coverage of this case since we were last together? No. Thank you. Ms. Crowells, the next witness, please.
Yes, we're starting with a video deposition of Dr. Zachary Pitzenberger.
Is the lighting, you want it brighter, less bright? Okay, thank you.
Today's date is October 20th, 2021. Today's date is October 20th, 2021. We are on the record at
10:03 a.m. in the deposition of Zachary Pitzenberg.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do. Let's start off with having you state your name and your professional address for the record, please.
Zachary Pitzenberger, 225 East Chicago Avenue, Chicago, Illinois.
And where are you presently employed?
At Lurie Children's Hospital in Chicago.
And my understanding is you are a pediatric emergency room physician. Is that correct?
That's correct.
Can you please start off by giving me the benefit of your education and training, starting from where you graduated from undergraduate all the way through any residency and fellowship training that you have?
Sure. I did my undergraduate education at Bowling Green State University in Ohio. 4 years. My degree was in biology, and then went to medical school at University of Cincinnati, College of Medicine, and did a 4-year training there. After graduation from medical school, I did a residency in pediatrics at University of Colorado in Denver. And after completing that, I went to a fellowship in pediatric emergency medicine at Boston Children's Hospital in Boston. And then since I graduated there in 2013, I've been employed at Lurie Children's Hospital in Chicago.
Okay. And I understand the fellowship training you did, that was in pediatric emergency medicine?
That's correct.
That's Boston Children's Hospital. I believe that's affiliated with Harvard Medical School.
That's correct.
Okay, so it's safe to say you have some Harvard training?
Yes, you could say that.
Where was your fellowship, doctor?
At Boston Children's Hospital in Boston, Massachusetts.
Okay, and that was in what specialty?
Pediatric emergency medicine.
I also understand you were the chief fellow on your CV here. It says chief fellow, Harvard Medical School. What does that mean?
During the final year of my fellowship, I was in charge of several administrative tasks regarding the fellowship, like scheduling conferences and things like that.
Looking through your CV a little bit here, Doctor, I see that there's an invited lecture here entitled Child Abuse, Overcoming the Disbelief, where you were a speaker in 2016. Can you tell me a little bit about that?
That was a conference held by our transport team at the hospital, where they asked me to give a talk on child abuse. And it's in detecting it in the primary care setting as well as in emergency rooms and urgent cares. So just kind of looking for different signs and symptoms that could be indicative of a child abuse case, and presented at that conference.
What did you review today, if anything, in connection with preparing for your deposition?
My note from the visit in 2016. 2015.
Okay. And that was a July 21, 2015 visit at Lurie Children's Hospital in Chicago?
That's correct.
Where were the services that you rendered in July 21 of 2015?
In the emergency department at Lurie Children's Hospital.
Okay. I also saw on your CV here that you have a publication, Pitzenberger's DE, entitled Trends in Pediatric Visits to the Emergency Department for Psychiatric Illness in the Academy of Emergency Medicine for 2014. Can you tell me a little bit about that publication, please?
That was a research project I completed during fellowship, in which we looked using a national database, just looked to see what trends were happening with visits to the emergency department for psychiatric illness in children.
As part of your training as a pediatric emergency room physician, is part of your training consist of psychiatry?
We don't do any specific rotations in psychiatry, but we see many patients with psychiatric conditions who come in for those concerns and treat them while they're in the emergency department.
Okay. And so screening for potential psychiatric illness, is that something that is within your training and expertise as a emergency room physician?
Yes.
Okay. Are you familiar, after the patient left the emergency room and left your service, are you familiar with Maya Kowalski's course at Lurie Children's after your involvement?
I'm not.
The date of arrival was what date?
July 21st, 2015.
Okay. And the patient, again, was Maya Kowalski, correct?
Correct.
Okay. And how did she arrive at the emergency department on July 21, 2015?
By ambulance, it appears.
Okay. And under the comment here, do you see where it says comment from Florida, severe pain, quote, myopathy, here for second opinion, joint pain, bone pain? Do you see that?
I do.
Okay. Who would have these chief complaints? How do those get entered into the chart?
They're entered during the triage process by a nurse when they first meet the patient.
Okay. And who would have been the source of that information in that comment, most likely?
Either the patient or the patient's parent or guardian.
And at the time, do you know how old Maya Kowalski was?
I believe later on in the note, I see she was 9 years old.
And on this first page here, we have something that says here HPI. Does that stand for, well, actually, let me ask it since there might be an objection. What is HPI?
So HPI stands for history of present illness.
Okay, and typically who provides the information for an HPI?
The patient or the patient's caregivers.
Okay, so it's fair to say the information on the HPI here would have either come from Maya Kowalski or her mother, Beata Kowalski?
Correct.
Do you have any, at the time you're rendering this diagnosis, do you have any independent records to confirm or substantiate what's on this HPI?
I believe they had provided us with a discharge summary from the visit to from the hospital in Florida that they had just left, which is somehow how we got some of the specific dates of the history.
Understood. And so rather than go line by line here, can you just describe in summary form what this HPI is discussing and explaining?
It's accounting for multiple visits to healthcare for respiratory illnesses that were thought to be asthma, and so treated with multiple courses of corticosteroids, and then was thought to have a complication from those corticosteroids during her last admission to the hospital.
And what are corticosteroids?
They're a type of medication used to decrease inflammation.
Okay. And I see references to myopathy and suspected myositis. What are those?
So myopathy myositis would be a complication of corticosteroid use in some patients.
Okay. And possible neuropathy and pain. What is that?
Neuropathy and pain would be just sort of irritation of the nerves or any kind of pathology of the nerves that causes pain. Typically, any sort of injury or inflammation can cause sort of that finding.
Okay. And I think your note also references that the patient at some point became unable to walk. Do you see that? It's under 7/4/2014.
Yep.
Okay. Was that something that was also communicated to you by either the patient or the mother?
Yes.
Based on your note here, what is your understanding of some of the hospital course at Johns Hopkins All Children's Hospital prior to transfer to Lurie Children's?
She was admitted there, and they diagnosed her with adrenal insufficiency, which is a complication you can get from chronic corticosteroid use. And they tried to treat her pain with multiple medications, including Toradol or Ketorolac, morphine, Valium, and IV Tylenol or acetaminophen.
Okay. And I understand it looks like there was also a neurology consult done there. You see that in your note?
Yes.
Okay. And it appears as if there was also pain management services that were consulted at Johns Hopkins as well. Is that correct?
Correct.
Okay. And the very bottom of your note, 7/2015, it indicates that mom requested discharge from St. Petersburg and mom arranged transport to Chicago. Do you see that? Oh, yeah. Of course. There it is. Okay. And so is that your understanding of how the patient came to be treated at Lurie Children's?
That's correct.
Okay. And under medications here, it lists several medications, some of which say last given and some of which don't. Can you explain to me the difference between a last given medication and a medication that's just listed?
The medications listed without any last given behind them are more for respiratory complaints or concerns about allergic kind of complaints, whereas the ones with last given are all pain medications, which would be much more sensitive to timing. So they were documented as to when she got her last dose, so you could make sure they didn't miss doses of her medications when she was presenting with pain. Those rather.
Okay, let's go ahead and we'll move over to 136 here. Past medical history. What did you indicate there as to the patient's past medical history?
We had no specific medical history on file from our records.
Okay. And same question for those medications that were listed back on LCH 136. Would that have been something you would have confirmed or something that would have been per patient or parental report?
Per patient or parental report.
And what was your understanding of the patient's constitutional situation under review of systems as of July 21, 2015?
So she reported pain and weakness for the last 15 days and a recent diagnosis of the steroid-induced myopathy or myositis.
Okay. With possible neuropathy/pain?
Correct.
And was that your understanding under constitutional? Was that your understanding of that was the purpose of this hospitalization, was a workup for these issues?
Correct.
What is a physical exam?
When the patient is in the emergency department, we'll assess their physical state of being objectively and document that in this portion of the note.
And do you do that with a hands-on assessment?
Correct.
And in this case, did you perform the hands-on assessment for Maya Kowalski?
I did.
Okay. And I also it looks like there's some vitals listed there as well. What are vital signs?
So they're measurements of kind of the patient's overall well-being, again, measuring pulse, blood pressure, temperature, respirations, weight, and pulse oximetry.
Okay. In terms of the patient's pulse, what was listed?
75 beats per minute.
And is that something that's within normal range for a pediatric patient of Maya Kowalski's age?
It is.
How would you characterize a pulse rate of 75 for a pediatric female who's 9 years old?
That'd be within the normal range for that vital sign.
Same question for the blood pressure here of 114/65.
That would be within the normal range for that vital sign.
Okay. Same question for temperature, respiratory rate, weight, and SpO2.
For the temperature, respiratory rate, and SpO2, those would all be normal. I would want to confirm it with a growth chart as to the weight, as that's normal for her age.
Thank you. And you note here under general appearance, alert, active, responsive, well hydrated, well appearing. What does that mean?
She was awake and responsive to questions and answers. Didn't appear to be dehydrated, so there's no physical exam findings of dehydration, and overall no signs of distress at the time of our assessment.
Okay. And then what did you put here under lungs and chest?
Just to clarify, this is the nurse practitioner's note from the visit. I did do my own assessment down below, but she documented clear auscultation, meaning there's no abnormal sounds when you listen to her lungs with the stethoscope, and she was in no distress.
Okay. Do you see any, based on your review of Exhibit 1, do you see any evidence of a patient suffering from an asthma attack or some type of asthmatic episode?
Not that, no.
I'd like to now go down to skin normal. What does that mean when you document on a physical exam, or your nurse practitioner documents on a physical exam normal for skin?
We don't identify any abnormal findings such as rashes or any other changes to the skin on the examination.
Is it your ordinary practice or the ordinary practice of your providers that you work with that if they notice a lesion or something like that, or a rash, is that something that would make its way into a physical exam finding?
That's correct.
Can you read under neurologic what your APRN noted as a result of the physical exam that was performed?
The patient was unable to cooperate with the examination to be able to obtain reflexes. Patient with good upper and lower strength, parentheses, as demonstrated by kicking this provider with both legs, pushing herself up and into her mother's arms with her arms.
Okay. And now, recognizing that some of the jurors that may hear this testimony are not physicians, can you kind of explain in lay terms what this neurologic physical exam note is describing?
That it was difficult to complete the physical examination secondary to her cooperation with our requests for different maneuvers that we would do to test her strength and other neurologic functions. But based on the behavior she exhibited with her kicking our nurse practitioner, as well as pushing herself up using her arms in her bed, she appeared to have normal strength for those maneuvers.
Okay. So why is it significant that the physical exam notes that the patient was able to kick a provider with both legs?
The concern being that she had weakness, it would demonstrate that there was some more strength than we were able to assess by her cooperating with us on exam. And so we felt there was some strength that was present, even though she denied being able to move her legs otherwise.
Okay. And I'll ask the same question here for the statement here, pushing herself up and into her mother's arms with her arms. Why was that entered into the note, and what is the significance of that entry?
It would show that she had a fair amount of strength in her arms to be able to lift her own body weight, which was not what she was demonstrating to us on our examination. We asked her to demonstrate her strength otherwise.
If you could just describe to me what the assessment and plan is on LCH 138 here as indicated by your nurse practitioner.
So it says that she has a percentage of generalized weakness and generalized muscular pain, the symptoms that were ongoing for a while at this point in time. So we were concerned for possible myopathy and myositis has been the concern at the other hospital. But there's also concern for conversion disorder at that point in time initially. So we were going to do some laboratory testing to try to confirm that any objective findings consistent with the myopathy or myositis, and go from there once we get the lab results back.
Okay, and then there's a reference here to conversion disorder being on the differential. What is conversion disorder?
It's a psychiatric condition where patients demonstrate physical findings that are not necessarily physiologically derived or not necessarily pathologically derived, and often is a manifestation of a psychiatric diagnosis.
Okay. And what does it mean that that conversion is on the differential?
It was on our consideration as possibly playing a role in the patient's presentation, but not necessarily confirmed at any point in time.
Okay. And is that why you did a med psych consult for this admission?
We didn't do one in the emergency department. I think they did one after she was admitted, but we thought it was an appropriate part of the medical care to be provided. Yes, based on the labs they had sent, which was a complete blood count as well as a complete metabolic panel and a CK, which is a muscle enzyme that is detectable after muscle breakdown. They all appeared to be reassuring at that point in time from the previous hospitalization.
So what does that mean? The CK was reassuring?
That it was likely within the normal range of the lab value or slightly elevated, but not to the market amount we would expect it to be elevated if she's having significant muscle breakdown.
And what is the significance of muscle breakdown in terms of this patient's presenting suspected diagnoses?
We would expect if there's significant myositis that there would be some sort of CK elevation associated with that.
Okay. And so the fact that CK was reassuring, what does that mean?
It made us less concerned that there was a myositis picture going on as the cause of her weakness.
Okay, can you walk me through each one of those items and tell me what those are and why that was on the plan moving forward for Maya Kowalski?
Yes, this is our plan at the time of our first assessment of her. So the PIV would stand for peripheral intravenous line. So establishing an IV for medications and fluids if need to be given, as well as to do a laboratory draw. CBC would be a complete blood count, which is a lab test we were going to obtain, as well as a complete metabolic panel, which is CMP. CK is the muscle enzyme we discussed just a moment ago. Morphine was indicative of, we were planning to give her a dose of morphine because her pain control didn't seem to be adequate at that point in time. Tylenol as well for pain control. And then we figured on our first assessment that she would likely need to be admitted to the hospital to general medical service for pain management as well as other further evaluation. And then a med psych consult would be helpful to determine if this may be related to a psychiatric diagnosis or not.
All right, and this, my understanding is on 138, this was entered in by your APRN or your nurse practitioner, is that correct?
Correct.
Okay, so when we turn to the next page, and I think that APN is Janice Zinani, is that correct?
That's correct.
Okay, and you worked, and back at this time, did you work with Miss Zinani?
I did, yeah, I do still, yes.
Why don't you walk me through the process of how an APRN does an assessment and then how you got involved in this case in terms of your assessment and entering a note about your assessment?
So once the patient is seen by our nurse practitioner, she would come in and present her findings to me. And then after we had come up with a plan together, I would go examine the patient and get a history independent of her to confirm the findings and see if I detect any other new findings, and then document that in my portion of the note, which is displayed here.
And so why don't we walk through the second paragraph here of your note. Do you see there where there's a reference to prolonged recent hospitalization with presumed diagnosis of steroid-induced myopathy, which has made her non-ambulatory and bedbound for the last 3 weeks at All Children's in St. Petersburg, Florida? Do you see that?
I do.
Okay, what are you describing there in your note?
That she'd been on this corticosteroid regimen, and there's concern for myopathy from the previous hospital, where she had been not able to walk in her bed for the last 3 weeks prior to coming to our hospital.
I'd like to move down here to the second paragraph. You see where it says, actually the third paragraph, where it says mother specifically requesting further diagnostic workup. You see that?
Yes.
What does that mean?
The mother had relayed concerns about the accuracy of the diagnosis and was wanting further evaluation in our hospital to make sure that we were on the right diagnosis and no other complicating factors would be present.
You indicate here in your physical examination, quote, exam limited by patient screaming and mother requesting no further examination after light touch to dorsum of foot induced intense pain. Do you see that?
Correct.
What are you describing there in your physical examination?
I touched the top of her foot lightly with my hand, and it seemed to induce severe pain in her, and that she began screaming afterwards. So the mother had requested that we didn't do any further physical exam at that point in time.
Okay. And the next line, you say patient is awake and alert, near constant screaming and pain, but distractible easily and will answer questions, hold conversation without apparent distress, and quickly go back to moaning and screams. Do you see that?
I do.
What are you describing there in your physical examination note?
If I would ask the patient questions or hold a conversation with her, she didn't seem to have any ongoing pain during that period of conversation. Once the conversation ended or she was done responding to my questions, she quickly would go back to sort of moaning and screaming in pain.
Okay, and as a pediatric emergency room physician, why is that significant, if at all?
Distractible pain is often considered to be less severe than non-distractible pain. It means the mind can be fixed on other things besides just the pain itself.
Okay. Is that something that you would potentially lead you to conclude that conversion disorder should be put on the differential?
Not necessarily, no.
The term distractible appears in your medical chart, does it not, doctor?
It does.
Can you just explain what that term means in the context of a workup in a pediatric emergency room?
Whatever behavior the patient would be demonstrating at that point in time can be stopped by giving the patient some sort of other stimulus that would distract them away from whatever the behavior was for a period of time.
And then here you note, quote, lung without observed decreased aeration, but limited as constant screaming with assessment and auscultation triggered coughing spell, but no cough prior. What are you describing in that portion of your physical examination?
The listening to her lungs with a stethoscope was somewhat limited because she was screaming constantly, so I couldn't get a good listen to whether or not there was any wheezing or other abnormal findings present. But with the deep breaths that she took for the examination, she did start having a coughing episode, but had not been coughing prior to that deep breath that she took during me trying to listen to her lungs.
And why is that a significant finding that makes its way into this emergency medical chart?
Since there was a limited ability to listen to her lungs, the lack of cough prior to that indicated that she was in significant respiratory distress to me.
So when you're saying no cough prior, are you saying Mike Kowalski was not demonstrating a cough until you started doing deep breathing to try to listen to her lungs?
Yes, that's correct.
Are you familiar with the term psychogenic or habit cough?
I am.
What do those mean?
Typically, they mean a cough that's not triggered by respiratory illness, but more through a psychiatric condition.
And then when you listen, you detected, I believe, 75 beats per minute of the heart. Is that correct?
I believe, yes, that's correct.
And then to finish off this paragraph, you document skin pale but no rash. Do you see that?
I do.
What are you describing in that entry?
That she appeared pale and slightly less pink than you see. Paleness just indicates a possible finding of anemia or other sort of illness, but there's no rashes or specific localized changes to the skin that we identified.
If you had seen some localized changes in the skin, is that the kind of thing that would make its way into your attending note?
It would.
And if you could just describe in general terms after reviewing assessment plan, what was your assessment and then plan for this patient moving forward?
So we were in agreement that there could be possible steroid-induced myositis as to what the other hospital had been concerned about. Although we felt that the pain was more diffuse and profound than you'd expect to see in just straightforward myositis. And some of her behaviors that indicated she was in rather severe pain were a little bit atypical for what we typically see in a patient who's on that aggressive of a pain management plan that she had presented with.
Okay. What do you mean by atypical?
Not the standard findings you expect to see in the majority of patients.
Okay. And I see here in your note, you say, although pain is more diffuse and profound in her behaviors than would anticipate with this aggressive pain management, and labs do not show signs of muscle injury with normal CK. Do you see that?
I do.
Can you break down in layperson's terms what you're describing in that portion of your note?
That she was on a significant amount of pain medications when she presented, but she still had profound pain that had not been responsive to the pain medications they had used thus far, which was which would be a little atypical, and that her labs at the time of our assessment showed no signs of muscle injury based on the laboratory findings of the CK.
Okay. And then you note here, quote, her behaviors are concerning for psychiatric component of the pain, possible conversion disorder with the distractible nature of her pain. Do you see that?
I do.
What are you describing in that portion of your note?
That her behavior during the examination was concerning for at least some component of her pain being related to an underlying psychiatric or psychological disorder.
Okay. And so it could, did you have an idea exactly what that psychiatric disorder was at the time, or are you just saying it's a possibility that needs to be addressed further?
Just it's a possibility that needs to be addressed further during the hospital admission.
Okay. What specific behaviors were concerning for a psychiatric component that you observed?
I'm not sure exactly based on my note. I don't recall the visit independently.
Okay. So just based on your note, what were some of the behaviors that were concerning for a psychiatric component?
I would say that the distractible nature of her pain behavior, as well as the lack of cooperation with the examination.
Okay. And again, we talked about conversion disorder. Based on your reading of this note, why was conversion disorder on the assessment plan?
I think her lack of response to appropriate treatments thus far, and the atypical presentation of what the diagnosis she had been given at the previous hospital would both be concerning for that condition.
I see here at the very end of your note that you did an admission to Gen Med. What is that?
It's our general medical service. So it's, the service that takes the majority of our patients with complex issues or issues that can be dealt with by a straightforward non-specialist group.
And what specialists, what team of specialists did you think would be needed to be consulted here for Mike Kowalski at Lurie Children's?
I thought likely the psychology or psychiatry department would have to be involved, as well as the pain management team.
Okay. And so why did you decide to get the psychology team involved?
I think it's the concern for a possible psychiatric disorder complicating her presentation.
Okay. And then why did you get the pain team involved?
Her pain management didn't seem to be adequately controlling her pain at the time of presentation. And so in an effort to try to improve her pain, thought that they could add other expertise in that area.
What is the Rehab Institute of Chicago?
It's a hospital that specializes in rehabilitation of patients who've had injuries or other conditions that make less able to do their daily routine and activities of daily living.
Okay.
It's affiliated with our hospital.
Oh, so it is affiliated with Lurie Children's?
We're all under the same scope of Northwestern University.
Let me ask you just some general questions about ketamine. Does Lurie Children's emergency room have any type of protocol for the administration of ketamine to patients?
Yes.
Okay. Do you have a reference range in terms of in terms of milligram per kilogram per hour? What type of doses that you guys administer there at Lurie Children's with respect to ketamine?
In the emergency department, we don't use a continuous infusion. We just do bolus dosing of ketamine for procedural sedation. Okay.
And why don't you do continuous infusions?
It's not something that many of our providers have been trained on, and our nurses are not trained on it either.
If you're going to have a continuous infusion at Lurie Children's, what wing of the hospital would a patient need to go to?
Like the ICU, or intensive care unit.
The intensive care unit? Okay. And why is that?
It requires close monitoring of nursing that needs to be typically one-on-one or very near that nursing staffing ratio, and then you need to have very close attention from the providers administering medication as well.
In terms of bolus doses for ketamine, do you guys have any guidelines at Lurie's regarding the types of bolus doses of ketamine that you will administer in the emergency room?
I believe our maximum dose is 2 milligrams per kilogram.
Have you ever heard of a patient or a patient's parent coming into your emergency room at Lurie Children's and asking for 1,500 milligrams of ketamine? What was that? What was your answer, sir?
I don't recall any cases of that high.
That's a max dose, so you could give less than that, but you're not going to give more than 2 milligrams per kilogram. Is that correct?
That's correct.
why is it, doctor, that at the emergency room at Lurie Children's Hospital, you don't administer more than 2 milligrams per kilogram of ketamine as a bolus dose?
I believe that anything higher than that would be out of the recommended dosing range from the manufacturer, but also there'd be safety concerns about the tolerability of that high dose.
Okay. All right. Do you use propofol to sedate patients in the emergency room?
I do not know.
Okay. What about intrathecal clonidine pumps? That's something that your service recommends for chronic pain patients?
We do not do that, no.
Am I approaching, saying that correctly?
That's correct, yes.
Did not see anywhere in Exhibit 1, which begins at 0135, that being the Lurie Hospital records. I did not see a notation anywhere that the mom was acting in any unusual or concerning manner. Do you?
I do not see that, no.
And given a background in spotting child abuse, if a parent was acting in an abnormal or unusual manner in relation to the care and treatment of their child, that would be something that would be incorporated into the record, would it not?
It depends a lot on the presentation. Sometimes we would include it, sometimes we would not want to include it, as that could be inflammatory to the patient down the road if that was not found in fact to be true.
Define conversion disorder for the jury.
Conversion disorder is presentation of a physical complaint or pathologic sort of disease state process that's not necessarily founded in the underlying pathophysiology and more based on patient's psychiatric or psychological condition.
And so it is a diagnosis of, in this instance, it would be a diagnosis, if it were true, of the child, not of the mother, correct?
Correct.
Do you understand what happened in this case generally?
I am not aware of anything outside of the ER visit with the patient.
Okay. You have nothing in your, strike it. Although it's called by a different name right now, are you aware of a condition formerly known as Munchausen by proxy and now known as factitious disorder by proxy, or a term similar?
I'm aware of that condition, yes.
I didn't see anywhere in these records where you made any such diagnosis. Is that true?
I did not make that diagnosis, no.
Nor did you recommend over for a psychological or psychiatric evaluation, Maya, with any indication that that was a concern, correct?
That was not indicative of that, no.
And did you have the opportunity to review any of the records, prior records of Maya? That is, from prior hospitalizations, prior treatments, things of that nature?
I did not know.
Have you treated children with complex regional pain syndrome, previously known, some people still do, as reflex sympathetic dystrophy?
I have, yes.
I'm not asking you for a definitive diagnosis, but insofar as her extreme reactions to imminent belief of pain or touching, in your experience, could this be an indicator of complex regional pain syndrome?
Complex regional pain syndrome is not a diagnosis I typically make, so I would defer to the specialists in that area.
What is a hyperesthesia?
Hyperesthesia would be an increased sensitivity to different sort of stimulation in the area of the body that's referring to.
Well, how can you say a neck is supple if you haven't had a chance to touch it?
So she's actively ranging her neck through the full range of motion. That would be indicative of a neck that is supple.
Isn't it true, doctor, that there were certain areas, such as the top of the feet, where if you touched her, she would scream in pain? In other areas, if you brushed up against them, lightly touched them, she did not.
Again, I don't recall anything beyond what's documented in the note. But the definitely had intense pain with the touching of the light touch to the dorsum of the foot.
statement here, patient kicking this provider with both legs and pushing herself up and into her mother's arms with her arms. You would agree that this is somewhat unusual behavior, is it not?
That would be atypical behavior for that age patient, yes.
Right. But it's not atypical behavior at all for a child with complex regional pain syndrome, is it?
I would defer to specialists regarding that.
You note that on several instances that she could be distractible from her pain. Is that not also an indication of CRPS?
Again, I would defer to the specialist regarding the specifics about the diagnosis.
Did you use any of the following examination tools in examining Maya? A pin to test skin sensitivity?
I don't see any documentation of that, no.
All right. Temperature tape.
Sorry, what was that?
Temperature tape or an infrared thermometer.
We did take a temperature. I'm not sure of the measurement device they used for that, though.
Okay. Was the temperature simple, normal bodily temperature, or was there any attempt to check temperature in different portions of Maya's body? Extremities, abdomen, things like that.
We would typically only check it in one portion of the body.
Okay. Was there a von Frey test? Or Frey test?
I don't believe so.
Was there a weighted pin test?
Again, I'm not familiar with what that test is.
An algometer. Was that used?
I'm not familiar with that testing device either.
Goniometer. Was that used?
Again, I'm not familiar with that testing device.
Skin. Have you ever seen photographs of what CRPS lesions look like?
I can't say that I have, no.
Okay. And do you know whether they appear in parts of the body that are sometimes difficult to see with a basic examination? Under the armpit, the back of the forearms, things like that.
I'm aware that sometimes those kind of lesions are difficult to detect on physical examination.
And so I take it that you continued with the diagnosis of myopathy and myositis and possible neuropathy pain that she entered with?
We could not rule. We had no evidence against those diagnoses, so we presume they were accurate in our evaluation of the patient.
And did it come to your attention that this was these diagnoses came from Johns Hopkins All Children's Hospital in Florida?
That was our assumption, yes.
Can we pause for a second?
Do we need to pause?
Yes. I didn't hear any audio.
Oh, I think there's just there's just a pause before the question, Judge.
Okay.
He's really good at sitting still.
Regarding the ketamine, you yourself are not an anesthesiologist, as I understand your training?
I'm not an anesthesiologist, no.
And I gather you have not been involved in the actual treatment of patients with CRPS?
I have not, no.
Finally, were any other tests such as MRIs, nerve conduction studies, EEGs, EKGs, anything like that done towards a diagnosis with Maya?
Not during the time in the emergency department, no.
I think you testified in response to Mr. Anderson's questioning that you do have some experience with complex regional pain syndrome. Did I hear that correctly?
I've treated a handful of patients that have come in with that diagnosis, yes.
Have there been occasions in the past, doctor, where you've placed CRPS on the differential diagnosis for a pediatric patient?
Yes.
And was complex regional pain syndrome on your differential diagnosis for Maya Kowalski?
It was not.
Why not?
The diffuseness of her pain involving almost her entire body would be typical for complex regional pain syndrome.
Can you name for me the 5 different symptoms that you would look for in a differential diagnosis of CRPS?
I would defer to the specialists in different, other than my specialty, regarding what the findings are that are needed for the diagnosis.
Yes. What are the 5 sample signs? Can you give me one of the sample signs for a differential diagnosis of CRPS?
I'm not familiar with the term sample signs regarding chronic regional pain syndrome, no.
Suffice to say you are not an expert in CRPS. Agreed?
That is correct.
You agreed that you would defer to those physicians who have studied CRPS for a lifetime?
I would defer to them, yes.
Well, if you had considered it, you would have put down the basic categories and whether any of the sample systems were present, would you not?
I would say we consider numerous diagnoses from every patient. We don't always document all the things we consider in their evaluation.
Okay,
That would conclude the deposition.
Okay, members of the jury, we're going to take a 5-minute break. Let's try to keep it to 5 minutes. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
I can see.
Received a note from the juror wanting to clarify the November 9th because employers are asking, can you clarify the November 9th date? Is this when you expect attorneys to be finished and then the jury deliberate, or does November 9 include jury deliberations? And it also says, thank you for the decorations, made us all laugh. One of the jurors has a birthday over the weekend, so my assistant put a happy birthday sign up, and then for the 11 others, we put a happy unbirthday sign up. So I was going to clarify when they come back that November 9 would include deliberations.
Agreed.
Anything else before we take 5 minutes?
No, Your Honor.
Okay, let's take 5 minutes.
All rise, court is in recess.
My only concern with telling the jury that deliberations will be done by the 9th is we hope they'll be done by the 9th with this jury. I just anticipated that it will include.
What I will say is, my goal is to get this.
I want them done.
Yeah, we want them done.
Sorry. Yeah, sorry, Your Honor.
Get this to you to begin your deliberations by, I really want to do it by the 7th.
Okay.
Yeah.
And then I can say, and it'll be up to the jury to determine how long it wishes to deliberate.
Yes.
Is that fair?
Yes.
Fair enough, Judge.
Anything else before I bring in the jury?
Now for the plaintiffs.
Let's bring in the jury, please. Everyone.
Members of the jury, I just want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation, you received no information. Is that all correct? And has anyone approached you about this case since you were last with us? And have you seen any media coverage concerning this case since you've last? No. Okay. There was a question about the November 9th end of the trial, and whether that's the time that you're going to begin to deliberate, or would that include the deliberation dates? I anticipate, and I think that you will be able to begin deliberations on November 7th. So once the jury begins to deliberate, it becomes really in the hands of the jury as to how long you deliberate. So my goal is to land this case for your deliberations November 7th. If that is going to become difficult or impossible, I will let you know when I know it. But as of right now, I continue to believe I can land this by November 7th. So, okay. With that, defense, your next witness, please.
Your Honor, we call Detective Stephanie Graham.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Ms. Hall. Let me see it for this.
Okay.
May it please the court. Good morning and happy Friday.
Good morning.
Okay. Would you introduce yourself to the jury, please?
Hi, I'm Stephanie Graham.
Okay. Ms. Graham, will you give this jury the benefit of your background and education? Well, let me just set the table first. We're going to talk to you about some involvement in this case, in the Kowalski case, in October, November of 2016. Okay.
Yes.
Can you tell the jury what was your occupation at that time?
I was a detective with the Sarasota County Sheriff's Office.
Okay. Now we're going to work backwards. Okay. Can you tell the jury, starting with college, where did you go to school?
I graduated from University of South Florida with a Bachelor in Arts in Criminology. From there, I went to the Sarasota Criminal Justice Academy, where I graduated first in my class in 1998 and subsequently was hired by the Sarasota County Sheriff's Office.
Okay. Did you go to the Sarasota County Sheriff's Office right out of, I think you said it was detective school or officer school? Criminal Justice.
Criminal Justice Academy. Within about a couple weeks, my hiring process, I believe, had started prior to my graduation from the academy. And then I was hired April 30th of 1998 because I just retired this past May.
So we're bringing you back. We're going to put you through a little memory contest. But so once you finish the academy and you have the job at the sheriff's office and that time period, what did you do for the first years? What types of roles?
Okay, so during my 25 years with the Sarasota County Sheriff's Office, I had the privilege of working in several different areas. One being a court deputy. I worked as a patrol deputy, a criminal investigations detective, a special investigations detective, a special victims unit detective, and a civil unit deputy.
Okay. Was there a time that you became assigned to what the jury may know of as sort of special victims or vulnerable victims units?
Yes, I became a member of the special victims unit, I believe, in June of 2012. That unit
is responsible for investigating crimes involving child victims that might be child abuse, neglect, also vulnerable adults such as disabled or elderly adults. Those individuals in our community who are most vulnerable.
Were you in that role in October and November of 2016?
I was.
Okay. And I understand that you recently retired?
I did in May of this year.
Okay, congratulations.
Thank you.
So let me ask you a little bit about your involvement in the Kowalski case, okay? How does, and maybe I can just sort of streamline this. When a call is made to the abuse and neglect hotline, is there a track that involves law enforcement?
Yes, generally there.
39.
Yep. Okay. Let me just try to streamline this so we can get to the reason we called you. Once the call is made, the law. If I understand what your testimony would be, the law enforcement angle of this would get assigned from your sergeant to you. Is that right?
Yes, generally my sergeant would assign the cases that came in through DCF to investigators within our unit.
Okay. And then the reason why you decided you wanted to meet with Jack Kowalski would be in pursuant of that investigation. Is that right?
Yes.
Okay. There was a date, and I'll reference to you that it was November 17th, 2016, that you had the opportunity to meet with Jack Kowalski. Is that right?
I don't remember the date specifically, but if that was noted, yes.
Okay. Why did you want to meet with Mr. Kowalski?
Well, at that point, I had been in contact with the Department of Children and Families about the progress of their case, and I was told that.
Okay, I'll lead. Okay. Were you? Well, let me just lead you through there. You met with Jack Kowalski at All Children's Hospital.
I did.
Okay, and you met with him in order to get his understanding of the situation that you were investigating. Is that true?
Yes.
Okay. And just to be clear, when you met with him, you're not affiliated with All Children's. You're meeting with him totally separate as a member of the Sarasota County Sheriff's Department. True?
Correct.
Okay. Where did you meet with him?
At All Children's Hospital, we were given a private room. I believe it was like a family waiting room where we had an opportunity to speak privately.
Okay. How are you attired when you met him?
Fairly the way I would be today, slacks, a blouse. I would be wearing a badge and my gun.
Okay. And how would you introduce yourself to Mr. Kowalski?
I would introduce myself then as Detective Graham with the Sarasota County Sheriff's Office.
Okay. Would you have given him your card?
Of course. If, as a general rule, either before or after, I would supply someone my card.
Okay. Did you tell Mr. Kowalski that his interview with you was completely voluntary?
I did.
Okay. And did he agree to sit down and talk with you?
Yes.
Do you remember approximately how long the conversation was?
I don't. I know that it was long. I don't have it was over an hour, well over an hour.
Did you tell him at least twice that he was free to leave the conversation at any time?
I know that later in the conversation, I did tell him and reminded him that I'd already told him this was voluntary, the door was unlocked, he was free to leave if he wanted.
Okay. Did you record the conversation?
I did record the conversation.
Okay. And why do you record conversations?
Recording a conversation during an investigation is the most accurate way to determine what was said during an interview.
You've had a chance to listen to the audio.
Parts of it.
Right. Are you able to tell the jury whether your recorder was by phone, on the table? What's your best recollection of this?
My best recollection that it was likely my iPhone is what we would use, our work-issued phone.
And is that a phone that you would have put on the table, most likely? Do you know?
Probably. Pardon me.
Okay. Let me ask you about some of the conversation that you had with Mr. Kowalski. When you met with Mr. Kowalski, did he talk to you about any meetings that he had at the hospital regarding his consent for treatment there?
Yes, he did describe a conversation that had taken place where he had expressed his consent for the child to be treated.
Okay. Your Honor, I'd like to publish to the jury what's been previously marked into identification as Defense Exhibit 3121A.
Yes.
I mean, when we were in the meeting with the doctors one day, and the other one take my out, sign her out, and I said, hold on, time out. And this wasn't in the, wasn't written down, which I was kind of mad about, but I asked the doctors, I said, what's the time frame you're talking about? And they explained, I said, that's doable. And was my wife happy with me, what I said? No, absolutely not. So you have to, there's times I'm going to go the other way.
Okay. And thanks for sharing that.
I don't know why they didn't write that down.
Was this a theme of your conversation with Mr. Kowalski where he was expressing to you that he was supportive of having Maya treated at All Children's?
Yes, that did come up.
We're beyond that. Reading on this stuff.
On that question, I'm going to sustain the.
Do you recall during your conversations with Mr. Kowalski whether he made other statements to you regarding his either consent or lack of consent at keeping Maya at All Children's?
That's my recollection, but I might need to.
Just be answered. Overall, you can answer that.
That's my recollection, but I would probably need to refer to the transcript to know specifically what those statements were when they occurred in the conversation.
Okay. Your Honor, I'd like to publish into evidence, publish to the jury what's been previously marked as 3121B.
You may.
My favorite question is, why would a parent go to these extremes?
Because I'm told this is the last resort.
But you're saying it's not. And this is not, also what it taken was a question from you somewhere along the line that are we doing the right thing? Maybe we should go back and talk to another doctor, do something more conventional, not something that's likely to kill her.
I'm effective of keeping her here. That's what I told you. And if they think something else, I'm supportive of keeping her here in London.
Detective Graham, having heard that audio, does that refresh your recollection as to the conversation that you were having with Mr. Kowalski?
Yes, it does.
Was there a time during the conversation that you had with Mr. Kowalski where he indicated to you any concerns with Mrs. Kowalski's behavior?
Yes.
Okay, and what types of concerns was he expressing to you?
She wasn't being cooperative with the things that were being requested. He stated he was appalled by some of her behavior.
Your Honor, I'd like to publish to the jury what's in evidence as 3121C.
You may.
But it's just your wife's behavior is very concerning to me.
Sure. And it's getting worse right now. Just, she don't want to cooperate.
Along those lines, Detective Graham, did Mr. Kowalski discuss with you during this time that any concerns he had with Mrs. Kowalski following the rules?
He had expressed there had been some interference on her part with him trying to communicate with Maya, yes.
Your Honor, I would like to publish to the jury what's been received into evidence as 3121D.
Yes.
And I'm not.
Because I know Mom talked to her once, and that was supervised. And I guess she got shut down many times because she was falling off.
She could.
And then she told me what she said. I said, you can't do that. Don't talk about medical stuff. Why are you talking about the lawyer? Why are you...
Why can't she control her? If her daughter is her main priority and why can't she follow the rules and do what she's being told?
Exactly.
During your conversation with Mr. Kowalski, do you remember any conversations with him about him noticing any differences in Maya's behavior, whether he was present or Mom was present?
Yes, he expressed that there were times he would be home alone and there would be no complaints of pain or discomfort, and when the mother would come home, the child would immediately be in pain.
Your Honor, I'd like to publish to the jury what's been received into evidence as 3121I.
You may.
When nobody else was in the room but Maya and the staff, she acted completely normal. When Mom would walk in the room, she's insane.
I heard that many times.
There's no other explanation for that.
I noticed it too with myself being home, and then Mom comes home from work.
And all of a sudden she's back.
So
you're at home, your guys are doing well, and playing.
no complaints about things.
No complaints
but
about
then
that.
when Mom gets home,
She's in pain.
During your conversation with Mr. Kowalski, did he express to you any of his intentions in terms of his home living situation with his wife if Maya were to come home?
Yes, he had offered to me that given the opportunity to bring Maya home, that he would be able to move out.
If I could publish to the jury what's been received into evidence as 3121G.
You may.
I thought you were going to answer the question if Maya was released from here and she was going to be brought back home, if I would have had my wife move out.
That's my next question.
That would be absolutely not our feet.
One moment. Thank you. I don't have any other questions this time around.
I do have questions. There is a there is a technique that and were you a detective at this time?
I said I was, yes.
And how long after that were you a detective before you moved to another position?
I became a member of the civil unit, I believe, in November of 2017.
So what, about a month after this?
No, November of 2017.
About a year after this?
Yes.
You were no longer a detective?
No, I had chosen to leave that unit.
But at this point, you were a detective. Now, there's a technique that detectives use when they're trying to get a confession or something out of someone, and that's called flipping the accomplice. Is that not true?
I would assume so, yes. I've not heard that term referred to.
What do you refer to it as?
As doing an interview.
Well, it's a little more than an interview, is it not?
I'm not sure I understand your question.
Is it not for the purpose of getting one person that you perceive as part of the crime to testify against the other.
That can be, yes.
Right. And to do that, what you do usually is use threats of prosecution of the person you want to talk, right?
That could be possible, yes.
All right. So now, for instance, like here, like threatening Jack to let him know that you had put a father away for 10 years before, right?
I told him that, but I think that was out of context. It wasn't meant to be in that, the way you're referring to it as.
Just how far out of context can it be to tell someone in Jack Kowalski's position, with you there in that room with a badge and a gun, that you had put somebody else away for 10 years impliedly for this?
My recollection of explaining that circumstance to him was that the parents thought they were doing the correct thing at the time they committed the crime and loved their child and had the outcome was not necessarily what they intended, but that there was a punishment for that. That is my recollection of the reasoning why I brought that case up.
You were reminding him that even though he loved this child, he was doing the right thing, he might in fact end up spending 10 years behind bars. That was the purpose?
I was explaining to him that even a loving parent thinking they're doing the right thing, not knowing what the end result could be punished for their actions, yes.
I noticed that you used a couple times the phrase, the opportunity to, as in the opportunity to meet. Do you recall that? Your testimony right here in front of the jury just a couple minutes ago.
If you're saying that's what I said, I don't remember using those exact words, but right, if you're saying, that's fine.
They're taking notes. And also the opportunity to speak privately, right?
Yes.
Okay. But that's not exactly the way it went down, is it?
Is that a question?
Okay. That wasn't the way it went down, was it?
I asked if we could speak privately. We were given a private room to sit down and speak.
You were given a private room because the hospital knew you were coming, obviously, right?
Your Honor, just to briefly approach on this issue.
Thank you, Judge. So, you had discussed coming over there before with Sally Smith, had you not?
I don't recall talking to Sally. I don't recall talking to Sally Smith specifically about coming to the hospital.
Was she or was she not the main source of your information about this?
Your Honor, I'm okay if he wants to go there, but it's...
That question you can ask, but
Dr. Sally Smith was the main source for the medical information I was receiving. The custody and DCF side and family court side was through the Department of Children and Family and supervised visitation.
Right. So now, relying heavily on Sally Smith's information, you went to the hospital, and who did you meet there?
Just to clarify, the information I received from DCF and Sally Smith was why I went to the hospital. I probably had contacted someone with the hospital to facilitate getting us a room where we could speak privately.
Okay. And then Kathy Beatty met you at some point from the time you came into the lobby to the time you got on the elevator to go up to the PICU, correct?
That's my recollection, is that she's the one who facilitated getting the room.
All right. So you and Miss Beatty rode up in the elevator, right?
I would assume so, yeah.
Yeah. And were you in uniform at that time? No, you were plain clothes.
Plain clothes.
But you did have your badge displayed?
I did.
And you had a gun?
Likely,
displayed.
yes.
What kind of gun? A Glock? What was it?
6-hour.
A 6-hour. Okay. And so when the doors opened, were Jack and Maya standing there?
I don't specifically recall that.
Mm-hmm. And in fact, the first time then, whether they were standing right there or close there too, the first time that they saw you would be with Miss Beatty, correct?
That's possible.
Mm-hmm. All right. And you got some information about this situation from Miss Beatty too. Isn't that true?
I had been in contact with Ms. Beatty as facilitating some information about.
And you've worked with Ms. Smith, Sally Smith, Dr. Smith, excuse me, previous. Right, with Miss Beatty. when we left off, you were getting off the elevator with Miss Beatty, were you not?
That sounds reasonable, yes.
Yeah. And then the hospital or someone provided a room for you. Is that right?
Yes.
And you sat down on one side of a table, a relatively small table, was it not?
I don't recall, but there was a table, yes.
Like it wasn't a gigantic conference room table.
No. My recollection is like a small family waiting room.
Okay, small family waiting.
Or not small, but.
And were you positioned such that Jack went in first and then you sat down between Mr. Kowalski and the door?
I don't recall where I sat specifically.
Okay. Then you had a badge and a gun sitting with Mr. Kowalski in a visitor room, right?
Yes.
And you told him you were going to ask him some questions, did you not?
I asked if we could talk, yes.
And one thing you did not say at the start was, oh, and I'm going to be recording you.
No, I did not.
And in fact, your phone that you recorded it on was on your purse, kind of half in and half out of your purse sitting next to you?
Generally, if I've done hundreds of recorded interviews. It is either on the table, and sometimes, yes, it might be in my bag. That specific day, based on the recording's clarity, I had reason to believe that it was on the table.
Okay. And so Jack Kowalski, for the most of this conversation, did not know you were recording him.
He didn't. The recording states that there was some conversation prior to the recording starting. I don't recall telling him, but there is no right to privacy when you're talking to the police. I can record conversations as part of any criminal investigation.
Well, you knew he was represented by counsel, did you not?
I was not aware he was represented in any criminal matter.
Well, you knew he was being represented in the matter involving his daughter there at Johns Hopkins. Did you not?
He talked about being represented. We actually discussed his attorney. He never specified that he wanted to speak to his attorney, but that was the attorney representing him in family court.
Did you ever then tell him he had the right to counsel at that point?
I'm not required to.
See, because you don't believe you had him in custody yet?
I know I did not have him in custody.
And at that point, you hadn't even found a reasonable suspicion. Is that right?
I had a DCF report. I had a medical staff with child protection team voicing concerns about the health and well-being of this child, with the concerns focused on the mother and her inappropriate behavior. And yes, I did have a reasonable suspicion to go and speak to him to find out what his opinion or basis was in this matter. That's what an investigation entails.
Well, would it be true that you at this point were not comfortable saying there's hang on one second. One moment, Judge. I need to find this. I'm going to need to come back to that. Are you saying then that a reasonable citizen, under these circumstances, with a detective, with a gun and a badge, sitting across from him, that he wouldn't feel just a little bit intimidated?
Sustain.
And in asking your questions, you used what we term leading questions, did you not?
I did ask him some leading questions, but he was very forthcoming with offering his own information that I did not ask for.
And your voice that we heard here was fairly aggressive about challenging him, is that right?
There was probably a point later in the conversation where I started to pressure him a little more as far as why this was occurring. I was questioning as far as why wasn't he asking more questions? Yes.
The point was, for virtually every single one of those recordings, you suggested or told him the answer to the question you wanted.
That is incorrect.
True?
I would disagree.
Did you not bring up in every one of those, isn't it true that, or why didn't you do this?
You would have to refer to the entire recording, but that is not my recollection.
And so then, having done this, did you really expect Jack Kowalski to disagree with you?
During the interview, I told him right at the beginning, if he was not comfortable answering a question, he didn't have to. I explained to him that if I spoke anything incorrect, that he should correct me, and he did, and I thanked him for that. It was not a conversation that I was, just giving him question after question. We were having a conversation. I thanked him for sharing information with me. I explained to him that, my position, and then he would explain back what his position was.
Mm-hmm. And you did this, of course, before you went on record in the recording, did you not?
That would not be true.
You did not put it in the first part of the recording, did you?
The first part of the recording was maybe a few minutes. I went to double check to make sure. I'm sure there's nothing worse than doing an entire recorded interview and finding out your recorder didn't work or wasn't activated. So that...
Go ahead, sorry.
I'm sorry, but I refer later into the interview that I had told him he was there voluntarily, the door was unlocked, he was free to leave. That was expressed because I had told him that prior to the recording beginning.
So he just stayed there because he wanted to?
I've done hundreds of interviews of all different types of parties, and cooperation is not unusual.
And in this, by a husband against a wife, that's been your experience?
I worked child abuse investigations for 5.5 years, and parents are always involved in these investigations.
Well, this is a little different investigation, was it not? This wasn't one where Maya Kowalski had bruises on her, was it?
No, this was a very complicated investigation.
And at that point, you had no evidence that Beata Kowalski had any psychological or psychiatric problems.
Mr. Anderson, why don't you all come forward?
And look, I need to approach him one more. Maya Kowalski.
As a general rule, we do not interview the child. That is for the child protection team to do.
And you never met Beata Kowalski?
I did not.
Witness.
For the jury's benefit, can you tell them whether you told Mr. Kowalski whether he was free to leave at any time?
I did.
Did you actually remind Mr. Kowalski that you were out of your jurisdiction?
Several times, yes.
And what does that mean to the jury when you're out of your jurisdiction?
I only have arrest powers within the jurisdiction of Sarasota County, and he was a fireman. They also deal with jurisdiction, so I think he probably understood that meaning.
You were asking questions about whether you were leading him into answers. The jury heard one of the clips about Mr. Kowalski having his wife move out. Was that something that you asked, or did he volunteer that to you?
He volunteered that, amongst other information, yes.
At the end of the interview, do you recall if Mr. Kowalski actually gave you his cell phone number?
He did, and he also offered to let me come to his home if I wanted to talk to him further.
Mr. Anderson.
And if you decided to arrest, first, do you think Jack Kowalski understood exactly where your ability to arrest or not arrest was?
Speculation.
I told him I was out of my jurisdiction, and I believe I told him he was not under arrest.
That is not exactly my question. My question is, he would not know, unless he was a police officer or in law enforcement, where you could arrest or where you could not arrest. True?
Actually, speculation.
She's staying on that one. She doesn't have to answer that.
And if Jack Kowalski was not there, something happened to him, and Beata Kowalski, something happened to her, the child would then go into what?
That's not...
Sustained. Sustained.
Nothing?
Further, Mr.
No, thank you, Your Honor.
Members of the jury, are there any questions? Have you go to jury deliberation. Do not discuss this case amongst yourselves. Do not do any investigation. And receive no information.
Rise, jury.
Jury's out of our presence. Detective Graham, if I could have you wait outside, please. The witnesses out of the room. Obviously, the jury's also out of the room. So the plaintiff had on red number 1, an objection as to the first question.
Yes, Your Honor. Yeah, I do agree. The court can probably give an instruction.
I need it on.
I had forgotten one question. I don't think anybody would object, because I'm not ready.
While you're away, you did not discuss this case amongst yourselves. You did no investigation. You did not receive any information about this case. Is that correct?
That's correct.
And have anyone approached you about this case since you were gone? And have you seen any media coverage?
No.
And this witness was out of our presence when I spoke with the lawyers. And so, ma'am, I've got some questions from the jury for you. And just as a reminder, you will have all of what's actually in evidence with you, but you won't have what is not in evidence. Did you show Jack that you were carrying a gun?
It would be normal for me to be wearing my badge and my gun on a daily basis when I'm at work. Yes.
The next part of that question, was he aware you had your gun with you?
It would have been holstered on my hip as part of my uniform that I wear every day during every investigation.
Do you remember if you gave Jack your business card before or after you met with him?
At the very beginning of the conversation, he requested my card and I offered it to him, and that was recorded.
When you say this conversation was voluntary, did you tell Jack there would be consequences if he did not speak to you?
No, I would not tell someone that. He was under no obligation whatsoever to talk to me.
If you were out of your jurisdiction, why were you interviewing him?
Because we were contacted by the DCF office in Sarasota County, and the family lived within Sarasota County jurisdiction, and that's why I was instructed and got involved. It would not be unusual for me to go to All Children's Hospital if the child was transported there and something had occurred in Sarasota County.
Did Jack inform you of his service? I assume that means of his fire department service.
He told me he was retired. I don't recall exactly retired from what, but he made a comment that he was a medic.
Did he demonstrate from that service that he possessed a knowledge of his rights as they pertain to your interview and his lack of requirement to participate?
There was no discussion about that.
I'm sorry.
I just want to say he appeared willing to converse with me.
Did he mention his legal counsel?
He mentioned hiring Deborah Salisbury, and that would have been part of the family court process, which is a separate process from my criminal investigation.
In your experiences, do leaders of, quote, police parallel services, end quote, paramedics/firefighters usually have more or less knowledge of their civic rights than average citizens?
I would not have an answer to that.
Did Jack demonstrate any non-verbal behaviors that made you feel the discussion was not wanted?
No.
Were you there to, quote, get to
to an anticipated conclusion, end quote, or quote, to seek the truth, end quote?
Can I expound on that answer?
I think you should answer the question that was actually asked.
Could you repeat the question?
Were you there to, quote, get to an anticipated conclusion, end quote, or, quote, to seek the truth, end quote?
I was conducting an investigation to get to the truth and matter of the fact.
Did you inform Jack the reason for the interview?
I don't recall the exact verbiage, but I would have expressed there were some concerns. We'd received reports from Department of Children and Family, and I was following up those reports.
You said it was probably your iPhone that you recorded your interrogation of Jack. Where was your phone during the interrogation?
Like I said during my first the initial testimony, because of the clarity, it very well, I mean, it sounded clear. It was on the table. Obviously, I sounded louder in it. It might have been sitting next to me. But I don't have, right at this moment, that was many, many years ago, I don't have a clear recollection. Would not be unusual for that to happen.
Was Jack given the notice the meeting was being recorded or to refuse the recording of the interrogation?
Well, it wasn't an interrogation, it was an interview. And no, there's no right to privacy when you're talking to the police, whether that's in the back of a patrol car, in a hospital, at their house. It would be common for me to record an investigatory interview.
In a yes/no, does the recording of the interrogation have a recorded opening with names, date, location, and consent to record?
It did not.
If not, then is it your usual modus operandi to record interrogations without the knowledge of the interviewee?
It would not be unusual to do that, no.
And members of the jury, those are the questions I'm going to be able to ask, and I cannot ask the other questions. Defense, is there any follow-up?
Just one. Detective Graham, why do you make the recording?
It is the most accurate account of what is being said for both myself and for the person I'm interviewing.
Thank you.
Any further follow-up?
On the passage. Now I gotta put this.
Did you tell Jack Kowalski that you don't care, that you would put he and his wife in jail tomorrow if it means Maya gets better?
If you're saying that's what the quote is, then yes.
And did you remind him of what good it would do to Maya or Kyle if both their parents were put in jail?
Objection. Argumentative.
Overruled.
Could you repeat the question, please?
Did you tell them or ask Jack what good it would do if Maya or Kyle or if both their parents were put in jail?
I'd have to look at the, if you're telling me that was the transcript, but I'd have to see the transcript itself. Yes.
You may approach.
Yes, this was at the very end of the conversation. I see where the quote is. Yes.
And so, what did you tell him?
Do you want me to read the blue highlighted area?
You don't have to read it, but let me just ask you again. You were telling Jack Kowalski, you were giving him an opportunity because, and you ask him again, what good does it do if Maya or Kyle have both their parents put in jail?
That was what was said in the transcript. I forget what was the question. If you could go back.
And you answered.
I did. Okay.
Anything further?
Yes, briefly, Ron. Mr. Anderson showed you a page from what looks to be page 168 of the transcript.
Yes.
That conversation that he's referring to came after all of the statements that you and Jack had that we published to this jury, correct?
Yes, I recall this was at the very end, and that I was expressing to him, because he had expressed to me during this conversation that he was protective, he was encouraging, he was being the protective parent. And I was just expressing it doesn't do any good for both parents to be in jail. It doesn't do any good.
Well, let's explore that really briefly since you brought it up. Were those comments made as encouragement to Mr. Kowalski to be protective of Maya?
Yes, because that is what he had conveyed to me during the course of our entire interview.
And
that he would do anything, and even said he would go to jail tomorrow if he was responsible.
Right, and the comment you made was not about your desire to separate them. It was Mr. Kowalski telling you he's protective and that he wanted to have Maya home.
Yes, that was his ultimate goal, was Maya.
At no time in your interview did you ever threaten to arrest him, did you?
No.
Okay.
Overall, can you answer that?
You can answer that.
No, in fact, at some point during the conversation, I think I said, you're not under arrest.
And you reiterated to Mr. Kowalski at least twice during the interview that he was not under arrest and he was free to leave. Is that
Yes.
fair? Thank you.
So you think it's encouraging to say, frankly, I don't care, I'll put you and your wife in jail tomorrow if it meant Maya gets better? That was encouraging to him. Is that right?
I was stating that my ultimate focus is the safety and well-being of the child. That is my goal as an investigator. And if that meant that I had to take action to protect the child from her parents, that is exactly what I would do.
Or it meant to let him know that if he had anything to add, he better add it right now, or you would consider taking him to jail, right?
I would disagree.
And didn't he say throughout he did not believe that Beata would ever harm her children?
I believe he said that he believed she would take the child back to get more dangerous treatments that we were trying to protect the child from.
That's not my question, ma'am.
Well, that told me that he believed that she might.
Ma'am, answer the question he asked and only the question he asked.
Yes, sir. Okay, could you repeat the question, please?
Didn't he tell you at least twice that he did not believe Beata would do anything to harm their children?
Yes.
Nothing further.
Members of the jury. Seeing none, you may this witness speak. Oh. Okay, members of the jury,
Yeah, let me try to do it real quick. And the question is, did you talk to him, being Jack Kowalski, again over the next few months?
No.
Members of the jury, that's the only question of this second round of questions that you submitted that I'm able to ask. So, is there any fault based on that one question?
No, Your Honor.
Okay, and may she be excused?
Yeah. Yes, sir.
Mr. Anderson?
Yes, Your Honor.
Okay. Ma'am, thank you very much. Members of the jury, given the time, I think it's a good time for us to break for lunch. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information about this case. We'll see you after lunch. But let's have them back ready to go at 1:30.
Jury exit.
Give me a sec. Just hand it back to her. Okay. Jury's out of our presence. Are there any issues we need to address before we go?
No, Your Honor.
Is 1:15 a time that everyone should be back?
Yes, Your Honor.
Can we ask what the afternoon lineup is?
Yeah, we're calling Ms. Masika at 1:30 for about 10 minutes, hopefully, and then it's depositions.
All right, well, we'll request a proffer of Ms. Masika's testimony.
So have
We
her
can do
here.
that at 1:15.
Have her here at 1:15.
Oh, okay, I'll tell them.
Yeah, so we can do the proffer while before the jury's supposed to be back.
Okay.
Okay, I'll see everybody back at 1:15.
All rise, goes to recess. Johnson, Young, Long, Carroll presiding.
Okay, please be seated, everybody. Everyone's back from lunch, and I heard there was a proffer in our works.
I did, yes, before.
I've got a Lindsay Masika and Cheryl Westmoreland on Zoom right this second.
The attorney is That's her, that's the secretary. Lindsay was seeking extension.
Do I need to put them in the waiting room first, or?
Well, we can do the proffer quick, but then before we actually do the testimony, we want to play a snippet of Mr. Kowalski's citation.
Are we doing a proffer now, and do I need Lindsay Masika here, or do I need to put her in the?
We can do the proffer then.
Lindsay Masika and Attorney Westmoreland, if you could. And Attorney Westmoreland, let's turn on your Zoom. Thank you.
Your Honor, my name is Ashley Deanne Fields. I'm an attorney with DCF. Miss Westmoreland is under the weather today, so I'm subbing in for her.
Okay. Yeah, can you tell me your name again?
Deanne, DEANNE, Fields, FIELDS.
And
I'm also an attorney for DCF.
And Miss Fields, is Deanne, is the A capital or is it just lowercase a?
It's just lowercase a.
And did I do that properly? If you look, did I get it properly?
That's correct.
Okay.
That was impressive. Changed her name. I'm sorry.
This, and just so the transcript's clear, this is a proffer. Ms. Masika, are you currently in the state of Florida?
Yes, sir.
Please raise your right hand to be sworn as a witness. Do you solemnly swear or affirm the testimony you give is the truth?
I do.
Thank you. Please lower your hand. Miss, or who's starting the proffer?
Can I just explain to Ms. Masika, because I didn't,
Sure.
about what they're, so Ms. Masika, the jury is not in the room, but we're just going to do a proffer of what your testimony is going to be. And then when the jury comes in, I'm going to have to ask you the same questions again. Okay?
Okay.
All right. Okay, so I'm going to skip background. But Ms. Masika, back in October of 2016, you were working as a CPI supervisor, correct?
Correct.
All right. And you had some involvement in the Kowalski matter, correct?
Correct.
Okay. Was it the situation, or do you recall the situation where Maya Kowalski was sheltered at Johns Hopkins All Children's Hospital at that time?
I do.
At the time, since Maya Kowalski was sheltered, was it required that any visitors, before they could visit Maya, have a background check run by DCF?
That is correct.
Okay. In addition to being involved in background checks, do you also recall a situation where Mr. Kowalski was visiting Maya in October, get the date here, October 24th of 2016, and you were requested to advise on what items could or could not be brought into the room?
I do.
Okay. And was that in your role as a supervisor for DCF?
Yes.
And did you specifically not allow in the razors?
That is correct.
And did you specifically not allow in the communion?
That is correct.
And was it your comment to, was it your concern with regard to the communion and your comment, therefore, that there was a concern there could be liquid ketamine on the communion?
That is correct.
At one point in time, was there an attempt or interest in transferring Maya to a medical foster home?
There was.
Okay. Can you explain what a medical foster home is?
Yes, that is a placement for a child to go where there is higher level of training in the medical field to be placed after a child is taken out of custody of their parents.
Okay. And is it your understanding, for whatever reason, that that did not occur?
Yeah, that did not occur.
All right. That would be it, Judge.
Any questions from the plaintiff?
Just very briefly, extremely briefly. Ms. Masika, my name is Nick Whitney. I represent the Kowalski family. I have a couple of emails of yours from October 24th and November 29th, 2016. Do you have emails with you this afternoon?
I had some things forwarded over to me, but not everything from the case prior of the deposition.
So let me ask you just specifically about these emails. I have an email from October 24th, 2016 from yourself to Cynthia Zangari, CC, and Kathy Beatty. Do you have access to that email as you sit there today?
No, I do not.
And secondly, I have an email here from yourself to Kathy Beatty from November 29th, 2016 at 10:59 p.m. Do you have access to that email as you sit there today?
No, I do not.
Thank you. Thank you.
You're welcome.
Okay, Ms. Masika, what I'm going to do is I'm going to place you into the waiting room. I'm going to let Attorney Fields remain, but I'm going to put you out of our presence, okay?
Okay.
The transcript should reflect that Ms. Masika is out of our presence.
So, Your Honor, I have two issues. First is my questions are directed that I want to refresh the witness's recollection, but without access to her emails, I'm left not able to do so. So on that basis, we'd like to either give some time to get these emails over to her or postpone her testimony to another day.
Well, Judge, I'm sorry.
Go ahead.
Well, can I hear the...
And then secondly, I don't have a problem with the questions regarding the razors or the communion wafers. I do think the questions about transfer to medical foster care and that not occurring wades into the Chapter 39 issues in this case.
On the second aspect, the medical foster home issue.
Well, the reason I bring that up, Judge, is because the accusation against Ms. Beatty in her deposition was that she wanted to just put Maya in a foster care like it was some negative type thing. So I just wanted her to explain what a medical foster home is. It's not like
No, that's
because
that's in Chapter 39. Discussions about medical foster care will be not allowed.
Okay.
Now, were there any other aspects of the proposed testimony?
The substance of the testimony, I don't think is problematic so long as I have an opportunity to refresh a recollection. And that's, I thought the witnesses were provided with a
Can we do that right now outside the presence of the jury?
Well, and Judge, because I think one of the emails he wants to refresh her memory about is about a situation that the court has already ruled is not admissible. So,
okay. Well, the question of refreshing the recollection is a different question of whether the testimony is relevant. So I'm just asking from a, can we just put up on the screen right now those emails and she can read them outside the presence of the jury? And then she'll go first?
Sure.
Okay, so do either Mr. Reyes or is it Cottrell?
Yes, sir.
Have the ability to put those up, and let me bring in the witness.
You need to enable screen share.
I do, huh?
can I see what you're going to show her?
Yeah. That would be.
Try that.
Judge, I think if we show the court what he wants to refresh her memory with, we can have an order on it because I don't think it's appropriate.
Okay, well, bring the pieces of paper up first. And Mr. Whitney, what is the topic or topics that you seek to go into?
That the source of information for Ms. Masika is
Mr. Reyes?
Yes, Your Honor.
I'm hearing feedback, and I think you were the most recent one to sign on, so.
I fixed that before I logged in.
Okay.
You still hear it?
Right this second, I do not.
Yes.
Mr. Whitney?
Yes, Your Honor. I want to, there's another one in front of you there, Your Honor, behind the screen.
Oh.
So with 2123, 610, and 611, it's that the source of information for Ms. Masika's interactions with the hospital was Ms. Beatty. That, having refreshed her recollection, Ms. Beatty characterized phone calls as damaging for the child. And that Ms. Beatty suggested to Lindsay Masika that Beata could not discuss pain or pain medications with her daughter, and to point out that the shelter order retained medical decision-making with the parents. That's the basis of my questions to 610, 611.
Okay, on those questions, don't go to the issue that I've previously said is the issue that's going to be going to the jury. So I don't see how those questions are relevant.
Which issue, Your Honor? I'm sorry.
As to whether there was a delegation. The fact that Ms. Beatty was talking to DCF is besides the point. That was the process for the Chapter 39. So that's not any problem, and I've been pretty consistent with that. So let's move on to your questions with respect to 2123-032.
I thought the issues with the phone calls were related to the intentional infliction claim.
Tell me the specific question you want to ask.
That Ms. Beatty was listening in on the phone calls and characterizing them to Ms. Masika as damaging for the child.
The question of whether she was listening on the phone call is relevant. The characterization damaging to the child is not.
And so
then I would alter my questioning with respect to that 610.
Perhaps we can ask her in proffer whether she has a recollection of whether Ms. Beatty was listening on the phone calls.
Well, Judge, I think it has to be very careful. This is not the same phone call the jury heard. That was November 15th, 2016. And I don't want this to be confused and the jury thinks that this is referring to the November 15th call that we've had so much testimony about. This is a November 29th, 2016 call.
So be very specific as to the date. And then in proffer, we'll ask her, and if she needs to be refreshed as to whether it was that day or not, then we can show this email. But I don't want the substance of the email being discussed as part of an answer.
Understand.
Okay, let's move on to the other exhibit, which is 2123-032.
Yes, Your Honor. Now, this is an email exchange between Lindsay Masika and Kathy Beatty. And my questions are going to center around.
First off, who is Cynthia Zangari?
Great question.
Zangari.
She was the CPI. One of the CPIs was referenced in Ms. Niehaus' testimony earlier.
And you have Ms. Beatty CC'd here on this email. So defense counsel's questions centered around the decision to not allow the razors, but you'll see at the bottom of this email, there's a whole host of things that were being provided.
Oh, I was going to get into what was, I'm sorry if I left that out. I was going to ask her what was provided, what was allowed in, if that's the question.
And so then I was going to ask her a question about who, you can see there in the primary paragraph, who was she deferring to at the hospital to weigh in on these decisions? And she's asking directly Kathy Beatty. So she's seeking input of Kathy Beatty before making any decisions. And then I was going to ask her, based on this, who is Jen? I don't know who Jen is, but there's authorization here from Jen to let the communion wafers in. So I wanted to ask her that question.
Judge, first of all, the email that asked Kathy Beatty is from Cynthia Zangari, not from Lindsay Masika. And then it goes up the chain, and Lindsay Masika is the one, if you have, do you have all the email there? Because Lindsay Masika then is the one that says, no, what if they put ketamine on the communion? And she's the one that decides it can't come in. They're trying to imply that Ms. Beatty had some decision-making about this, and this was DCF all the way.
I mean, it says here, Kathy, are these items okay? I want to ask this question if they were deferring to Kathy Beatty.
That line of questioning, I don't think is appropriate, so no. So we'll bring back in Ms. Masika, and you can ask her in proffer about, was it November 29th question? Whether Kathy Beatty was on that phone call, or whether Kathy Beatty said she was on the phone call, or whatever you're going to ask her. For purposes of the proffer.
Then for purposes of the proffer, outside of these emails, I'd like to ask a line of questions about other items that were taken away from Maya Kowalski and whether she had any involvement.
That's fine, but, you know, those other issues are not going to go into the jury, but if you want to do that within proffer, that's fine. But let's do it now so we don't have the jury waiting, okay? I'm going to bring Ms. Masika back in.
So when we're going to be able to show her this email?
Well, let's see if she needs it first. Hi, Ms. Masika. This is Judge Carroll again. We're going to have a few more questions. The jury is still not in our presence, okay? Mr. Whitney is going to ask you some questions.
Okay.
Hi again.
Hello.
My first question is, do you recall email correspondence between yourself and Catherine Beatty and others on November 29th, 2016 regarding a phone call between Beata and Maya?
I recall having emails between everyone. I just wouldn't be able to say the specific dates without it in front of me.
Would it refresh your recollection if I showed you that email?
Sure.
Judge, I think the ultimate question was going to be asked as opposed to.
We're in proffer. Let's just
Okay.
put up the email and let's move on. Okay, let's put up the 2123-610.
Yeah, I wasn't saying to put it up in front of the jury. Ms. Masika, if you would take a moment and review your email back at the top and then Ms. Beatty's email, at least the first part of it below, and let us know when you're done.
Okay. Okay.
Ms. Masika, was it apparent to you that Ms. Beatty was monitoring the phone calls between Beata and Maya?
Objection to.
Okay, you can answer that.
Yes.
Other questions you might have in proffer.
Ms. Masika, there were certain items that you approved and certain others that you disapproved. Those were discussed with Johns Hopkins counsel a moment ago. For example, you disapproved the razors and ultimately the communion wafers. Do you recall approving things like deodorant, body wash, nail polish remover, nail file, earrings, chapstick?
Yes, I do.
As a general rule, did you allow toiletries and items for Maya's care in the hospital in?
Yeah.
Was there ever a point where you disallowed shampoo?
Not to my recollection, no.
Was there ever a point where you became involved in disallowing a Tommy Hilfiger Christmas dress?
No, sir.
Was there ever a point you became involved in disallowing chocolate cake?
No, sir.
Was there ever a point you became involved that you disallowed rosary beads for Maya Kowalski?
No, sir.
Did you ever disallow a prayer book for Maya Kowalski?
No.
That ends the proffer.
Anything else, Ms. Quarles?
Not the proffer, just some arguments.
Okay, ma'am, I'm going to put you back into the waiting room. We'll call you back in just a couple minutes.
Okay, thank you.
Okay, the transcript should reflect Ms. Masika is out of our presence.
Judge, I'm sorry.
Go ahead.
Judge, despite the court telling counsel that it had to be specific on the time, he's again trying to blur the lines. And he just said, are you aware of Kathy Beatty monitoring the phone calls? It has to be date specific. They're going to try and imply that that's a November 15th call.
No.
I'm confident Mr. Whitney is going to use the specific date when he asks the question.
Well, he didn't on the proffer, that's why.
Well, she had the email in front of her, but I will triple check. I'm circling it. I'm starring it. I will use the date.
Anything else?
No.
Now, on the last bit of questions about the rosary beads and all that, any further statements about?
Well, the point of this testimony from defense counsel's perspective is to shift the blame for items that were kept away from Maya Kowalski to DCF. So we need to be allowed to explore and highlight for the jury that, yes, that may be true of some items, but that's not true for the items that I just went through there with Ms. Masika.
Ms. Gross, that I'm telling you that the questions that Mr. Whitney just asked and that explanation is gaining traction with me. So why shouldn't he, being Mr. Whitney, be able to ask those questions?
I'm not objecting to this.
Okay, you can ask those questions. Thank you. Anything else before we bring the jury in and Ms. Masika?
1 second, Judge.
Your Honor,
Clear your other problems too.
I would like to stop sharing, but it appears that that's not even an option for me. I was able to share the document or share my screen, but now I can't unshare it.
Well, I'll tell you what, let me do this. Did that do it?
Still, I'm gonna exit the meeting and then pop back in.
Well, I'll tell you what, no, hold on a second. Let me just disable your rights to share.
Thank you.
Judge, before.
That fixed it.
I'm sorry.
Okay, so really we don't need to show her any documents.
That's correct.
Okay. Ms. Gross.
Yes, before this witness, we wanted to play a 5-second snippet from Mr. Kowalski's deposition. If it's going to mess up with the setup.
It's going to mess up the setup.
Then we'll just do this, Judge. That's fine.
Yeah, I'm sorry, but.
I understand. That's fine.
Okay. I'm going to just bring in Ms. Masika. I'll tell the jury that I've already put her under oath. Okay, let's bring in the jury, please. And Ms. Masika, I'm bringing in the jury right now. I'm going to tell them that you are under oath.
Okay.
Okay. We'll just take a moment for the jury to come in.
Okay.
Okay, welcome. Everyone, please be seated. So, did you have a good lunch on Friday? I want to confirm while you're away on lunch, you did not discuss this case amongst yourselves. You did no investigation and you received no information. Is that all correct? Correct. And that you did not observe any sort of media accounts about this case. Is that correct? Correct. and that no one approached you about this case. Is that correct?
Correct.
Okay, our next witness is going to be by Zoom. I have already administered the oath to her, so she will be testifying under oath. Ms. Croels, if you could please call your next witness.
Yes, the defense will call Lindsay Masika.
Okay, and you may proceed when ready, Ms. Croels.
Thank you. Good afternoon. Can you hear me?
Hello. Yes, I can. Can you hear me?
Yes. Would you go ahead and state your name for the record, please?
Yes, it's Lindsay Masika.
I've said your name wrong. I'm so sorry. Masika.
That's okay.
Ms. Masika, what is your current employment?
I am a therapist.
Okay. Prior to being a therapist and back in 2016, did you work for DCF as a CPI investigator or CPI supervisor?
Yes, I did.
And what does CPI stand for?
Child Protective Investigator.
Okay. And how long did you work for CPI?
Approximately 6 to 7 years.
Okay. And was that back in 2013 until 2019?
Yes.
Okay. So back in 2016, you were a supervisor for CPI?
Correct.
And that's part of DCF?
Correct.
All right. And at that point in time, did you have some involvement with the Kowalski matter, the Maya Kowalski matter?
I did.
Okay. And with respect to that, you understood back in October of 2016, when you were involved, that Maya Kowalski was sheltered under DCF custody, but remained at Johns Hopkins All Children's Hospital.
That is correct.
Okay. And as a result of Maya being sheltered, was it required by DCF that any visitors had to have background checks be conducted before they could visit Maya?
That is correct.
Okay. And were you involved in communicating with Mr. Kowalski about that?
Yes.
And did you, in fact, did you do the background check, or was that assigned to someone else?
That could have been a combined effort. Once we get the individuals, we submit the request.
Okay. And the individuals names would have to be submitted to you by Mr. Kowalski, correct?
Correct, yes.
And regardless of their position in life, whether they were a teacher, a priest, a baker, whatever they were, they had to be approved and vetted by DCF before they could see Maya, correct?
Come forward just a second, and I'm going to place my microphone on mute to you, Miss. How do you say your last name again?
Masika.
Miss Masika. Okay. Hey, Ms. Masika, I think you need to unmute yourself. Thank you. I'm going to sustain the objection. You don't need to answer that question.
All right, Ms. Masika, do you remember back on October 24th, 2016, around the time being involved in determining what items could be brought into Maya Kowalski's room by her father?
Yes, I do.
Okay. And specifically, was it you that made the decision that the razors could not be brought in?
That is correct.
Okay. Was it also your determination that the communion could not be brought in?
That is correct.
And was that because of your stated concern by you that there might be liquid ketamine on the communion?
That is correct.
Okay. And that's on behalf of DCF, correct? That you made that statement?
Correct.
All right. You did allow some item in though, correct?
Yes.
Okay. Let me just ask you, do you recall that you allowed in the body wash?
Yes.
The earrings, the nail polish remover, a computer lab workbook,
yes.
Nail file? Yes?
Yes.
Sorry.
Yep.
Chapstick and deodorant, correct?
Yes. Yes.
Okay. Thank you, ma'am.
Mr. Whitney is going to have some questions now.
Good afternoon. Ms. Masika, have you had the opportunity to review an email between yourself and Ms. Kathy Beatty from November 29th, 2016?
Yes, just today.
Was Ms. Beatty your point of contact at the hospital?
She was.
Was it apparent to you upon reviewing the email discussing the phone conversation between Beata Kowalski and Maya Kowalski from November 29th, 2016, that Ms. Beatty was monitoring or listening in on the phone calls?
Object to the form, Your Honor.
Overruled, you can answer it.
Yes.
I want to move to those items that you disallowed and that you allowed in your role. To be clear, you excluded from Maya Kowalski the razors, is that right?
That is correct.
And I wanted to clarify on the communion, when communion was discussed, what you excluded were communion wafers, correct?
That is correct.
Generally, and defense counsel just read the list there, you let in things like deodorant, body wash, nail polish remover, chapstick, a nail file. Was it your general policy to allow in items that were for Maya Kowalski's health, well-being, bath needs, etc.?
Yes.
Was there ever a time where you disallowed shampoo for Maya Kowalski?
No.
Was there ever a time that you disallowed chocolate cake for Maya Kowalski?
Oh, my computer froze, sir.
I think we saw that, yes. I'll repeat my question. Was there ever a time that you disallowed chocolate cake?
No.
Was there ever a time that you became involved in excluding from Maya Kowalski her Tommy Hilfiger Christmas dress?
No.
Did you ever disallow Maya Kowalski to have her prayer book?
No.
Did you ever disallow Maya Kowalski from having her rosary beads?
No.
Thank you, ma'am.
Thank you.
Just briefly, Your Honor.
Yes, ma'am.
First, the phone call that was referenced in the November 29th email was a phone call on November 29th, 2016, correct? That was...
I don't recall. I just read that now.
With respect to outside food, was it also, was DCF also monitoring whether or not outside food could be brought into
Objection.
Maya's room?
Foundation, predicate, speculation.
You can answer that question.
Can you repeat the question for me?
Sure. Was it also a fact that DCF would be monitoring outside food and whether or not outside food could be brought into Maya?
I believe we were monitoring any items that were in and out of the hospital for Maya.
Okay. Your Honor, can we approach briefly?
Yes. Ms. Masica, can you still hear us?
Yes, can you hear me?
Yes, I'm going to give an instruction to the jury. Members of the jury, the parties have agreed that the telephone call being referenced just now occurred on November 29th, 2016. Anything further, Ms. Crowells?
No, Your Honor.
Anything further, Mr. Whitney?
Not this time.
Now, don't go anywhere, Ms. Masica, because the jury might have questions. So just give me a second. And yes, there's going to be jury questions. So. I'm going to put you back on mute, ma'am. You will not be able to hear us.
Okay.
Okay, Ms. Masica, I've got a series of questions from the jury. I'm able to ask all of them but one.
Okay.
Why did you let computer workbook in when you did not let her have her laptop?
I don't recall there being a specific reason between one or the other.
Next question. Was the communion wine or crackers in a sealed package?
That I don't recall.
Next question. Did anyone ever test the outside food for ketamine if they were worried that ketamine was being placed in those items?
Not that I'm aware of.
Okay. Ms. Crowells, anything in follow-up from the jurors' questions?
No, Your Honor.
Mr. Whitney.
Yes, Your Honor. Ms. Masica, please correct me if I'm wrong. Are you in Sarasota as you sit there?
No, I'm in Bradenton.
Bradenton. And is that where your office was in 2016?
No, my office was in Sarasota or Arcadia or Northport.
And at the time of Maya Kowalski's sheltering, did you go to Johns Hopkins All Children's Hospital on any occasion?
No, I did not.
And is that the reason you don't have knowledge as to the status of the communion wafers, whether they were sealed or whether food was tested?
That would make sense, yes.
Thank you.
You're welcome.
There's more questions from Ms. Crowells, and I think the jury as well.
No, Your Honor.
Okay.
Wait.
Okay, so looks like I've got a couple more questions coming from the jury, so I'm going to place you back on mute, okay?
Okay.
Was it?
I thought there were 2 sheets.
Nope, just one sheet this time. Ms. Massica, can you hear us again?
Yes.
Great. Did you have an assigned single contact at Johns Hopkins All Children's Hospital?
It wasn't specifically assigned, but I did speak majority with the social worker, Kathy Beatty.
Did more than one Johns Hopkins All Children's Hospital employee contact you, and who were they?
I don't recall. I could have spoken with nurses, but I can't, without seeing, my notes or files from the investigation, be able to clearly answer that.
Thank you. Ms. Crowell, anything further?
Just briefly, Judge.
Ms. Crowell.
So you testified that you didn't get over to the hospital, but do you recall Ms. Nihas was working and at the hospital assisting with supervised visions with Mr. Kowalski?
Yeah, she was employed by the Safe Children's Coalition. She was doing visitations.
Okay. And do you recall that she was the one on that October, it was 26 date when the question came up with regard to the communion and what could be let in and what could not be let out of the room?
That is correct.
Okay. Thank you.
You're welcome.
Nothing further.
Anything else from the jury? Seeing none, may Ms. Massica be released from all subpoenas?
Yes, sir.
Yes, sir.
Okay, thank you very much, ma'am. I'm going to go ahead and turn it off for you. You're free to go. Thank you.
Thank you.
Bye now. Deputy DiMizio, can I have you fix that? Thank you.
Can we approach her?
Sure. Ms. Quarles, the next defense witness, please.
Yeah, thank you, Your Honor. We're going to call by video Jack Kowalski.
Let me do the lights.
Video.
Told Detective Is it your contention that everything you told Detective Graham when you met with her back in November of 2016 was not true?
Everything I said to her was true.
Your Honor, the next witness we're going to call is Dr. Gadi Revivo by video. His deposition was taken on November 8th, 2021.
And members of the jury, my understanding this is a 55-minute ish. And so we'll take a break after that deposition.
Doctor, will you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give today be the truth, the whole truth, and nothing but the truth?
Yes.
Dr. Revivo, can you please state your name and professional address for the record, please?
Yeah, Gadi A. Revivo. I work at Shirley Ryan Ability Lab at 355 East Erie, Chicago, Illinois, 60611.
Just, where you went to college, your degrees, and then where you did your residency, fellowship, things of that nature.
Right. So I went to the University of California, Davis, for an undergraduate degree in exercise physiology. Went to medical school at the Pacific College of Osteopathic Medicine of the Pacific, and then followed by a residency in adult physical medicine and rehabilitation here at the Rehab Institute of Chicago, followed by a one-year fellowship in pediatric rehabilitation medicine, followed by employment at Rady Children's Hospital 2002 to 2008. Upon my return here to Rehab Institute of Chicago, now known as Shirley Ryan Ability Lab, with interests in obviously pediatric rehabilitation medicine and a focus on spasticity management, inpatient, and also chronic pain management.
Talk to me a little bit about your background in pediatrics. I understand you have a fellowship training in rehab physiatry. Is that correct?
The fellowship is specific to pediatrics as it pertains to physiatry.
Okay. Is there a difference between, and I know this is probably a somewhat of a general question, but can you just generally outline what why we have a pediatric fellowship training track for those who are going to be dealing with pediatric patients?
So, the physical medicine rehab residency is a 4-year program, including your first year, which is internship. Typically, though, that is adult-based with a few months of pediatric exposure. So for those of us that have an interest in pediatric PM&R, you do a fellowship for further focused training.
As part of your training and your practice back in 2015, 2017, did you have the occasion to treat pediatric complex regional pain syndrome, also known as RSD, reflex sympathetic dystrophy?
Yes.
Would you consider yourself an expert in the treatment of complex regional pain syndrome?
Yes.
Okay. Approximately how many cases of pediatric complex regional pain syndrome do you believe you'd handled up until the point you encountered Maya in 2015?
2 a year, 3 a year, by 15, probably 30, 40 cases.
Okay. Would that also include some exposure during fellowship?
Yes.
I think I heard you say during that explanation there that your program is physiatry based and non-injection mediated. Did I hear that correct?
That's correct. Sorry, one last thing. The other big component of the program is the cognitive behavioral strategy. So, of course, using the cognitive strategies to improve on pain management. So biofeedback, mindfulness, pacing techniques, sleep hygiene, looking at the stressors in the social milieu, whether that's in the home or academics.
In terms of the cognitive side that you just described, is that the same as the term cognitive behavioral therapy?
That's correct.
Since there's been an objection, can you just label what the 3 standard general modalities are employed at Rehab Institute of Chicago back in 2015 and 2017 for the treatment of pediatric CRPS?
Cognitive behavioral therapy, occupational therapy, physical therapy.
Fair enough. And I think you said that there are times where you have involved anesthesia to engage in blocks. Did I hear that correctly?
That's correct.
Okay. And what do you mean when you say a block?
Well, so a couple of my partners there at Lurie's, and again, we're not partners in the sense that we're employed by the same institution, but we work on a lot of the same patients. Mm-hmm. So I'll send these patients if we're not making headway in reducing allodynia or hyperalgesia. So typically I will send them to the pediatric pain anesthesiologist to determine whether or not, a centrally mediated block to change the sympathetic overflow in the patient's body, or potentially a specific nerve, either nerve root level or peripheral nerve, that will desensitize basically or anesthetize the lower extremity. That will then allow my PT and OT group to promote the strategies used to improve on the patient's function.
Approximately how many times have you involved anesthesiology in the treatment of a pediatric CRPS patient at the Rehab Institute of Chicago?
In that time period?
Ever?
Yeah. Maybe directly handful of times, 5, 6.
In those handful of times, do you ever recall any of those anesthesiologists using ketamine to treat complex regional pain syndrome in a pediatric patient?
No.
So I think it's fair to say, doctor, that within pediatric circles, you do not consider ketamine to be a standard of care medication for the treatment of pediatric CRPS?
Correct.
Okay, and why is it that you have that opinion?
Hasn't borne or proven its efficacy. I'll leave that to the anesthesiologist to utilize based on their clinical acumen and whether or not that makes sense in their domain of treatment.
Did I hear you correctly that you do not refer patients to providers that use ketamine to treat pediatric CRPS?
No, I did not say that. What the anesthesiologist that I work with at Lurie's, that's not in their treatment armamentarium. We've never had that conversation. So
okay, fair. I guess the better way to ask the question is, to your knowledge, the anesthesiologist that you work with in terms of pediatric CRPS, to your knowledge, they don't use ketamine to treat pediatric CRPS?
That's correct.
Okay. Why don't you tell me a little bit about the Shirley Ryan Ability Lab, that was formerly known as Rehab Institute of Chicago? What type of services do you guys offer? Why does the organization exist? That type of thing.
So we're a freestanding rehabilitation hospital that provides service to pediatric patients, to adult patients. We have service lines of care, including inpatient rehabilitation, where patients are admitted typically from another institution, typically acute care. We have a day rehabilitation model where patients are well enough to be in their home setting, but need an intense level of therapeutic milieu. So they may receive some combination of PT, OT, and speech therapy. We also have a large outpatient clientele. So in my specific line of work, I see obviously children with cerebral palsy, spina bifida, traditionally on the outpatient service. We have a large, vibrant inpatient service, primarily made up of kids who've had traumatic injuries, whether it's TBI, spinal cord. And I do see patients in the day rehab milieu as well.
Okay. Did you review anything in preparation for today, doctor?
No.
Did you have an opportunity to review your progress notes that we're attaching as an exhibit?
I did.
Okay. Did you have a chance to review some of the emails that I've attached as exhibit 2 and 3 that we'll talk about a little later?
I did.
Are you familiar with any facilities in the United States that do what's known as a, quote, ketamine coma procedure for the treatment of pediatric CRPS?
No.
Have you ever heard of a Dr. Anthony Kirkpatrick?
No.
Have you ever heard of a Dr. Ashraf Hana?
No.
Are you familiar with any publications by Dr. Anthony Kirkpatrick and or Dr. Ashraf Hana in the field of the treatment of pediatric CRPS?
No.
Have you ever heard of a pediatric patient receiving up to 23 milligrams per kilograms per hour of ketamine for the treatment of pediatric CRPS?
No.
I guess my first question for you is, do you recognize what Exhibit 1 is?
Yeah, it would be a consultation that we provided for this patient at Lurie Children's Hospital as they were an inpatient back in 2015.
Okay. And I believe the date of service here was 7/23/15. Is that correct?
Correct.
Is it my understanding that you would have actually personally interacted with Maya Kowalski in preparation of this note?
Correct.
Okay. And Dr. Rojas would have had some involvement as well?
That's correct.
Okay. And so that's Lurie Children's Hospital on July 21, correct?
Correct.
All right. And then it says here in your note, after reviewing records, Maya continues to have low cortisol levels, but a thought not to be related to her symptoms. Do you see that?
I do.
What are you explaining in that portion of your note?
Just the fact that it was reported that she had low cortisol levels.
Okay. Any idea why that was not thought to be related to her symptoms?
No.
Let me ask you this, doctor. Separate and apart from the information in your note or the emails that I sent you, do you have any independent recollection of your interaction with Maya Kowalski or her mother, Beata Kowalski, back in July of 2015?
No.
Well, let's go back with your note here. It says, you see where it says, today Maya is in pain? Do you see that?
Yes.
Okay. And then it says, quote, she describes the pain as constant and involving her entire body, including legs, back, head, and arms. Do you see that?
I do.
Is that the type of pain presentation that you would typically associate with the patient with pediatric complex regional pain syndrome?
No.
And why is that?
For the very nature of the definition, it's complex, but it's regional. So typically we'll see patients who present with a limb, so maybe a foot or leg. I have seen patients that may present with a kind of hemiparesis presentation. So they'll present with a limb and the trunk. But this is a different diagnosis based on what we're saying here, based on my experience.
In your experience in treating pediatric CRPS, have you ever seen a whole body or entire body case of CRPS?
Well, I've seen plenty of patients that come in with whole body pain.
Okay.
The question is that CRPS? So in my, if you want to talk about semantics, complex regional pain syndrome, based on the strict criteria, is a regional component of the body. Someone who comes in with widespread pain, that's not how I would describe the ICD-10 coding.
And when you say regional, you mean you expect maybe to see it in a patient's leg, but not both legs, torso, arm, and head?
Correct. I have seen patients that, again, no patients potentially follow the textbook, and you have to be creative in medicine. And we've seen patients where they'll start with symptoms that may meet the criteria for CRPS in one limb, and now they're starting to have the same symptoms in another limb. But I have a different definition for someone who comes in with, as we've described in this, entire body pain.
Do you see the section there that says prior to admission, age appropriate, independent, current functional status, she is unable to sit up independently. Mom carries her to wheelchair in order to go to bathroom. Do you see that?
That's correct. I see that.
And did you draw any opinions with Maya Kowalski about what type of care she would need?
Clearly, she's not able to sit up independently.
And my understanding is you would have done a physical examination of Maya Kowalski. Is that correct? All right.
Correct.
I note here in your physical examination, it says, quote, she is moaning and crying without tears. She stops moaning to answer questions. Do you see that?
I do.
What is the clinical significance of including those two sentences in a physical examination?
That allows us to create a picture of behavior and presentation.
And what picture of behavior and presentation are you describing here with the entry? She is moaning and crying without tears. she stops moaning to answer questions.
But there's clearly a, behavioral component to her pain. And this is how she's expressing her pain and her grief by presenting in this fashion.
What do you mean by there's a behavioral component to her pain?
So oftentimes patients may not be able to provide, in this instance, we use FACES or the Wong-Baker scale. So how do I determine the degree of pain based on some scale? So if we don't get a number, potentially then we can ascribe severity based on behavior, whether it's movement, whether it's verbal, whether it's facial, whether it's, in this case, moaning, crying.
Why is it clinically significant, if at all, that the patient would stop moaning to answer questions?
Well, it's nice to know that she can stop some of that behavior to get some composure, to be able to participate in the exam.
And then I think it says down at the end here, refuses examination due to pain. Do you see that? Right after normal muscle bulk, it says refuses examination due to pain.
Correct.
What are you describing in that entry?
Well, it looks like when you look through the components and the systems, as we went through the examination, like under sensation, refuses exam and screams with light touch. So patient did not want to participate in that, and we have to honor that during the assessment. If providing some type of sensory input is creating too much pain for the patient, then we stopped at that point during that sensory component of the exam.
Later on down under musculoskeletal range of motion, you see where it says when asked to wiggle toes, she is able to, but breaks of and screams. Do you see that?
I do.
Okay. What are you describing there in that portion of your musculoskeletal note?
We're getting a sense of, does the patient have active ability to move any extremity, body, whether it's axial spine or the extremities themselves, and what kind of power what kind of neurologic function do they have under their own power to move a limb?
And then, it's a similar question, but you see where it says strength, moves UE against gravity, moves LE while in bed, but screams with movement on command. Same question about that passage. What are you describing there?
So the first part of that sentence, moves the upper extremities against gravity. So we can see that she's got intact or at least anti-gravity motor function, right? So if you're ascribing a muscle grade on her own, at least 3/5 in the upper extremities. It was also noted on our assessment then that she was able to move her lower extremities. However, when we asked her to do so, obviously there's screaming involved.
And then mobility dependent for all mobility. I think we discussed that earlier. Is that your recognition that she required assistance with getting around?
Correct.
So we walked through a little bit of your physical examination here, review of systems, et cetera. And then my question was, did you, after your assessment of Maya Kowalski, come up with an impression and recommendation for steps moving forward?
Yes.
What were those?
Well, so the impression as written is that this patient has a central sensitization process that exacerbates her pain and pain amplification with behaviors. The fellow had written a decline in function attributed to conversion disorder. She has signs of pain, catastrophizing, anxiety, kinesiophobia. So again, going back to the physical, that's the behavior seen. We know that mood and anxiety are a component of pain and pain management. And then kinesiophobia, so fear of movement because movement causes pain. We determined that she would benefit from physical and occupational therapy, the psychological components, desensitization, and again, cognitive behavioral therapy. So basically said, look, we've been asked and tasked to consult on this patient and are recommending that, a chronic pain program a la ours may help this patient in her functional recovery.
You pointed out the reference to conversion disorder. Do you see that in the impression recommendation?
I do.
What is being described there by use of the term conversion disorder?
So that's an older term and certainly used back. Sorry.
My apologies. Go ahead, Doc.
So that's a term that is a little more antiquated in DSM-5 and clearly moved to something we attribute to or describe, as functional neurologic disorder or functional symptom, FNSD, so functional neurologic symptom disorder. But it's basically a collection of disorders that have a basis in organic, pain pathology with significant overlay of anxiety, mood, and psychiatric. So and the old term of conversion is what is converting? Is that you're getting a psychiatric mediated etiology to and a milieu with organic pathology. So we don't use that term anymore. And granted, we've become more eloquent in our description of patients. And frankly, what I think is interesting here is, again, this patient presents with whole body pain, which really is more akin to an accurate diagnosis of what we call central sensitization. So knowing that the central nervous system, i.e. vis-a-vis, the brain, the prefrontal, frontal cortices, the amygdala, the brainstem, not only govern, but they manipulate inputs coming from the peripheral nervous system. And basically you're getting the sensitization or neurosignature of pain. We treat patients from a cognitive behavioral standpoint. Many patients that now come in, and if you look at the literature from Kozlowska, might even say that patients who have fibromyalgia, CRPS, patients that have hypermobile spectrum disorder, all have some functional component. Again, that doesn't mean this is psychiatric and factitious, because that's a different whole ball of wax. Are you talking about malingering? Are you talking about Munchausen's? We're not doing that today. I think the issue that we describe in a lot of the patients that we treat is that there is this process of central sensitization that over time, with the exposure of chronic pain, the brain is changing that neurosignature it's receiving from the peripheral nervous system and actually beginning to modulate it. So a patient like this that presents with, diffuse pain that she clearly had hyperalgesia, she clearly had allodynia to light touch, is more akin to central sensitization. And you asked me earlier, why isn't this CRPS? And well, couldn't a patient who has whole body pain be CRPS? And absolutely, we've seen patients that have had more than one limb, and that isn't following the textbook. But my experience is pain patients don't follow the textbook. But it's just a continuum of the process, whether the pain is peripheral, right? And it's coming from one, peripheral nerve through the nervous system, getting regulated through the autonomic nervous system. And now you have this upregulation of a signature, a la central sensitization. And so it's just the eloquence in which you use the terminology. So we've moved away from conversion disorder. We don't describe it that way. We talk about functional neurologic disorders. These patients present with motor dysfunction. In this case, this patient, may have difficulty walking or needs total dependence in mobility, although you can see that based on components in the exam, she demonstrates the ability to actively move an upper and lower extremity. We know that patients may present with other pseudo seizures. I've seen patients who've had altered speech. Those are all functional in origin. And the confluence of organic pathology with psychologic components of stressors, anxiety, mood, alteration, etc.
It sounds like we've moved away from using the term conversion disorder in the most recent DSM-5. What about back in 2015, 2016? Was that term being used?
Yes.
Are you critical of anybody in this time frame, 2015, 2016, who uses the term conversion in their medical charting?
No.
And so we talked about your impression and recommendation here in some detail. And I think you said that your recommendation was to do the type of pain program that they could offer at Rehab Institute of Chicago. Did I hear you correctly?
That's correct. That was one of the options. And we also said, obviously, and again, I have no independent recollection of this patient, but clearly she lives out of state. And so, one of the other thoughts was, would she find something that would provide at least the nature of the way we treat our patients with pain, something closer to home in Florida.
And so what, and I know we talked a little bit about the program in general, and some of this may seem repetitious to you, but can you describe the type of program that you were referring Maya Kowalski to in terms of the modalities of treatment that you thought were necessary back in 2015?
So these would be cognitively, behaviorally based. So the core of that is changing the way in which the patient perceives pain, has a relationship with pain, and that's through the cognitive component with the psychologist, using biofeedback skills, mindfulness, using strategies to start to change that conversation around pain, coupled then with the physical and occupational therapy modalities seen fit by the provider to optimize return in function while reducing, pain perception. So we talk about it in this case where she has evidence of pain to light touch, a desensitization process where you're actually trying to change that perception of what inputs are causing centrally that central sensitization process.
Any recommendations for any type of analgesic or pain medication?
Not at this visit.
And I think we talked about it, but your recommendations were for PT, OT, psychology, desensitization, and cognitive behavioral therapy?
Correct.
Okay. At a program such as Rehab Institute of Chicago or a similar facility that could provide that similar panoply of services?
Correct.
Okay. All right. And same question for Jennifer Richards. Who is that?
Yeah, so Jennifer Reichert, she was the clinical manager at our Center for Pain Management during this time period.
Okay. And Ms. Reichert was asking questions about the program at Rehab Institute of Chicago for pediatric CRPS. Have you had a chance to review Ms. Reichert's responses to Beata Kowalski's questions about the program?
Yes.
How do you characterize Ms. Reichert's responses to Ms. Kowalski's questions?
It looks like there were a set of questions that Ms. Kowalski had about, if they're to participate in our program, specifically, what type of service do we offer? And she attempted to go through that process of answering those questions.
Based on your review, did it appear as if Reichert responded to these questions in an accurate fashion?
Yes.
It doesn't appear in the emails, but I did have a question about it. At the Rehab Institute of Chicago, do you have any experience with treating pediatric CRPS with the surgical implantation of an intrathecal clonidine pump?
No.
Do you recognize intrathecal clonidine pumps as a standard of care modality for the treatment of pediatric complex regional pain syndrome?
I don't.
In this time frame, January of 2017, if you were asked what type of meds or vitamins do you use for your CRPS patients, what would your answer have been?
We'll typically trial the gabapentinoids, so gabapentin, Lyrica. There have been trials using high-dose vitamin C. And certainly have a discussion with patients and their tolerance for trialing meds. We'll certainly use tricyclic antidepressants to try to change the neuropathic signature. Potentially go deep into the antiepileptics. But that's probably about as far as we'll go. So really, treatment for me specifically is gabapentin, Lyrica, tricyclics, maybe, trialing some of the antiepileptics. And, certainly there's some debate whether vitamin C makes a difference.
What about ketamine?
No.
And why not?
Look, I don't have experience with it. That's not something that we certainly use, and I've certainly not had any patients that frankly have asked about ketamine. So, if they do, I refer them to the adult colleagues down at Rush.
I've heard a lot throughout this case that the standard of care therapy for pediatric CRPS is PT, OT, and cognitive behavioral therapy. Is that a statement you would agree with or disagree with?
I treat a subset of these patients. I would not sit here today and tell you that I treat every kid that has contracted or developed CRPS. We have one philosophical viewpoint on how to treat patients with chronic pain, whether it's CRPS or central sensitization or whatever. And that's the way we treat them. I clearly realize we're in the minority. I'm part of a pain listserv. We're unique in that it's truly physiatric based with cognitive behavioral therapy at the core. Clearly, most practitioners of pediatric pain management are anesthesia based. So we're unique in that matter. I would not say that's our standard of care. I'm not going to speak for the field.
And based on your review of these emails, what was your understanding of the plan of action as of January 2017 as set forth in these emails?
I'm actually not sure. It sounds like they were maybe interested in doing the program, and I'm not sure where it got left.
Fair enough. Do you ever recall being contacted by anybody from Johns Hopkins All Children's Hospital to discuss Maya Kowalski, her case, or really anything for that matter?
No, not at all.
Same question for a Dr. Sally Smith. She's a pediatric child abuse physician. Do you recall if she ever contacted you?
No.
Okay, what is the Budapest criteria?
So it's a group, and Dr. Norm Harden, who was one of our mentors and colleagues here and director of pain management, provided a construct in which to provide clinicians which a way to better diagnose CRPS and to sift through the other diagnoses where maybe they didn't meet criteria and such. You would have to figure out what the etiology of pain was, because otherwise it's like fibromyalgia was 20 years ago. If you couldn't explain it, everybody had fibromyalgia. And so attempting to become a little more eloquent in the presentation and developing a impression of the patient.
When you're diagnosing a patient or considering diagnosing a patient with CRPS, do you use the Budapest criteria in your clinical work?
Yes.
And why do you use that criteria?
Provides for a better, accurate treatment. Obviously, the reality for me is a lot of the procedure, so specifically in CRPS, the therapist may ascribe a very specific philosophical presentation of, providing graded motor imagery and mirror therapy and, attempting to decouple the limb from, this pain presentation. But it's just going to determine and devise the treatment plan a little more eloquently.
From what I'm reading here from your consult note, you didn't diagnose the patient with CRPS. Is that correct?
That's correct. So yes, in a patient with CRPS, the PT and the OT are going to start in a very different place than maybe FND, or in this case, conversion disorder or central sensitization, and focus on, if she's not moving, how do you get her to start moving and improve on transfers and improve on mobility.
Based on your review of this consult note and your training and experience, why did you not put complex regional pain syndrome, also known as RSD, on Maya Kowalski's differential?
Well, one, the presentation is more diffuse. There isn't a specific, hey, I had some traumatic injury to my extremity, and now I've got pseudomotor changes, vasomotor changes. So I have swelling, I have discoloration, I have a temperature discrepancy between one limb and another. The rest of the body's fine, but please don't touch my right foot, because when you do, you send, electrical shock waves through my body. We're not getting any of that flavor or description in this note. So hence, the fellow at the time put conversion, and perhaps maybe more appropriately, that concept of what I described as central sensitization is more pertinent or relevant based on the presentation.
All right. So because a lay jury may hear this as opposed to specialists in your field, fair to say that your differential at this time was leaning towards central sensitization and not complex regional pain syndrome?
That's correct. And again, I have no recollection of this patient, but I can only go on this one note. Basically, not observing any of the telltale signs of changes in an extremity. In fact, this patient has normal muscle bulk. They're moving the extremities. There's, obviously, whether it's allodynia or hyperalgesia to light touch, I'm not seeing any of the symptomatology of consistent with CRPS.
So, Dr. Revivo, am I doing that correctly?
You are, thank you.
Dr. Revivo, complex regional pain syndrome is a progressive disease to a certain extent, is it not?
It depends.
Well, you can start out with a few symptoms, but as time goes on, develop several more. Can you not?
In my experience of patients, you certainly have had potentially, the presentation of hyperalgesia and allodynia and maybe the pseudomotor and vasomotor changes. What I've seen is potential spread in the body. As far as morphing symptoms, or additional symptoms, I don't know.
All right. Did you check to see whether she had the beginnings of any CRPS lesions?
I can only go based on what we have in this note, since this is the only visit we had with this patient and what we've documented.
And you are familiar with CRPS lesions, are you not?
Yes.
They're rather distinctive.
That's correct. That's correct.
And if this patient down the road were to develop those lesions, say within the matter of 3-4 months, 6 months after you seeing her, would that have some effect on your ultimate diagnosis?
For sure.
And isn't there now there are 2 or 3 different forms of CRPS, are there not? There's like Roman numeral 1, Roman numeral 2, and Roman numeral 3. I don't know how you turn them.
Well, yeah, I mean, traditionally, there has to be trauma. And whether they're, Roman numeral 1 and 2, at least, the dichotomy between the two is that you have EMG identified nerve damage with type 2.
Okay. And what did you check for to determine if that type of nerve damage was present?
Obviously that would be EMG, but that would be if that was warranted based on the examination at the time. So our exam specifically looked at attempting neurologic assessment of both sensory systems and motor systems. Sensory systems, obviously, refused exam, screen with light touch. So she clearly has got at least hyperalgesia, if not allodynia, by definition. And based on our examination and what she would, again, just based on what we've described in this note, allow us to do. So we noted right active movement of the upper extremity. We noted intact motor to allowing her to wiggle her toes. So in some part, we were able to assess both a sensory and a motor component on the exam.
And just so the jury's aware, in either one of these, if it's CRPS or it's the diagnosis that you had, these are not diagnoses of being paralyzed, are they?
No, you're right. You typically not paralyzed. No.
Okay. And as we sit here today, I don't think, I don't know, I don't think you've had the opportunity to discuss what happened to Maya afterwards, her continued course of treatment throughout the rest of 2015 and into 2016. Have you?
No, this is my only visit with the parent and the patient.
And one of the problems in diagnosing these, if I'm reading my literature correctly here, is that many people don't believe the patient, particularly children, that they're in pain because of the way it presents. Is that fair enough to say?
Very fair. And I think that's why I talked about conversion and really moving away from that moniker as it's maybe even, perceived as pejorative in that, this functional neurologic symptom disorder, which central sensitization, if you read the literature and you ascribe to certain opinions, may fall under that, in that there is some component of functional change. Because if you state that this patient in some regard has intact motor function, but yet is dependent in mobility, then this pain is very real. And at the same time, there is a functional component, i.e., there is some function that is altered or limited because of pain. But no, I deal with chronic pain patients every day. That whole concept of central sensitization and what what Melzack stated as the neurosignature and the neuromatrix is that pain is very real. What's hard to know is that you get a lot of this background noise. So you get behavior. It's difficult to examine a patient like this, but by no means does that mean we don't believe them.
And particularly we talked about the specialization of pediatrics, it's sometimes difficult, particularly with a child, if you don't know, as you just explained, how this works. It can be easy to misidentify this as a psychiatric or psychological problem, isn't it?
Correct.
Can you describe for the jury the concept of intractable pain in what you do?
I mean, intractable pain would be no relief, right? So we use the FACES scale to try to ascribe a degree of how much pain the patient is perceiving, and the fact that pain is chronic and unabating.
Your diagnosis was not conversion disorder, true?
Certainly there were components of conversion disorder on our assessment with, an ICD, well, in 2015 would have been ICD-9, but the more eloquent diagnosis today really would be that concept of central sensitization. So, yeah.
And likewise, there were some signs, such as the allodynia or aldonia or
hyperalgesia.
hypoalgesia, thank you, present in Maya as well. And those are CRPS indications, are they not?
They are, but without the other telltale signs, as you stated earlier, I see allodynia, I see hyperalgesia. I see that in other pain diagnoses, like central sensitization, like hypermobile spectrum disorder, like fibromyalgia.
All right, so we're clear then. With your experience, what symptoms would you need, symptoms or signs, combination, would you want to see before you felt confident in a CRPS diagnosis?
Sure. Some degree of asymmetric temperature change. There may be some swelling or edema. There may be discoloration, whether it's purple or red. But you start to see some dysvascular, neurovascular changes in an extremity that are more akin to what we typically see in the traditional patient that presents with a CRPS diagnosis.
And plus the, like you said, the super sensitivity to touch.
Correct.
Allodynia. And then the, and that's kind of like a fear of being touched, is it not?
Well, the kinesiophobia is really the fear of movement or being touched. I mean, allodynia is, you lightly stroke a portion of the body and you're causing, excruciating pain, where traditionally that's not a painful stimulation.
But they think it might be, and so they overreact.
Sure.
And then of course the lesions eventually.
So
the lesions eventually.
Yeah, I mean, in my experience, it's patients that are coming, have been made, the diagnosis has been made. They're coming with the lesions. They're coming in the cam boot. They're coming in with the altered mobility, as opposed to, seeing them.
I see. So you're not usually the one coming up with the diagnosis. You're the one treating it once it's been diagnosed. Fair enough?
Fair enough. I mean, we're a tertiary center, chronic pain. These patients traditionally have seen other clinicians, whether the diagnosis is accurate or not. We've had plenty of patients where they state they have CRPS and then we disagree and say, well, you're on a continuum of that neurologically, but you don't meet all the criteria. Or traditionally they've seen, 2 or 3 orthopedists. They've been put in a cam boot and they show up to us and we're like, yeah, okay, you meet the criteria. Now let's treat you. Now you're asking about suicidal ideation and, all these other issues that may be related to pain, but I did treat at some point, begrudgingly, some of the adults in our program just because of staffing. And we had patients that said, hey, I'm going to go home and kill myself. And we had them sent to the emergency room. We called 911 and said, I can't send you home safely. Sure. Telling me that you have a plan and that you have a means. And those were the adults. I've never had a pediatric patient tell me that.
And so some of the pains with, say, the CRPS, are they a constant or can they go away and come back, reoccur?
It's very interesting because I have a cohort of a couple girls that, by textbook would be given that definition, but then their symptoms and their signs and symptoms veer from textbook and they have symptomatic flares and they're doing well with gabapentin. And, whether it's truly CRPS at this point, or do we change the diagnosis to this concept of central sensitization? Their bodies haven't read the textbook, but yet we're still treating them as if they had allodynia periodically and hyperalgesia. And yeah, it's a very small subset.
Hey, doctor, a couple follow-ups. This is David Hughes again, counsel for Johns Hopkins All Children's Hospital. Can you please list your board certifications?
So I'm board certified when we complete PM&R residency in basically, physiatric medicine, and then sub-boarded in pediatric physical medicine. So really have one board. The pediatric board supersedes the adult board. And we basically take an exam every 10 years, and then we're doing longitudinal assessment at this point.
Would you consider yourself an expert in the field of pediatric physical medicine?
Correct, yes.
Okay. There was reference made to hyperbaric oxygen therapy for complex regional pain syndrome. Are you aware of let me ask you this. Do you at Rehab Institute of Chicago employ hyperbaric oxygen therapy for pediatric CRPS?
No.
Have you ever heard of that modality being used for a pediatric CRPS patient?
Yes.
What is your opinion on its efficacy if you have one?
I usually tell families that if they have enormous amounts of money, then certainly they can use it, but the research hasn't borne out practicality, efficacy. We traditionally will use it for patients who have burns and wounds, but I again, remember, treat a lot of patients with cerebral palsy. Families want to pursue that treatment. Again, if they have endless amounts of money to pursue that, then so be it. But the data doesn't burn that out.
Have you ever had a parent come to you at Lurie's or the Rehab Institute of Chicago and ask for their child to be placed in a medically induced ketamine coma down in Mexico?
No.
Have you ever heard of one of your patients going down to Mexico to do that?
No.
And are you familiar with the Dr. Fernando Cantu down in Mexico?
No.
And I think you said you've seen some of these lesions in pediatric CRPS patients before. Is that correct?
I have.
What do these lesions look like in your experience, specifically on pediatric CRPS patients?
I mean, I think to be really specific, these patients, they present with a, let's say, for instance, the leg. There may be a discoloration, maybe somewhere between purple and red. There's temperature differences. There's some swelling. I've had one patient, if you want to say the word lesion, he was an adult, and this is at the time that I'm still seeing adults whose limb basically was black and purple. So, that may be more along the lines of the textbook lesion, but the lesions that we're treating are the signs and symptoms that are more ascribed to, this waxing and waning discoloration of the limb and temperature difference and swelling.
Okay. Let me screen share an image here for you, and I'll represent to you that this is an image of Maya Kowalski taken on, I believe, January 1 of 2017. Its base number is JHACH014768. I'd like to attach this as an exhibit. Do you see the what I'm circling here on the right forehead here?
Yes.
Does that appear to you to be consistent with the type of CRPS lesions you've seen in the past?
No.
Why not?
Because it isn't. It looks like a scratch.
Okay, so why does it look like a scratch to you?
Because it does. It doesn't look like it's CRPS. There's no swelling. There's no edema. It's on the forehead.
You mentioned EMG nerve conduction testing in your testimony. You remember bringing that issue up?
I do.
Let me ask you a hypothetical, doctor. Say, for example, 1 month after the Lurie's presentation at issue, Maya Kowalski underwent an EMG at an outside facility, and that was negative. Knowing that, how would that impact your assessment as to whether or not Maya Kowalski did or didn't have CRPS?
Well, I think in fairness, I wouldn't give her a diagnosis of CRPS type 2, but solely based on a negative EMG. That doesn't mean she doesn't have CRPS type 1. Just tells you that there isn't nerve damage.
Would you consider a study where the average female age is 39 and the average male age to be 43 years of old to be a pediatric focused document? Why not?
Because pediatrics is 0 to 18 years of age.
Fair enough. Have you ever had a parent or anybody for that matter refer a child with a CRPS diagnosis to hospice?
No.
You saw some characteristic CRPS style skin lesions during your assessment with Maya Kowalski. Do you think that's something that you would have documented in your progress note?
Absolutely.
Okay. Well, that light comes on really fast, doesn't it? So now that I've blinded you, it's time for your break. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. Let's try to keep it to about a 10-minute break.
Very active.
It's a thank you note for the birthday.
Oh, nice.
They even drew little balloons and signed the juror number. I don't want to say the juror number, but it's
Right.
the juror number whose birthday is.
That's nice.
Yeah.
They didn't thank you for the unbirthday?
Actually, no. We got to do something about that. But it does say it brought a smile to all of our faces, so perhaps it's implicit in the note. So, in any event, any issues we need to address before we?
Just a quick discussion, Judge, on timing. Unfortunately, the next witness we have is another video deposition.
For how long?
That's the really unfortunate comment. It's 2 hours.
Well, okay.
I just wanted to let the court know. Maybe they could stand up and stretch it 1 hour or something.
That's fine. Anything else?
No,
Ms.
no.
Lawrence?
Nothing.
Let's take a 10-minute break. Let's try to keep it at 10 minutes if, in fact, we've got a 2-hour deposition in our immediate future.
Yes.
Yes.
We'll be in recess 10 minutes. Seated, everyone. I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And has anyone approached you about this case since the last time we spoke? And have you seen any media accounts? Okay. And thank you very much for the nice note about the birthday and the unbirthday. Happy birthday and unbirthday for this group. And as a present for you, we've got a 2-hour deposition that we're going to play.
We're so sorry.
So we're going to dim the lights, but before we do that, since it's 2 hours, is there anyone need to make any telephone calls? Oh, I am very, yes, we are doing it on a Friday afternoon. That will take us about 5:15. So does that impact, does anyone need to make a telephone call? Okay. Without any further ado, Mr. Shapiro? Do you want to try them with them on?
Yes.
We'll leave them on, and if you need it dimmed, let us know. And again, feel free to move around and stretch. Okay. Mr. Shapiro.
Without taking arrows from the jury, we're calling Dr. Farhan Malik, ICU doctor, taken on November 12, 2019. Thank you.
Raise your right hand, please. You solemnly swear or affirm the testimony you have to tell the truth, the whole truth, and nothing but the truth.
Yes. Please state your name for the record. Farhan Malik. And you are a physician in practice employed by Johns Hopkins All Children's Hospital? Yes. And as part of your practice, you at one point treated Maya Kowalski.
Correct. And where'd you go to college?
New York Institute of Technology.
Year you graduated?
2005. 2005. Yeah.
Medical school?
New York College of Osteopathic Medicine.
And where's that located?
It's also located with New York Institute of Technology. They're both in Long Island.
And what year did you graduate your 4 years there?
09.
It's a 4-year program for osteo as well as MD, right?
Yes.
For the benefit of the jury, can you give them a very brief description of the differences, if any, between an MD and a doctor of osteopathic medicine?
Sure. The degree is actually called a DO.
Yeah.
It essentially is very similar to MD schooling. You just take additional courses in osteopathic manipulation, which I liken it to chiropractic. And so you have the option of practicing that when you graduate versus just practicing as a regular doctor.
I was reading, I think, maybe for your medical school website, but osteopaths take a more holistic, all-person approach to the patients than MDs. And is that traditionally what the deal is?
Yeah, the philosophy that I think founded the tradition was kind of treat the patient as a whole, not just the symptoms.
Again, I don't know how accurate this is because I'm just reading off the internet, but osteos tend to be literally more hands-on with the patient. I mean, there's more manipulation and testing, feeling, touching, that kind of thing, and diagnosing.
You take classes in the manipulation aspect of it, and if you choose to practice that, once you're done, and incorporate that into your practice, if you're in a field where you can, such as internal medicine or general practice, becomes a little different when you become more and more specialized.
The area that you chose to go into was critical care with a focus on cardiac, is that right?
Yes, cardiac intensive care.
All right. And where did you do your residency?
Newark Beth Israel Hospital, so the Children's Hospital of New Jersey.
And what year did you, what years were those?
So that would be 09 to 2012.
And after residency, what did you do?
I did my fellowship in pediatric critical care at the University of Texas in Houston.
And what year were you licensed to practice medicine in the state of Florida?
2015.
What month?
I don't recall exactly. I believe it was May.
So at the time you saw Maya Kowalski in her October 7th admission, you had been a licensed physician in Florida for 15 months? So you made 12, May, June, July, August, September. So about 16, 17 months?
Yes, I believe approximately.
You were a fairly young doctor, relatively speaking, experience-wise?
Yes.
And were you licensed in any other states?
New Jersey.
And what year were you licensed in New Jersey?
That would be at the start of the conclusion of my residency, so that would be 2012.
So after your fellowship at UT Houston, where did you go?
Johns Hopkins Old Children.
And what was your position?
Pediatric critical care physician.
And what does a pediatric critical care physician do?
All things involving intensive care. So if a child gets admitted to the ICU for any number of reasons, trauma, sepsis, after surgeries.
As part of your residency and fellowship, did you take any additional courses or areas of study in pediatric psychiatry?
or psychology?
No, the only additional training that I received in that would have come in the form of my continuing medical education.
And do you have a list or any determination, a way for us to determine what those courses might be?
Yeah, I have a list of all my CMEs.
Let me, I think I got it here. Let me show you Exhibit 1, Doctor, and let me know if that's as of, say, October of 2016, accurate.
Yep.
And that's just going to be 1, and then I'll mark this one as 2. Well, would I be accurate in saying that according to Exhibit 1, there was no specific continuing medical educational course devoted to pediatric psychiatry or psychology?
Correct.
So, do you remember any of them specific to any of the disorders, claimed disorders, illnesses, claimed illnesses with Maya? Did any of these quizzes involve questions about complex regional pain syndrome or RSD?
No, not that I recall, but I've relied on my medical training to when I got presented with her as a patient.
And how many of them involved identifying medical child abuse, if you recall?
Throughout my career?
No, just that first 15 months there after you were licensed in Florida and before October of 2016. Basically before you saw Maya for this.
None.
Would it be fair to state then that as of October of 2016, you were not an expert in complex regional pain syndrome / also known as RSD?
Yes, that's very fair.
Would it be fair to say that as of October of 2016, you were not an expert in medical child abuse?
Yes.
You were not an expert in factitious disorder by proxy?
Yes.
You were not an expert in a conversion disorder?
You're listing a lot of psychiatric disorders that, no, I am not an expert in because I'm not a pediatric psychiatrist. So.
And then Munchausen by proxy, same answer?
Yes.
Not an expert in that either. All right. When was the first time you met Dr. Sally Smith, if you recall?
I don't believe I've actually ever met her.
Have you ever spoken with her on the phone?
I can't recall exactly, but I might have spoken with her regarding this case.
Did you know of her, even if you didn't speak to her or see her?
Yes.
And what did you know of her as of, say, the period before October?
That she was our go-to person to speak to if you had concerns of child abuse.
So, did you have any specific instruction from All Children's Hospital, your employer, about when to make a call to child protection as opposed to not making a call?
No. As a pediatrician, if you're suspecting child abuse, then it's your obligation to make a call. And Johns Hopkins just reaffirmed that you should follow protocol as a normal pediatrician. So she was our contact person, and I was informed that if there was ever a case that I was involved in where I suspected child abuse, that she should be contacted.
Did they tell you, anyone at ACH, that you should call her first or call the abuse hotline first?
No. I believe that I was under the impression that I should call her first.
Okay. And would that have been through other doctors or management or?
There was a contact number, I think, on our list of phone numbers for all our specialists. I think that was her cell phone.
On any of Maya's prior admissions or visits to the ER at ACH, had you ever run into either her or her family?
No.
So the first time you ever met any of them would have been on that October 7th visit?
Correct.
Did you actually make the call yourself to the child abuse team hotline? Or did somebody else do it?
I don't believe I did, no.
Okay. But it was done at your direction? First phone call to DCF?
I would have to review the records.
Okay. That's a fair answer. Okay. And do you know Dr. and it's Tepes Sanchez, but I think everybody just calls her Dr. Tepes. Is that right?
Correct.
Okay. Did you know Dr. Tepes before this admission?
Yes, we're colleagues.
And how long had you worked together?
Couple of months.
What was her specialty, or is her specialty?
Same as mine, pediatric critical care.
Even though it's not really written down from what you can recall, can you just describe to me what, when you think about it, what the protocol is if you have a suspicion? What are you supposed to do?
I think I described it before. Essentially, you're contacting Dr. Sally Smith, the child abuse specialist, in conjunction with.
Can the attorneys for a moment, please?
Yeah.
Members of the jury, I'm going to ask that you step back into the room. I'm going to see if we try to shorten the video. I don't know. I can't promise. Please don't hold me to that. But do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
Your reaction?
Everybody. And you're going to check those designations?
Yes.
Juries that are our presence. Okay, please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? Correct. Okay. We're still going to be playing this doctor's deposition, but it's going to take a while to make the cuts to make it reduced in time. So instead of doing it now and making you wait here, in honor of the unbirthdays, you get to go home now. No. So, yes. But you probably want to leave soon before I change my mind. So, as a reminder, I know we're just kind of having a moment of levity there. See, you got it. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. And on Monday, just normal time. Yes. Yeah. So I want you here so we can start at 9 a.m. on Monday. Now, next week, there is no day off next week. So it's a 5-day week for you, okay? Have a great weekend. Happy birthday.
Thank you.
Very excellent.
Okay, please be seated. I have to redo the math. The plaintiffs consumed, because I'm not going to charge anybody for those last few minutes with Dr. Malik. 1 hour, 15 minutes. So plaintiffs, you're now at 49 hours, 30 minutes. Plaintiffs, you used defendants, you used 1 hour and 45 minutes, and you're at 23 hours, 50 minutes.
50.
Yes, 23:50. They're 10 minutes away from a full day. Now, obviously, I said we were going to stay here until 6 to do exhibits. So, do you all want to take a couple-minute break before we jump into exhibits? But
That's 5 minutes to organize our thoughts on which exhibits we'd like to go first. That's all right, Ron?
that's fine. But I want to try to get rulings on as many of these exhibits as possible.
It doesn't matter. We can just start with where we're at and go through.
Well, I don't want to have like lots of late nights if we can help from it.
No, agreed. And do you mind if I stand up while we do?
Oh, that's fine. Do you want a couple minutes to?
I think 5 minutes should be great.
So we'll be back in 5 minutes to start addressing exhibits.
All right.
Just in follow-up from Dr. Malik, I don't recall making those, but if I did, maybe I need to redo those. But
No, Judge, I think our quick checking, it was our error and failure to object.
well, we will separate and independent of this. Given how I've been ruling and given your time constraints, perhaps you might want to relook at Dr. Malik and see if there's things that you wish to pull back and save time.
We will. I suspect, I don't know this for sure, but those might have been done before the 2022 attempt at trial. We'll look at the meeting.
Okay, so
Because I was like, I don't remember those.
No, well, Judge, it wasn't you.
In any event, are we ready to move on to exhibits?
Yes, Sharon. We'd like to go to, I think you've done the first and second page up to 3090, so we're just going to go in order. So 3090 is
Well, there were still a
video.
couple on page one.
I'm sorry?
There looks like there still were a couple on page one.
Oh, I think,
I think we addressed all of them. Some of them they withdrew,
no, we didn't.
or not for later discussion.
I don't know which one.
That's one for Brandon Alexander.
Oh, that's right. Yeah, we need Dr. Alexander's testimony before we deal with 3023, Judge.
And then 3030, was that the sheet of paper that had no writing on it?
Yes, Your Honor.
Yes.
Okay, what's next?
I think we're up to 3090. I don't know what, they have an objection. You want to see the video, Judge?
It's a horseback riding on January 16th of 2017. So
Correct.
how long is it?
Got it pulled up here right now. It's 20 seconds, 25, 26.
Go 26 seconds or minutes?
Seconds.
Go ahead and play it.
Do that to you on a Friday, Judge.
Is this in like slow motion?
It does appear to be that way.
That's how it was produced. We'll take the hearsay groaning out.
Now he's got his ears for.
So perhaps someone filmed it in slow motion.
Perhaps is how it got to us, Judge.
Ms. Lawrence, are you making this argument?
No, thank you.
We have no objection.
Okay. Court will receive 3090.
3094 is another video.
No. Her face is bigger. Her butt is in the pants. I got that. You do? Yes, I got it. Oh, I killed no. No. Tell me. Don't want to see.
No objection.
Court receives 3094.
3095, another video. Another puppy video. It's a cute puppy.
I see you.
You know what Kyle does? He just lays down and then she comes and jumps on him.
Come on, leave. It's okay. It's okay. It's okay. It's okay. No! No!
Our objection would be it's 2 days from the previous video. It's starting to get cumulative.
Judge, I think it shows much more movement.
It does. I'll receive 3095. What's next?
3096.
Go.
Let me see 3097 as well.
Judge, we'll just do 3097 and not 3096.
Mr. Whitney. 3097's in. And did we do 3120?
We'll withdraw that, Judge. That was like 9 seconds.
And then we did a whole bunch of 3121s.
We did, Judge. We're done with 312.
Okay, I believe the 3120 was withdrawn as well as 3096.
Yes, Your Honor. 3124 has already been admitted. 3135 has been admitted.
3135 dash.
Yes, sorry, dash 2 has been admitted. So we have 3137.
Can you
withdraw this, Judge?
Okay, so 3137's withdrawn.
Yes. 3138 has 9 photos.
And are we going to see all 9 of them?
Yes.
Relevance 403 says these are drawn from the People magazine article, and here clearly the release of the film Take Care of Maya. So unless we're going to explore the context and the reason for these photographs, I think it's irrelevant, prejudicial.
Do I need to respond, Judge?
Yes.
Judge, these are photographs taken in 2023, so they're obviously relevant. They're also, given the description by the plaintiffs as to what Maya does and doesn't do, I think it's relevant that she was in New York at the red carpet. The jury all knows about the Take Care of Maya video. We all asked them about it for days, so it's not going to open a door to anything. We all asked them about it, so it's not like we're trying to keep out the fact that it is.
Well,
They also had one showing her exercising.
can I see the series again?
These are 2023 photos. 2023? Yeah, these are the first. Yeah. Judge, if we want to pare them down, we can do that.
We're going to pare them down, yeah.
Okay, all right.
And the ones we want.
Okay. Yeah.
So, anything else, Mr. Whitney?
I'm curious to see which ones they want to whittle them down to, and then I might have further objections.
Well, this is not yet a ruling, but I think they're going to have to choose 3 photos, 1 or 2, 4 or 5 or 7 or 9, I think. So why don't you look at those?
2, I'm sorry, 1, 2.
1 or 2.
1 or 2.
1 or 2. You're going to get 3 photos.
Okay. Yeah, we'll take 2.
We'll take 2. So you're going to, okay, and then 4 and 5.
We're only getting 3 photos?
Well, one was Maya individually. This is with family. They're both are laughing and smiling, so.
We'll take number 5.
And then the other one is the person I'm assuming is the boyfriend, 7 or 9.
But there was one of her on the exercise machine, Judge.
That looks staged.
Okay. All right,
I
we'll
mean-
take 9.
We object to 9, the Tribeca backdrop. If they need a photograph of her in a relationship, that has maybe become relevant. 7 would suffice. 9 is going to introduce all sorts of issues. Although they're aware of the existence of the film, we're going to want to explore what arrangements were made for her in New York City, how come this was a comfortable experience rather than what she testified to, being out and about and seeing Kathy Beatty or people that look like her. We'll also, if photos are coming in, want to be able to explore that all of them that are going to be admitted were staged by People Magazine, and they're not truly candid shots. It's a People Magazine photographer.
Judge, this is a valid photo, number 9. That they already talked about the fact they went up there for the Tribeca Film Festival. That came out in, I think it was Mr. Kowalski's testimony. It's not opening any door. The jury knows about it, and it is a different view than has been presented with regard to Maya Kowalski's life that she has presented in front of this jury, where she's afraid to go out of the house. She's afraid to do anything. This is a different view, and the defense has the right to put this perspective in front of the jury. So between 7 and 9, we would choose 9.
Like I said, it wasn't a ruling. To me, the Tribeca Film Festival it's a collateral issue to this lawsuit. And I get what you're saying about she's out and about, but the context is a little bit different. It would seem that 7 would also suffice to help tell that story. And I think I would allow you to do 7, but I've got concerns about going down the road of pictures of the Tribeca Film Festival.
Okay.
Just like I didn't want, they wanted to put in the movie, and I said no.
Well, Judge, to me, putting in the movie is a whole different kettle of fish. You're talking about
You don't
incredible
think I'm getting that request if we start talking about putting in 9?
Judge, that's in all seriousness, that's a completely different analysis. This is one photo. They already know they went. If we can block out Tribeca Film Festival if you want. But it's a completely different view of Maya Kowalski's life that they have failed to present to this jury that the defense believes they have the right to do.
I will receive in 3138 number 2, 5, and 7, and it will exclude the others.
Can we see 8 again, Your Honor?
You can put up 8.
Yeah. She can say it's staged, Judge, but I think we should be allowed to put in 8.
2, 5, and 7. What's next?
All right. 3139. This is an email from Dr. Wassenaar to Beata.
September 9th, 2015. Okay.
Yes, September 9th, 2015.
Something's wrong with his email. It doesn't have a recipient.
I'm sorry.
It says from Dr. John Wassenaar.
But the from at top says from Kowalski. It doesn't have a to. So it's not, I don't know what this is, but it doesn't seem to be a valid email. I've never seen an email about a to address.
Yeah, Judge, we'll withdraw it. 3140, 4 pages.
Can you put the first 2 pages up for me, please?
It's from, it's October 30th, 2015, email from Beata Kowalski to Dr. Kirkpatrick.
Well,
I guess because it's going backwards, let me see 3 and 4 first, because so I can read it in.
I think you're right.
Hey, can I see pages 1 and 2, please? The timing seems a little different. Maybe they didn't respond to like the last email.
I'm sorry, I don't recall what the date was on
On page 3, it was at 5:50. So I suspect what probably happened is she took an older email and then responded.
Right.
Right, because on page 3, if you put page 3 up, there's a later email saying, surprise, surprise, there is no response from Wilsey's office, I'm done.
At 5:40 p.m.
Yeah, that must have been what had happened. What is the plan's position?
Our position is it's hearsay without exception.
Seems like she's trying to get
Well,
medical care and treatment.
Perhaps some statements from Beata Kowalski could be for purposes of medical treatment, but certainly not all of them. She's relaying what a nurse practitioner with Dr. Wilsey's office allegedly told her. That's hearsay without exception. Dr. Kirkpatrick's communications are hearsay without exception. The exception for medical treatment is as to statements made by the patient, not emails between doctor and patient.
Which also goes to state of mind. You've got her saying, I think I'm going to have a stroke soon. I can't
Well-
stand it how medical treatment is being handled in Florida. It's beyond the state of mind.
Is the true objection here the statement, his NP told me that Wilsey is uncomfortable ordering IV fluid? Is that what we're talking about?
That's one of them, Your Honor.
What else?
Within Beata Kowalski's first email there,
Can you give a date?
I'm at the top of page 1. I mean, a lot of this is, if it's statements for purposes of medical treatment, it would be made directly to the physician. So this is Beata Kowalski venting about the treatment that she is getting by the staff at the office. Those are not statements for the purpose of medical treatment. So give me the go around, who she spoke with, that she's uncomfortable ordering IV fluid. All of these are Beata Kowalski venting. They're not statements to a physician or a nurse for purposes of medical treatment. I'll grant that the statement about Maya's condition would be a statement of present condition.
It's also a statement of the Kowalski's state of mind at this time, dealing with what she's going through with Maya.
I'm going to admit without redaction pages 1 through 4 of Exhibit 3140, so the whole thing will come in.
3141.
3140, pages 1 through 4. Did I
no.
misspeak? Because 3140 is only 4 pages, correct?
I'm sorry,
That exhibit's only 4 pages.
that's correct. We need 3141, please.
Okay, the next one.
Yeah. This is also 4 pages, Judge.
Let's put up 3 and 4 first because it might be starting from the bottom up. Okay, so 3 and 4 looks like a lab order of some type.
Yeah, I'm not sure about 3 and 4, Judge. Can we look at 1 and 2 again?
Well, hold on a second. Before we go off, let me see what this is, the dates.
It's like a,
November of 2015. What was,
okay, we'll withdraw 3 and 4 and just look at 1 and 2, please.
well, but just is this the time right before she went to Mexico? Was this the lab order that she had before going to Mexico?
It is right before she goes to Mexico, Judge.
May I see 1 and 2?
And you can see on number 1, he specifically, Dr. Kirkpatrick says to file this email and patient's chart. It's part of the medical record. And communication with BI regarding medical treatment.
Yeah, I think Dr. Kirkpatrick testified to the need for this pump for acute pain on the trip down to Mexico. This is part of his medical record. So is 3 and 4, though, so it needs to come together. Since that's the way it was, that's the progeny of this document.
That's fine. We can continue, keep 3 and 4 if you want.
Okay, so 3141, all 4 pages 1 through 4 will be admitted.
Okay. 3-1, are you ready, Joy?
Yeah, I am.
3142. Oh, we don't need this. We'll withdraw this, Judge. Uh, 3143. This is 4.
Same thing?
It's 4 pages.
Is 3143 the same thing as?
No. It's different.
Well, then let me see 3 and 4 first. Actually, it looks like I need to put up 2 and 3. Here. Okay, and then remind me who Dr. Shaw is.
He is a pharmacist with Quorum that assisted with setting up various ketamine home medications as well as Dilaudid and the PCA pump. He'll be testifying. With Beata's co-workers, pharmacists by trade. Coordinated with Dr. Kirkpatrick for all of these.
And where was this? This was to be performed in Dr. Kirkpatrick's office?
This was for home use.
This is, home use is a bit of a misnomer there. This is again related to the pump that was discussed for the trip to Mexico. Home use, this is a backdoor attempt to get in the script that was previously excluded because of authenticity issues regarding terminally ill. So this is hearsay without exception. It's a pharmacist. It's not for purposes of medical treatment. Beata Kowalski or Maya Kowalski seeking this out. This is a conversation not involving the Kowalski family, behind the scenes between a pharmacist and a physician.
Judge, you can see that one of the pages, number 1, it says, please put these emails in the patient's chart. So it's medical.
I'm sorry. Go back. I have 2 of them. I'm rereading this. What is naloxone?
Can I ask who you're reading to?
On page 3, I've already created an order for NALOXONE.
It's an opioid antagonist, Your Honor. It can, it is used to reverse opioid overdose because there was a high amount of terminally ill Dilaudid being prescribed around this time. And to protect against overdose, that's a medication that's administered in the case of an overdose.
And this is not talking about ketamine at all, correct?
Not yet. We're not there yet, but this is the Dilaudid was on board well before.
Can I see pages 1 and 2?
It's also known as Narcan. You may know it by its common name.
Mr. Whitney.
Yeah, in addition to the hearsay objections previously made, relevance, as the court has spotted, has nothing to do with ketamine. And lastly, 403, because what they want to do here is suggest that Beata Kowalski was pushing for hospice care or taking a position that Maya was terminally ill. And they want to suggest that through this email, which was not the case. This was back and forth between pharmacists and a physician. The pharmacists were attempting to find a way to fill a prescription or get around an insurance requirement. I'm not sure what, but it has nothing to do with Beata Kowalski or her state of mind, and it's prejudicial.
Back in November 2015 timeframe.
Yes.
Is there any evidence that Maya Kowalski, Jack Kowalski, or Beata Kowalski made any sort of affirmative statement about hospice care or being terminally ill?
Judge, it goes, I'm not aware of her contacting some facility, if that's what the court is asking.
I'm wondering because we have a humongous 403 problem here if there's no other evidence about the terminally ill. And my recollection was it was the pharmacist, or it was alleged that the pharmacist wrote something that was not done by the doctor on a prescription. And so my recollection is there was no evidence that Beata Kowalski, Jack Kowalski, or Maya Kowalski had any statements that they were seeking hospice care or that Maya was terminally ill in the November of 2015 timeframe. So
I just have to observe the one attorney per argument rule, please.
Well, that's fine, Judge. It's just that Mr. Hughes knows more about this email, but
I just want to, if there's any facts in the November of 2015 time period that would suggest that, other than this email based on the...
We may be getting to another email later on in the series where Beata Kowalski is involved, but again, I believe this goes to the sheer amount of drugs that are being loaded into this.
No, I want to talk about, because talking about someone saying is terminally ill, we got some pretty big issues that I need to deal with. So I need to know, is there any affirmative evidence that Beata Kowalski, Jack Kowalski, Maya Kowalski, and I'll even say Kyle Kowalski, made statements about seeking hospice care or that inquiring whether Maya Kowalski was terminally ill in the November 2015 time period. As a matter of fact, is there any statement out there that you're aware of?
Statement, no, but she's clearly CC'd on all of these. And
Well, I read the November 10th, 2015 at 12:17, so I need to discuss the situation. I don't see this as an adoptive admission that she agrees that Maya is terminally ill.
Well, but the 9:38 a.m. email says, Dr. Kirkpatrick is saying to Ms. Kowalski, I suggest you contact your local hospice care unit, and it goes to how sick Maya is at this point in time.
we do.
Based on a request from the pharmacist.
We do, Your Honor, actually. It's coming up later in the series, as I indicated. It's actually exhibit number, Defense Exhibit 31491 on November 10th. Mrs. Kowalski is emailing.
Can I see 31491?
Page 1, yes. It's a 12-page exhibit.
Where am I looking?
You are looking on page 1, a little bit down, November 10, 2015, 12:17. Beata is asking Dr. Kirkpatrick whether they could discuss the situation of, quote, terminally ill.
That's the same email we were just looking at, isn't it?
It's the same.
It's the exact same thing.
Right, but you were asking, is there an affirmative representation from Ms. Kowalski regarding the terminally ill situation?
Okay, we'll go back to because this is the exact same email. November 10th, 12:17. Can you pull up the other one that we were just looking at? Yeah, it's the exact same email. Although the one you just showed me had a color.
What is Ms. Kowalski writing to Dr. Kirkpatrick, basically saying, I'd like to discuss this terminally ill situation, see if we can reconsider that, so we can get more medication.
No. This is an issue that unless you have affirmative evidence because of how this all comes up, because remember, we have the pharmacist writing something onto a doctor's script that then the pharmacist calls the doctor then responds to Beata Kowalski suggesting calling hospice, and then we've got Beata saying we need to discuss the situation of terminal. That is not an adoptive admission that Beata Kowalski is affirmatively saying that her daughter is terminally ill. So that issue is off the table.
But that's not why we're introducing it, Your Honor. And actually, the sequence of events that happened here was that Mr. Schott and Dr. Kirkpatrick had a conversation. And during that conversation, Dr. Kirkpatrick authorized Mr. Schott to place on Dr. Kirkpatrick's prescription, patient is terminally ill, so they could get more Dilaudid than would otherwise be able to be filled.
But we are not talking about, because that's not a statement that Beata made, that Jack made, that Maya made, and even if that's true that Kirkpatrick made it, I think as a matter of 403, the unfair prejudice vastly outweighs any probative value. So I'm done talking about the terminally ill issue. So is there anything else that on this we need, because it's not talking about ketamine?
Yes, it isn't talking about ketamine, it's talking about a lot of medication. What if we redacted the terminal ill sections when we revisit this? Because we think it's important for the defense to show the amount of medication that is being requested and being ordered.
And this is Dilaudid. This is one of the most potent
But the defense was requesting that we come back after we've redacted the emails to revisit this, because it shows a lot of heavy-duty drugs that they're giving this young lady in 2015, which is significant to the defense.
Mr. Whitney, if we redact out all of that discussion about terminally ill and what the script needs to say.
Well, I'm not sure where those redactions would leave us. Is the suggestion that we begin at the bottom of page 2 with James Schott's email to Anthony Kirkpatrick and then continue into the next couple of pages? And if so, I need to review those again.
Well, perhaps, on page 1, you see the November 10th, 2015 Beata Kowalski.
Yes.
I forgot to ask that first 2 sentences, that first paragraph, leave that in and then redact out the next 2 lines. Redact out.
Well, I would like to leave in the 4th line that says, thanks again for your time and understanding.
Sure, redact out that third line.
And then we have to redact below that the Dr. Kirkpatrick email.
Yeah, and then redact the email before that from the pharmacist to...
all the way to the end of it regarding hospice care and palliative care. Because that's all based on Dr. Kirkpatrick's understanding of what the pharmacist was suggesting, so it's all interconnected.
I think the 938 email, all of that text would have to come out.
And then
the email at 8:50 a.m. on November 9th from Jocelyn Krager to Kirkpatrick would have to come out.
Judge, I think what we'd like to do, we're calling, is it Dr. Schott?
Sure.
Mr. Schott?
Pharmacist Schott.
We're calling the pharmacist Schott, and so I'd like to table this until you have his testimony, because I think...
I am, if you're just going to start asking about this terminally ill issue, you're not going to talk about it unless we do a proper ahead of time.
We'll do a proper, Judge. Understood. Understood. We'll do a proper.
we generally object to this approach, which is every time an email, the court's making a ruling to exclude an email or redact, then the defense withdraws to come back later and revisit it, and it's becoming...
I have to allow people to do proffers. I allow you to do proffers. I have to allow them to do proffers. Doesn't mean that they're going to get it, because I think I've been very clear that I think this whole terminally ill discussion and how it happened is a humongous 403 issue.
Understood.
Okay, so at this juncture, we'll revisit 431 and 43. Okay. 3144. This is, Your Honor, day 1 of the coma, and it is Beata's writing it to herself.
Is this posted someplace?
So, some of this form, if I may address this. Sure. Some of this does form the basis of the WordPress blogs, and I know the court wanted authentication, so we have here the email from Beata to Beata that she cuts and pastes into the blog, but at a minimum, we're seeking to admit the email that is her own writing. This was produced to us from plaintiff's counsel in response to a request to produce, so it's authenticated.
From Beata Kowalski's iCloud.
Yeah.
Mr. Whitney?
Your Honor, we don't know who wrote this email. No one's going to testify to this. It is from Beata Kowalski's email address. Ms. Kimball, who we discussed earlier, also testified to writing things like this. So we don't know who created this. It's hearsay without exception.
Let me ask you this. Was Ms. Kimball in Mexico?
Not
during
aware.
the medical coma?
I'm aware,
So,
but they were touched.
well, it seems to me the whole purpose of hearsay is to keep things out when there's not a belief that it's reliable. This has very specific information, which presumably, had we had the records from Mexico, we would have been able to verify specifically this is what happened on the blood work and all of that. So it's her email account. I'm assuming that that's her email account. And so it does seem to me to be a statement she wrote to herself. And so to me, this is a very low chance that it's not Beata Kowalski writing this.
And so what's the hearsay exception? Because it's not a statement for purpose of medical treatment.
Your Honor, it's clearly detailing the state of mind. It's purposes of medical diagnosis. It is admissions against interest. She is writing as if she is Maya, and she's writing all sorts of complications related to the coma, that procedure that Maya went under, and that it's an admission that is that contradicts the testimony that's been presented in regard to the coma procedure that Maya underwent. And the procedure is very high risk due to the fact that I have immunodeficiency, poor nutrition status. I mean, it's an admission.
And I believe statements of the decedent are admissible under party admission.
But we have case law on that.
Okay, well, let me back this up. Did anyone say recorded recollection? Because I think that one has to be offered.
No, we did not say recorded recollection, Judge. At least I don't think so. I've had whispering in my ears, but I don't think we said recorded recollection. But this is an admission. It's detailing all the complications that occurred and the concerns so the state of mind for sure, and it also shows all the complications, admission of that versus the somewhat rosy picture that's been portrayed to the jury of this coma that Maya underwent.
Certainly not for purpose of medical treatment. Beata's not writing to the doctor. And statements of a decedent under the case law we reviewed are not admissible as party admissions.
I don't know what he's referring to there, Judge. That doesn't make sense to me. She's clearly a party.
Statement being offered against the party.
Yes.
The party's own statement.
Yes.
It would seem that there is an exception to the hearsay that would apply. Anything else, Mr. Whitney?
Under Huff versus White Motor Corp at 609 Federal 2nd 286, and admittedly this is a rare situation, but I'm in Earhart's. Statement of decedent is not admissible against the estate as a statement of a party opponent.
We're not admitting this against the estate, Judge. We're admitting this against her.
Well, what was your cite? It sounded like a federal case.
It is, Your Honor.
609?
609 Federal 2nd 286.
because it uses the double negative, but it looks like the statement was admitted. We hold that unless the declarant was not mentally competent when he made the statement, it should have been admitted under the so-called residual exception to the hearsay rule.
I don't believe Florida has the residual exception to the hearsay rule. So I don't think that piece is applicable.
What?
I don't see how this case has any implication.
Well, I'm not even sure it. Okay, the decedent in that case was Jesse Huff. So the decedent was Jesse Huff. The PR was Helen Huff, the wife. The declarant, defendant offered and trial court excluded the testimony of Melvin Miles. The declarant, who was the husband of Mrs. Huff's husband and a friend. Huff gave the following description of how the accident occurred. So this is a person who heard the decedent say how the accident occurred. Apparently, Indiana doesn't accept privity. So, even if that were the case, you would still run into the problem under Florida law 18D, which is a statement by the party's agent or servant concerning a matter. Mom is perhaps the agent. So I don't see how that case applies at all.
Is the court saying that the audit here is the agent of Maya? Is that what's being?
Well, I mean, the reality is we have. I'm sorry?
I found the case in all fours in Florida covering this.
Well, give me a Florida case that's better than a Seventh Circuit federal case.
It's a second district case, 185 Southern 2nd 7.
Ritter versus Bringle, Brengle.
Yes, and about 2/3 of the way down, it says admissions against interest made by a person since deceased may be introduced against a person claiming under its succession to the deceased declarant. And then it cites a Florida Supreme Court decision from 1951.
Can you give us the site again?
Yes, sir. It's
185 Southern 2nd 7.
Thank you.
Okay, so I conclude that there is an exception to the hearsay rule that would apply for exhibit.
Understanding, I want to put one more thing on the record, which is that we'd object on relevance in 403 because this email is not relevant to our medical malpractice claims. There's no claim back against Fabre, against Dr. Cantu. the hospital had no knowledge of this when they did what they did. So it's not relevant to anything that happened inside that hospital for 3.5 months.
Your Honor, they've put central to this case the idea that the hospital had no basis to conclude that there was medical child abuse, that there's no basis for the transfer orders questioning this treatment. It's absolutely false that the hospital did not know about this, because part of what the hospital had and saw in its records were specifically treatments of this. And Mrs. Polsky was in the ER demanding that, Maya be put into a ketamine coma. The plaintiffs have set up in front of this jury arguments that, it wasn't really that high risk, it wasn't that big of a deal. This details, frankly, without using hyperbole, the horror of what went on with Maya in this coma. So it's highly relevant issues that the plaintiff has introduced.
Well, let's go back to the 30,000-foot view. There's evidence before this jury that there was a 50-50 chance of death that was told to the family, including Maya. We have Dr. Cantu said, well, we say that, but he doesn't believe that to be an accurate. This tells us what happened or could be seen by the jury as what happened during day one of the medical coma. There was evidence that was presented to the jury about the coma. There was videos. There was discussion about some lab work. I think there was some discussion that there was some difficulty during the procedure.
Yes, recognizing all of that, Your Honor, the only thing that the hospital had knowledge of at the time is what was in their records. And that was a couple of lab results from Dr. Cantu. In order for this to be relevant, there would have to be either a Fabre claim against Dr. Cantu, of which there's no basis for that. They don't have an expert to even opine on causation in that regard. And nothing that the hospital did can be explained by what's contained in this email, because they did not know of it until 3 years into this litigation. So what they did in the fall of 2016 is unrelated to an email that's produced to them in 2019, 2020.
What are we doing about Fabre? Because Mr. Altenburn suggested that there was going to be no Fabre or potentially no Fabre request.
That's likely the way this is going, but that's not what we're introducing.
Okay, help me understand what you're introducing.
Again, Your Honor, they have represented to this jury that all of the medical treatment that the Kowalski saw was completely normal standard of care, and the people at All Children's are not RSD specialists. They did not understand that what was being requested here was just everyday thing. And of course there was, I had to push for the 50-50 admission because people were downplaying it. What this shows as a play-by-play, because the record for the request from Dr. Cantu were either destroyed or lost or whatever, it shows a couple things. It shows the horror that went on to Maya Kowalski while she was in this coma. It shows that our experts are correct, that this is completely unnecessary and dangerous risk, which just goes directly to the heart of our FMC. It also shows Yana Kowalski writing as if she's Maya, and the plaintiffs have made a big deal about, the lack of basis of any Munchausen by proxy diagnoses. This is in the file of Sally Smith as part of her WordPress blogs. It's also, I believe, referenced in Dr. Lewis's report. This goes right to the heart of everything that we're defending against, as the plaintiffs are putting on a case of, we were just seeking conventional treatments that you just weren't used to, and the ketamine coma was no big deal. We can't defend our case if we can't show exactly what Piata was writing in real time. It's an admission by a party of the plaintiff that's relevant. This has to come in order for us to defend this.
Well, let's walk through the counts. Doesn't go to false imprisonment, right?
It does not go to false imprisonment.
Doesn't go to battery.
Well, it can go to, anyway. It would only go to false imprisonment to the extent that it corroborates what our doctors were trying to tell Beata and Jack Kowalski with, look, we'd like to talk to you about staying here because the treatments that you want, there's no question in the record that they were coming into the ER saying, we want to put Maya in a ketamine coma. And our doctors, as they testified, the nurses were shocked by this. And this corroborates what our doctors and our nurses were saying, which was this treatment that you're asking for is insane. So let's sit down, let's talk, let's have a real conversation, let's have you agree to the treatment plan. So this email corroborates exactly why our doctors had to stop. So we can go to that.
Not sure I agree with the stretch there, but okay. Doesn't go to battery.
Does not go to battery.
I know the DV is under advisement relative to Maya for negligent infliction of emotional distress, but doesn't seem to go there, right? How about medical malpractice?
Yes, it definitely goes to medical malpractice.
Well, let me ask this, because medical malpractice focuses on the acts or omissions that occurred at Johns Hopkins All Children's Hospital.
And whether we were right, and whether we were, because their whole claim, their whole basis, which we think obviously we disagree, but their whole claim is you sought the standard of care treatment that Maya Kowalski needed, and as a result of this, now Maya Kowalski somehow, because you wouldn't give her the proper treatment, Maya Kowalski somehow is somehow worse off with relapses and remissions going into the future in a $20, $30, $50, $80 million care plan. Our point is, and as we've said over and over again, the treatment for CRPS is physical therapy, occupational therapy, cognitive behavioral therapy, and time. And you don't do ketamine drips and ketamine infusions at 23 milligrams per kilogram per hour. You don't go for ketamine comas. You don't go for intrathecal pain pumps, which is what they're saying that we prevented them from doing. And this email is the best evidence, and frankly, the only evidence that we have to show exactly why we are the standard of care. And this is risky and dangerous. It comes from Beata's own words.
What?
And we didn't aggravate. They're going to argue in the jury instructions that we aggravated her CRPS by not giving her this.
But it's true the Johns Hopkins All Children's Hospital did not have access to this email, and I'm presuming what's going to follow.
Not true. We had access to it because it was part of Sally Smith's file. The WordPress blogs are part of her file.
Well, so now we're adopting Sally Smith as our agent for purposes of treatment and standard of care at the hospital. If we're going there.
Okay.
Sorry.
Go ahead.
None of our experts have testified, none of our standard of care experts testified that the breach of the standard of care was failure to give a ketamine coma. What Beata Kowalski, you heard this from Dr. Bauer, what she came in asking for was 1,500 milligrams of ketamine, like Dr. Hanna was giving the United States. This reference to 23 milligrams per kilogram per hour is not a reference to this. It's a reference to Dr. Hanna's treatment 2 days before her admission.
Why don't I see, because I'm assuming what I do on day one is going to be what I do on the balance. So let me look at the next few, and then I'll probably take it under advisement and let you know on Monday. But 3145, please.
Same issue, Your Honor.
Okay, let me just read it real quick. Anything that we haven't already said with respect to day one, with this day two email.
Well, again, I also want to point out that Beata Kowalski is writing as if she's mine, and they have squarely put in front of this jury that we would never agree to these transfer codes because one of the diagnoses is on there, and Dr. Newberger was read into the record saying that diagnosis was medical malpractice. They're going to argue this. This goes directly to the suspicion of Munchausen by proxy as a mother writing as her daughter. So it also goes to that in addition to the prior statements that we used to.
Your Honor, it cannot go to a suspicion of Munchausen by proxy in 2016, October 7th through the 20th of 2016, when it was not in their possession. It wasn't known to them. What she wrote with respect to thank you, God, and appreciate it, Jesus, has nothing to do with the Munchausen by proxy inside that hospital in 2016 because they didn't have it.
We did have it.
Well, you didn't have it for the false imprisonment time period at issue.
But we had it during the time that we were trying to transfer the child.
Before October 17th?
They would need some evidence in the record of this.
When the transfer attempts were trying to go to Nemours in November, and the plaintiffs keep saying...
Look, time out. You said it goes to false imprisonment. You got the picture taking and you got the EEG. So the only time the false imprisonment is that first week. So that's the point I think Mr. Whitney was making, that it wasn't available for false imprisonment. It might go to your med mal, but that's probably the only place that arguably it might go to. So all I want to do at this point is let me see the rest of them. If there's anything unique about the next series, let me know, but let's not have a continued re-argument because I'm not going to rule today.
Yes, sir.
So let me see the day 3, which is 3146. Let's go to the next one, which is 3147. And is 3148 the last one in this series?
I believe so.
And it looks like that's 2 pages.
Yes.
Can you just put up both pages, or look, I make it too small? Let's see. Yeah, just go back to just the 1 page, please.
I would add one more basis when you're done with it.
What's the other basis?
It goes to show that that my clients were correct about the reasons why ketamine is not an effective drug. It's showing, this specific one is showing that Maya is not recovering from these ketamine doses. And we would just submit to Your Honor, just because we believe we can show that my clients, or some of them, have knowledge of this. But even if we didn't, this would be no different than our doctors. Take a simple case. Someone comes into the emergency room and says, I have a broken arm, and we read the x-ray report as negative, and they go home and then they sue us for failing to diagnose the broken arm. Couldn't we say there's an x-ray from 2 days before the admission that is also negative? It doesn't show a broken arm, and sure, we didn't know about that, but it corroborates. Their diagnosis is the same as our diagnosis. All of this goes to corroborate exactly why, in defense of a medical malpractice claim, my clients were correct. They were correct to be suspicious of ketamine. They were correct to be scared of having Maya undergo these treatments. And it completely contradicts the narrative that the plaintiffs have put in front of the jury.
I'm sorry, what was the end?
Sorry, it completely contradicts the narrative the plaintiffs have put in front of the jury. And it's especially important because, again, the plaintiffs are saying that we aggravated a condition by not providing this treatment.
Anything else, Mr. Whitney?
Their experts are free to come in and testify about standard of care. They don't need this to do so. This, again, was not in their possession, and I'm not sure how it helps them because the photographic and video evidence is that Maya Kowalski, and their records, that Maya Kowalski did progressively better and better following this ketamine coma. We would also challenge the idea that they had possession of this information at any time during the relevant 3.5-month admission, unless they're adopting Sally Smith as their agent.
I'm going to take 3144, 3145, 3146, 3147, and 3148 under advisement. What's next?
Do you want any additional information for us, Judge, or are you just gonna?
No, well, let me ask this, and this is bleeding over to a different concept, but since we somewhat referenced it earlier, and it goes to Fabry. Because ultimately, well, I mean, if the defense doesn't seek Fabry, then there's not an issue. But again, the medical malpractice goes to the acts or omissions at the hospital. So following up what Mr. Shapiro was just talking about, let's say you have a car crash and maybe there's somebody that's negligent in that. It might be helpful to know, hey, there was a crash and what generally happened. But when a person that was a victim of negligence in a car crash goes to the hospital for care and then the hospital malpractices, you don't really go back and apportion the first crash. And so it would seem like from an evidentiary standpoint, it might be helpful to know what happened, but then you don't try to figure out, well, driver 1 was 18% at fault while driver 2 was 83% at fault, because that wouldn't really matter for the malpractice.
I understand what the court's saying, that typically who caused the car crash doesn't come into whether or not the doctor's malpractice. Is that your point when you got into the ER? Yeah, but again, given this is a very unusual case, and given this scenario that the jury's presented, this type of evidence specifically goes to rebut their position that our failure to give her ketamine, which is their position, that we stopped the ketamine protocol, aggravated her CRPS to the tune of a permanent aggravation.
But let's be specific. Ketamine in the amount that was given in Mexico is different than a lesser dose. And this jury's already been told multiple times that the dosage of ketamine in the amount that occurred in Mexico is not available in the United States. So,
because this, let me give you an example. Mr. Tremp took the witness stand. This is also why this is relevant. Mr. Tremp took the witness stand, and it was memorable. I'm sure you remember because we got into it. She was a freight train heading to college. This ketamine was all working, and because you didn't give her the ketamine, she's now a wreck and can never do X, Y, and Z. These records go exactly to my cross-examination of Mr. Tremp, and the jury needs to see them because the only picture they've gotten from the plaintiff is, and especially with their expert relying on it, from everything I've seen, Maya Kowalski was happy, healthy, and thriving with ketamine. These words from Beata, a first-hand witness, exactly what's happening to Maya during ketamine comas is essential for the defense to be able to rebut the information that Mr. Tremp is showing that this freight train heading to college was actually near death on a table in Mexico because of the treatments that they put her through then, and they continue to advocate in even higher doses at Dr. Hanna's office. And that's exactly the point. I mean, he was giving 3 to 7 milligrams per kilogram per hour in an intubated session. Dr. Hanna was giving 23 milligrams per kilogram per hour, and we need these records to be able to say that this is what ketamine does to somebody, not this rosy picture of what the plaintiffs are showing. You get a couple doses of ketamine and then you're swimming in the pool. And they're asking for over $5 million in ketamine as a reasonable, as a necessary treatment, and we need these to be able to tell the jury, no, this is what ketamine does to a child. So it goes to damages, it goes to medical malpractice, it goes to aggravation, it goes to state of mind, it goes to a number of relevant issues.
and I said I will take it under advisement. I in a moment, but I continue to struggle. I feel like we're almost on a collateral issue.
I understand where Your Honor says, to us it's the heart of the case. That's all I can tell you.
Just on this point about this being relevant to Mr. Tremp's testimony. Specifically, the $5 million in ketamine that Mr. Shapiro just referenced is not for recurrent ketamine comas. It was for the infusion treatments at Dr. Kirkpatrick's office. The same type of treatments that she was receiving in the United States immediately before the hospitalization. So what's relevant is the demand or request of Beata and Jack to have a similar dose that Dr. Hanna was giving. Nothing about a ketamine coma and what transpired there. And again, there's no file break claim against Dr. Cantor.
Let's move on. What's next?
3149. There's actually 12 of them. It's her advising Dr. Kirkpatrick of.
Isn't this similar to the one that we just ruled on?
Yes.
Yes.
I think we're...
The terminally ill stuff, you've...
No, I don't think this.
It is.
Oh, it is. Okay. I thought it was, oh yeah, so number 25.
We're going to revisit that.
That's
that one's offer.
Yeah. 3150. Oh, we must have skipped one, Judge. This is coma day 6. Somehow it got.
let me just see it.
Yeah.
Let's not have any argument on it. And
Right.
it'll be taken under advisement.
Yeah, I just think we, yes, this belongs to that same grouping, Judge.
3151, Clay.
I think that's day 6, so that's. Is this still 3150?
Yeah, there's a few of these that are in order. 3151, 3152, 3153. There's several more, Your Honor, not to interrupt you, but if we're going to group them all together, we can show you the next ones in the series. There's...
Yeah, let me, I finished 3150. Show me the next one.
3151.
What's next?
3152.
Okay, what's next?
3153.
What's WC?
Wheelchair.
I mean, this one doesn't seem to discuss anything about medical, so
Would agree.
3153 will be out.
3154.
This looks like the same email.
Oh, I apologize. Is it? 3155.
So 3154 is out as well.
Sorry, I think 3153 was the one that I misstated. Clay, will you go back to 3153? Oh, sorry, 3153 and 3154 are the same.
Yeah.
Okay, so 3153 and 3154.
Okay, so the transcript clear 3153 and 3154 are not admitted.
3155 relate to the ketamine boosters.
Do you want hard copies of these?
Yes, please.
Yes?
Yeah, if I can take them home tonight.
Okay.
Okay, just query, how is it possible if Beata Kowalski's in the United States and this is happening in Mexico, how is this possible?
I'm sorry to follow you.
Well, assuming that this is Beata, and I think that's what we were working on, I flew to Monterey Saturday the 19th, and on Sunday the 20th I got admitted. And it's talking about specifics.
I think that goes to our concern over the reliability of all of these emails, Your Honor.
Wow, I think you emailed from Mexico.
Well, it says mommy couldn't switch her clients and couldn't get the time off from work. So daddy had to fill in mommy's shoes.
But it's still, there's still statements by the decedent, which are chargeable against the party. It's still mom's recollection and statement of what went on with these cones and these boosters, which again.
Well, how can mom make a statement if she's not there? I mean, just practically, how's that possible?
The other reason we would admit him again is I think it goes to the state of mind and the potential Munchausen's diagnosis that they criticize with mom logging as if she's not
out. What's the next one?
Which one was this, Clay? 3156.
Well, again, I mean, this refers to mommy being in the United States while all this stuff's happening in Mexico.
Yep. I'll just be heard of this one last time. Again,
If it's duplicative of what you've already said, then no. If it's something new, then okay. Is it anything new?
I think I've already made the point about the Munchausen diagnosis.
Yeah.
Okay.
Okay.
No, and for the sake of expediency, Your Honor, there's about 30 of these. You want them all printed out and given to you rather than going through them one by one.
Yeah, that's probably better.
I just don't want to keep you here any later than you want to be.
And many of those that are to come judge are not in Mexico. They are stateside, and they're monthly updates that provide a foundation, a baseline leading up to the 2016 initiative.
And so you'll be able to print those out in a few minutes here?
Yeah.
Okay, so let's go on to the next one that is not in this series.
Yeah,
that
I'm trying to figure that out, Judge.
Just Clay, will you print them all the way through 3181? Then we can give the list.
I'm just looking at your list here. It looks like 3172 might be different type of thing.
We'll pull it.
I'm just saying we might want to address it now.
Okay, sure.
Hey, printing, can you also pull up 3172? Then if you give them.
Or Mr. Reyes could also probably pull up exhibits.
We have it up, Judge.
All right.
We'll withdraw that, Judge.
We want it. We'll take it. Admit.
Withdrawn.
So 3172 has been withdrawn by the
That's correct, Your Honor.
defendant. What's next?
I think 3175 is also perhaps not part of the series.
Like, you've got 3174.
Oh, I'm sorry. It says on your sheet here between Biad and Dr. Cantu.
Yeah, let's say that.
Biad to herself.
Well, maybe try 3176 because that also has.
Okay. This looks like an email of Dr. Cantu. Oh, yeah. Is that in? I think this has already been shown.
Yeah, discussion about it with the judge.
Madam Clerk, is 3176 in evidence? Clerk says it's not.
Well, there might be a corresponding 10,000.
Let's get it in.
Yeah, I recall this being discussed. Maybe I just looked at it, but Dr. Cantu was testifying.
Your Honor astutely noted that everywhere else in the world orders their days and months differently in the United States.
Yeah, I agree with Ms. Croyles. I think we've had a conversation.
I think it says 2415, Your Honor.
2415?
It is.
Okay, can you just pull up 2415 on one side and 3176 on the other side?
Yeah, it looks the same.
Okay, so 2415, let's just make sure that's in. Clerk is saying yes, so we don't need 3176?
Yeah.
There we go. So we don't need to do anything with 3176 because it's already in at 2415.
Take Victor. Just trying to look at the descriptions here, Judge, to see. Is he pretty easy?
Yes.
I think that, like, the 3185, I think we've looked at these already, and I'm not sure. I have to go back and look, Judge, if we've already visited these in the court as ruled or not. I don't want to repeat myself. Okay, what about 3191? Let me see that one at least. No, we
We'll
don't
take
do
it.
this. No, we'll withdraw this.
Take that bond paragraph in isolation.
So what one was just withdrawn?
Yeah, but
What-
Judge, I think we need to look at, I'm sorry.
What number was just withdrawn?
3191, Your Honor.
What's next?
3240.
The Daisy Award?
Yes, Your Honor.
That's already been talked about. Okay, put up 3240.
Mm-hmm.
Any objection?
No, Your Honor.
3240 is in. Is received, I should say. What's next?
Judge, I think that's all we can address without,
We're going to go back through these, and if there's any more, we'll let you know, but I think that's going to be almost everything in the trouble.
well, we're gonna have capital BB emails, but I have to go through them.
Well, let me just, my understanding was this was supposed to be a relatively comprehensive list.
I'm sorry.
So next week, we're not going to expect lots of new exhibits that are not on this.
Well, I think, Judge, like the Kathy BB email are 800 pages. And I need to go through that, not the one that's listed here, that's a different one. Which we could look at that one. But then there's literally 800 of them. I need to go through this weekend and distill which of those I'm going, based on the court's rulings to date, which ones I'm going to try to get in. So there will be some, she's not testifying Monday or Tuesday. So, we can deal with that. With the court's indulgence on that. I think that's pretty much it.
Yeah, because the rest were WordPress blogs, but I think that WordPress blogs are verified by the underlying emails that you're taking under advisement. Your Honor's concerned about the WordPress blogs were authenticity, so if you're going to let in the underlying emails, that's going to answer a question, or vice versa. So.
And just so you're aware too, Your Honor, the WordPress blog is effectively stopped in December of 2015, so a lot of the emails, the tranche you're getting into 2016 would not be in the blog itself.
I just want to, because we've got time, if there's other exhibits, I don't want to miss an opportunity and make us stay late another day.
Well, let me look. Well, I'm going to see if there's any others that we need to address. Can you just give us a minute, Fred?
Yes, ma'am.
Thank you. Okay.
Thank you.
You go back to flying fighter jets. How about that?
We have some photos we could look up, Judge.
Okay, thank you. What number?
3225.
Are these on the list? Detective?
Yeah. No, they're not. I'm sorry. We're back. I think that one's in.
No objection.
I don't remember seeing this one.
No
Now,
objection.
all of the metadata that's under there, is that,
Oh, we can get that from there, Judge. But we need the date, though.
I mean, I'm not opposed to it, I just,
We might have to object to the username of Raspberry Shopkins. I don't know if she still uses that.
can we,
And she has quite an Instagram followership these days, but I'm not sure it's Raspberry Shopkins.
and let's, I try not to put email addresses and telephone numbers.
Go ahead and take it down.
I'm sorry, I didn't mean to interrupt.
Yeah.
Oh, I'm sorry. I didn't
You know what? Before we start flashing stuff on the screen, we'll go through them. We have other things we can discuss rather than.
Yeah.
Thank you.
I didn't realize we were doing that. Sorry. This is. Yeah, 3168, Judge.
3168.
This is in March of 2016. Beata writing to the church requesting this information. We put in a flyer for a fundraiser. Seeking money for more ketamine booster infusions.
Well, we object, Your Honor. I think the redactions there are prejudicial, and the idea that she's doing this for financial gain is what the defense wants to get at. So there's no way to do this. Well, part of the Munchausen diagnosis or theory is that a parent's doing this for ulterior motive. So they want to argue that Beata Kowalski is putting her daughter through all of this because she can make a few $1,000s. The redactions under that last paragraph says begins currently. You can see two redactions, which would be insurance companies. And so, yeah, it's expensive, but the reason she's seeking money is because insurance doesn't cover the treatments. So I don't know how you can extract that and then make an accusation against the mother that she's doing this all for financial gain.
I just had a clarification. Are the plaintiffs alleging in this case that we misdiagnosed Munchausen or no?
Well, let me ask you this. Is the hospital contending that mom had Munchausen?
Well, the diagnosis code that we have to defend says one of the reasons for transfer, it's in the diagnosis. So it's one of the diagnoses. Are the plaintiffs alleging that that's a misdiagnosis?
Because I've been unclear as to whether the defense agrees that whether she does or does not have CRPS.
The defense of this case from a medical malpractice standpoint is that whether this was psychological, RSD, conversion disorder, Munchausen's by proxy, the treatment would be the same: physical therapy, cognitive therapy, occupational therapy. What I'm asking the plaintiff is the plaintiff alleging that the Munchausen diagnosis was wrong, that we committed medical malpractice by having that appear in our record, that we committed medical malpractice by having that on the transfer code, that it goes to that because of that allegation that pushed Beata to some type of intentional infliction of emotional distress. If they are, then we absolutely need not just these that are going to hand to court, but these things of fundraising, because it does go to the diagnosis. So the answer to Your Honor's question is, we don't plan on making this case about whether she had which disorder they had, but we definitely, if the plaintiff is going to allege, which I think they have clearly, that the diagnosis of Munchausen inflicted distress, stopped transfers to the Moores, was a medical malpractice diagnosis, then this would go to our defense to say that that diagnosis was one of the working diagnoses on the district.
Yeah, I'm unclear.
Okay.
Because I go back to opening statement, and Mr. Hunter made a statement to the jury to the effect of, we did not have to be right, we only had to be reasonable.
Correct.
Which I thought was an interesting statement at the time. But I'm unclear now by what you're saying, whether the hospital agrees that Maya Kowalski has CRPS. Because, I just heard a whole bunch of depositions today that seems to suggest that the hospital is saying she doesn't have CRPS.
The hospital's position on this, and from the defense's point, is very clear. The diagnosis of CRPS is questionable. Whether she has it or not is subject to debate because there's no test to rule it in. There's no test to rule it out. It's a syndrome. It's not like you can take a blood test and say that you have CRPS the way you can say you have leukemia. But from the All Children's point of view, whether she had CRPS, whether she had psychosomatic pain, conversion disorder, or whatever the new language was that you heard from the doctor, the medical treatment for this is the same. Cognitive behavioral therapy, physical therapy, occupational therapy, all of which we provided, and all of which, to the extent we could not provide, we were trying to transfer to other institutions that had a higher level of care for this. Yeah, I think that you can see in the discharge, if it's on the admission diagnosis, we provided treatment for her if she would have had it. It's also on the discharge. CRPS is on the discharge diagnosis as a can't rule out. So the hospital's position on this, I don't think should not be unclear to this court or to this jury. We are not taking the position that Maya never had CRPS. It was a diagnosis that we considered, we respected, we provided treatment for, just the same as if she had a psychosomatic disorder. And on the discharge diagnosis, it says it couldn't be ruled out. So if that answers the court's specific question about what our position is on CRPS. There's just not a blood test for this that we can say, yes, she had it, or no, she had it.
I heard what you're saying. I'm not sure I think it's a clear answer, but I hear and I appreciate the line you seem to be trying to walk, but I'm not sure I totally understand it being a clear answer.
I'll try to give it to you in 10 seconds. To the pain management team, it didn't matter. The treatment for, and Dr. Elliott has testified to this, our pain management team testified to it. I think the ICU doctors, I thought, testified to it, but our pain management people will testify to this. The treatment for RSD/CRPS is exactly the same treatment as cognitive behavior, as conversion disorder or any psychosomatic, or I think it was called central sensitization disease. It's cognitive, physical, occupational therapy. And to the All Children's team, it didn't matter whether she had CRPS or not.
Well, then my question back is, does it matter whether mom had Munchausen? Because one, Johns Hopkins All Children's Hospital is taking the position that it's a children's hospital, it's not an adult hospital. It did not seek to provide any care and treatment. There's certainly evidence that's been adduced that this is a diagnosis that would impact Viata. Frankly, I'm struggling to see how it goes to what type of care for CRPS that the hospital did or did not provide to Maya, and the focus is on Maya for medical malpractice. So that, I'm struggling with why we're spending so much time on it when it doesn't seem to be an actual issue in the case.
Only because the plaintiff has injected this into the case, saying that your diagnosis of Munchausen by proxy or as a reason for the transfer is the reason we couldn't accept the transfer, and it was a negligent diagnosis. Your diagnosis of Munchausen by proxy caused intentional...
Correct me if I'm wrong, but I don't think the basis of medical malpractice is the diagnosis that precluded a transfer. Am I misunderstanding the case?
that specific question, whether the listing of Munchausen by proxy on a transfer diagnosis is not the basis for a malpractice claim, that was first an issue raised in this case by the defense when they attempted to claim that effectively Jack and Beata had been unreasonable for not accepting that psychiatric diagnosis in that transfer, and it was on them for not accepting the transfer to Nemours. Then we get testimony that Nemours doesn't in fact have a CRPS inpatient program, and Ms. Beatty lied on the phone to Beata Kowalski, and it was a psychiatric diagnosis they were trying to transfer her for.
Let me stop you because I need to understand it. Is the plaintiff saying that there was negligence on the part of the hospital having to do with having that diagnosis, the conversion/Munchausen, as a medical negligence on failure to transfer?
I just want to rephrase the question to make sure I'm understanding. Is our position that it was a breach of the standard of care to use Munchausen in the transfer diagnosis? Am I understanding that correctly?
Are you claiming any sort of damages? Let's do it this way.
Sure.
Any sort of damages associated with a non-transfer that occurred on whatever date that was or that time period?
When was the Nemours transfer?
There was two attempts, right?
It was in November, and I would only, if I may, Your Honor, I would even broaden that to ask the plaintiff, are they seeking any damages from this defense for the diagnosis of Munchausen by proxy? If they're not, that may simplify what Your Honor's concern is.
Well, I'm going to try to answer the court's question first. I don't believe we're allowed to seek damages from the transfer attempt in the context of a Chapter 39 proceeding. I think that was a defense theory raised to muddy up the false imprisonment claim, and now I'm hearing that this transfer diagnosis or transfer attempt wasn't even made until the middle of the dependency proceeding when Chapter 39 shelter order was in place. So, I'm sorry.
No, go ahead.
With respect to Munchausen by proxy, I think the court a second ago spotted the issue, which is that the diagnosis of the mom. So they take a position that's duplicitous. That is in their records, Munchausen by proxy. There's no question. But then they retreat and say, well, we're a pediatric hospital. We can't treat or diagnose adults. But yet their records of Maya Kowalski are littered with an adult diagnosis. We have been asking the question for years, and this is what you're hearing. We can't even get a frank admission as to whether or not CRPS was or was not a diagnosis of the hospital they were treating. We've tried innumerable times. They won't commit to what their diagnosis was. And then to take the position that the treatments for all of these conditions are identical, well, that's preposterous. But secondly, if that's true, our breach of standard of care, Dr. Duncan testified to this. If you're taking the position that all of these conditions, no matter what they are, require cognitive behavioral therapy, and you provide 3 hours of cognitive behavioral therapy over the course of a 3.5-month admission, we can go with that for the moment, and it's a breach of the standard of care no matter what diagnosis they ultimately land on, but they won't land on one.
Well, with respect to the first attempt transfer, the one in October that occurred during the period of time for the claim of false imprisonment, it seems to me whether mom had Munchausen or not is not the issue. Because the evidence, the issue is mom didn't want to sign the form because of that diagnosis. So even if the plaintiffs, or even if the defense said, well, mom had Munchausen, that doesn't change the fact that mom wasn't going to sign the form. And so that doesn't go to the question of false imprisonment.
Right, the form was.
So how does it go to Maya's medical malpractice claim or any claim that's actually remaining in this case?
Okay, to correct, that transfer attempt was in November, but I would just reiterate this.
The first one was October.
The first one was October, but the form was for a November transfer.
Okay.
But all that being said, I think I see exactly what the court's question is, so I would ask it again. Are the plaintiffs seeking damages from my client for any of the counts for what they're alleging is a miss or a false diagnosis of Munchausen by proxy? If they're not, if we have a stipulation from the plaintiff, we're not seeking damages from you for the diagnosis of Munchausen by proxy, then I don't have to put on a case about why that diagnosis was correct. So I turn to the plaintiff and ask him that again.
What I want is I want the defense team to huddle inclusive of Mr. Hunter and the plaintiff's team to huddle inclusive of Mr. Anderson. I want you all to talk about this issue. It's both what Mr. Shapiro was just saying, but I also think it goes to the question of whether the hospital is going to contend or not that Maya has CRPS. Because, I mean, I hear what you're trying to say, but sitting here, it doesn't seem to come across pretty clear as far as the evidence that you're presenting. If we get to the point where there's an agreement as to the plaintiffs are not seeking damages, and I'm not saying that they have a valid claim, but for this exercise, if they're not going to seek it, and you agree that they're not, since they're not seeking it, you don't have to deal with it, it seems like a lot of this issue goes away.
I totally agree. Totally agree.
So,
okay, we'll huddle.
You need to huddle, and I really want to know on Monday the outcome of it. I also want to know if the hospital has a more clear statement as to whether Maya Kowalski has CRPS.
Okay, I thought I announced it, but I'll try to synthesize it.
It might be that you're just going to go with what you went with, and that is what it is.
Okay, thank you, Your Honor.
But let's go back and sharpen our pencils and look at the actual claims that are in this case. And knowing that I've knocked out a whole bunch of claims, both before trial and during this trial.
Yeah, it goes to the same issue. The remaining documents we have are similar to fundraising and things that may not be relevant if the plaintiff is not seeking damages for alleged Munchausen. We probably don't need a lot of these.
So this is probably, even though we're not exactly at 6 o'clock, probably a good time to just say, yes. I actually think this discussion in the last 10 minutes has been helpful. Now, my hope is that the lawyers that are here can go talk to the lawyers that are not here and see if we can come to some sort of agreement.
Yes, we appreciate the court's guidance, Your Honor.
What time on Monday?
Oh, Your Honor, may I approach? I have the compendium.
Great, thank you.
Thank you.
What time on Monday do we need to be here, knowing that the jury's going to be ready to go at 9?
Yeah, all of our witnesses on Monday, Your Honor, and I think we've announced them to the
I don't know if we have.
Have we told you, Mr. Goodman? Well, I apologize. On Monday, we're going to have Dr. Mendez, Dr. Katzenstein, Dr. Elliott. I think there's a question about Dr. Kriesman appearing. Dr. Kriesman, without getting into why I would need to attend by Zoom, he would come late in the day if we still have time after calling Dr. Mendez, Dr. Katzenstein. Dr. Elliott, to your question, Your Honor, Dr. Mendez's records are small. They've already been admitted evidence. Katzenstein and Elliott are both called children's providers. We're only relying on their records that are already in evidence. So it's a short way of saying I think 8:30 should be fine for me.
And those two that you just said, whatever their names are going to be here live?
Yes.
All three of them.
All three will be live. And the fourth one, Dr. Kriesman, he's an all children's provider. He would be by Zoom, but again, the same records, it's just all children's records.
Mr. Whitney, did you get the list on?
Yes.
So I go back to the question of what time do we need to be here on Monday.
I think 8:30 is fine because we're not looking to introduce any exhibits not on, that haven't already been admitted for those witnesses. 8:30.
So we have filed our depositions of the experts that were deposed on the defense side for the court's consideration of our motion. We also still have a motion for a curative instruction that's pending, so maybe we can take that up Monday morning.
The motion on your experts, are those any of the people that are coming on Monday?
No, Your Honor, but if they're filing one against, what our experts can be doing that week, and so.
Well, my immediate question was what time on Monday, so it sounds like 8:30 is the time we need to be here, 8:30 on Monday. And I do want to have a report back what that conversation we were just having last 10 to 15 minutes. And remind me to address this question for instruction, and then we'll go from there.
There was, say, a housekeeping technology matter that I think Clay wanted to address about Zoom. I'll turn the table over to him.
We talked to Mike about it. It's just with the screen sharing issue. Mike could figure it out.
I stand corrected.
So there's nothing I need to do?
I don't believe so. On Monday morning, that might change, but it's required for real.
Everyone have a good weekend. We'll be at recess until Monday morning at 8:30.
Have a good weekend, Your Honor.